To the meeting of the Environmental Management Commission. At the beginning of every meeting, General Statute 138A-15 requires me to remind the board members of their duty to avoid conflicts of interest and to ask whether any commissioner has a known conflict of interest with respect to any matters coming before the board at this time. Seeing none, the next order of business is approval of the minutes of the January 13th meeting. Are there any comments on or corrections to the minutes? And if not, I'll entertain a motion for approval.
This is Commissioner Modest. I move to approve the minutes.
Is there a second to the motion?
Commissioner Bailey, I second the motion.
Thank you. All in favor of approving the minutes, please raise your hand. Thank you. That appears to be unanimous. The first action item on the agenda is the Eagle Transport petition for declaratory ruling. And I'm first going to turn to Commission Counsel, Mr. Reynolds, to just provide the procedural background for consideration of a declaratory ruling again. So, Mr. Reynolds.
Thank you, Madam Chair. As you are all aware, and made mention of this when we were together last in person, what you have to get before you today is a petition for declaratory ruling from Eagle Transport. We delayed the matter in January since we were doing it remotely in an effort to have the presenters be here in person for you. And the petitioners, as well as I and the chair, felt like that would be the better things to have them here so you could see and interact with them. And it makes for a lot easier discussion and question and answer period than raising your hands virtually. So, but the reason this matter is before you is that it is back before you on remand. The commission previously heard this matter, I want to say in 2020. It's been a while now. And as you're familiar with from our petition for declaratory ruling in November with Optima TH, you have generally two questions in front of you for petitions for declaratory ruling. The first being a decision as to whether to grant the petition, which is simply saying that you're going to reach the merits, and then you have a vote on the merits themselves. Well, we are going to save ourselves some time this time because previously you voted to deny the petition, which is not a ruling on the merits, for lack of a genuine controversy, saying essentially that there was no genuine issue between the parties and that it had been correctly applied. But that was, again, that was not that it had been correctly applied, but that there was no reason to reach the decision on the merits because you didn't find it there to be an issue. It was appealed to Superior Court. The Superior Court has remanded it to us now to reach a decision on the merits. So you will not have to do two different votes. You only have to do the one vote as to how to decide the matter on the merits. The ruling by the Superior Court was that there wasn't sufficient support in the record for the Commission's decision, but it did not point to any particular parts of the decision that says this is wrong or that your logic is wrong, just that it wasn't supported by the record. And so, or the denial of the petition wasn't supported by the record. So now the Superior Court has asked us to rule on the merits. As you've all heard me say before, this is a quasi-judicial matter. And what quasi-judicial means is that you have to make a decision on the record before you. No information outside of the record. So in addition to having to determine whether you have a conflict of interest, which you've been asked and none of you have indicated that you have a conflict of interest with respect to this matter, you also have to ensure that you don't have an impermissible legal bias. An impermissible legal bias is a predisposition to decide a cause or issue in a certain way, which does not leave the mind open to persuasion. You are not disqualified merely because you have taken a particular position on a policy issue arising in this case, or because you have heard this matter previously. Just that when you make your decision today, that you're making it based on the record after full and fair deliberations. So today you have Mr. Keith Johnson and Mr. Glenn Dunn representing Eagle Transport and Mr. Hill Davis from the Attorney General's office representing the department to make their case. And I'll be glad to answer any questions about the procedure at this point if anyone has it. Madam Chair, just the last part of the procedure is that both sides are allowed 15 minutes for a presentation, and then typically questions and answers after that.
And we will call on the petitioner first, Mr. Johnson.
Good morning, everyone. Thank you, Philip. Chair, I'd like to also introduce Bree Bryant with Eagle Transport is here with us. And as Philip mentioned, Glenn Dunn, my partner, is with me. Glenn's going to have a few remarks at the very end. And you have a written submission from us. And then I also have handed out to you just a few pages out of the relevant Oil Control Act today that I'll refer to in a few minutes. Okay, first, before we get to the merits, let me remind you all that you're here exercising a very important judicial function that you've been tasked by the General Assembly to fulfill, which is very different from some of the other tasks that you fulfill that are more rulemaking, more policy oriented. That's not what this is. You have to decide whether defenses that are in the relevant Oil Control Act are available to Eagle. The defenses are there in the Act. The question is whether they are available to our client under the circumstances that we're going to describe in a minute. So your decision must be based on the relevant current statutory law, right? It's up to the General Assembly to determine what's unlawful conduct, what defenses apply, and to whom. That's the General Assembly's job. And that's determined from the relevant statutes, which I'm going to go over with you. I'm going to just refer to it as the Oil Control Act. There's a longer name. And I'm also just going to refer to oil. The Act applies to oil and hazardous substances, but again, that's a mouthful. This is an oil spill, so let's keep it to oil. I noticed that in its submission, DEQ has revived an argument that the rules passed by this commission give it authority to hold Eagle responsible for the cleanup. Those rules implement the Act, as you know. The answer to the question here lies in the statutes, not in the rules. So the question here is not what the commission would prefer the current law to be, right? And I mention that because when I saw DEQ's submission to you, I see a lot of policy arguments. I would respectfully submit those should be left and presented to the legislature. What we're discussing today is what the current law provides. And for reasons that we will explain, the defenses in the Act are available to Eagle or anyone else who was held responsible for cleanup for an oil spill. If anyone believes that the law should read differently, they can go to the General Assembly and petition for a change in the law. Okay, let me remind you of just the undisputed facts here. I know some of you are new, some of you, it's been a while. Eagle's tanker truck, while transporting fuel, was unable to avoid a collision when a car failed to yield while turning onto a highway. And there's a drive cam in the record. I don't know if any of you have watched it, but it tells the story. It's hard to watch, but it tells the story. There's nothing that Mr. Daryl Jonas, Eagle's driver, could have done to avoid the collision. He just has time to say, "Oh crap." That's not the word he used, but those were the last words that he uttered. The truck, as a result of the collision, overturns and catches fire. Mr. Jonas did not survive. The other driver, Ms. Karen Haley, did survive, and she acknowledged responsibility, pled guilty for misdemeanor by death by vehicle. So there's no dispute over who caused this accident. Sometime after Mr. Jonas lost control of that truck and it turned over, there's an oil spill. There's also a fire. Not all of the fuel burned up, and there is an oil spill onto the highway and the right-of-way. Fortunately, that's not a common occurrence, but there's no factual issue here, right? What you are facing is purely a legal issue. Now, DEQ takes the position that Eagle is responsible for all assessment and cleanup of that fuel spill. and the chemicals used by the firefighters to fight the fire, even though there's nothing Mr. Jonas could have done to avoid that accident. In legal terms, DEQ insists that under the applicable law, Eagle is absolutely liable, meaning Eagle is responsible for those costs, which are very significant, no matter what caused the spill. Okay, so the issue presented to you is pretty simple. Did the General Assembly declare in the Act that any person engaged in using, storing, transporting fuel that is discharged to the environment is absolutely liable for all the costs to respond by assessing the impacts and conducting the remediation without any possible defense, and no matter what the cause of the discharge was? Now, the answer to that question is no. For reasons that we'll explain, that harsh position is contrary to the language of statute. This really gets to the crux of the matter. What absolute liability, which is DEQ's position, versus our position, which is strict liability, what is the difference? And this really gets to the crux of it, and there was some confusion over this when we were before you before. Absolute liability means exactly what it says. Absolute, applying to a class of persons with no defenses available. Okay, what's an example of where absolute liability applies? The only one that I know of under our law is under our common law of blasting rock. If there's injury from the act of blasting rock, there's absolute liability for that act or for what occurs. Okay, what's the difference between that and strict liability? Strict liability means there's potential liability merely by engaging in some act or owning the property. In this case, the act is using, storing, or transporting oil or hazardous substance. You can be liable under a strict liability scheme even if you haven't been negligent in any way. That's what makes it strict liability. Nobody has to prove that you did something wrong, breach some duty of care. But under strict liability scheme, and I should have said limited defenses, there are limited defenses available for events that are beyond the control of the person that caused, is responsible or potentially responsible for the discharge. Well, what kind of events, defenses are we talking about? Basically two things: acts of God or the acts of some third party. Now, getting to the statutes themselves, this is the statute that is the basis for DEQ's position. It addresses the removal of prohibited discharges. Any person having control over oil discharge in violation of the act shall collect and remove the discharge and restore the affected area. Okay, now there's several places I noticed in DEQ's submission to you that they changed the word control and used the word possession. Remember, the word is control. I can be in possession of something. That doesn't necessarily mean I'm in control of it at all times. Control. The other thing that I want you to note here is that there's no unique law for oil carriers. This applies to any person using, storing, transporting oil. There's no unique law here for oil carriers. I mentioned that to you because I noticed at least 7 times in DEQ's submission, they refer to oil carriers. Well, oil carriers should do this. Oil carriers should do that. Whatever decision you make today cannot be limited to companies that are in Eagle's business. And I remember there were some comments when we were here before you before, well, that's just the cost of doing business. Well, okay, this is broader than what applies to oil carriers. You get it. Okay, let's get to the statutory language. And this is the handout that I gave you. The first page I gave you is an index of the Oil Control Act, Article 21A. And you see I've highlighted there the 2 key parts: oil discharge controls and removal of prohibited discharges. The main thing I want to, and I'm going to drill down on 83 in just a minute, because that's really where the key language is. But before I do that, I want to make the point that this is the only place in the Oil Control Act where the subject is addressed. So when we're talking here about what this key statute about discharges means, it applies throughout the entire article. Okay. Let me go back. So 83, basically, there are two key parts, a declaration from the General Assembly of what's an unlawful discharge, and then exceptions. Okay. 83A, this is the other part of the handout that I gave you. 83A, broad declaration about what are unlawful discharges of oil or hazardous substance into the environment, except as otherwise provided. So let's go to the exceptions, and that's subpart B, accepted discharges. This section shall not apply to discharges of oil or other hazardous substances in the following circumstances. What are those? One, when the discharge is authorized, right? That makes sense. Two, now we're really getting to the crux of it. When any person subject to liability under this article, meaning the entire act, proves the discharge was caused by, and then you have the defenses. And you can see what I mean when I say these can be divided into basically two categories. What the lawyers call force majeure events, acts of God, or acts or omissions of some other person. I've highlighted the act or omission here only because that is the one that Eagle invokes here, since our driver did not cause the accident which resulted in the spill. But you see my point. Whatever decision you make here today cannot be limited to that one defense. The question is whether any person who's cited as having control of oil and therefore responsible for cleanup can invoke any of these defenses. Okay. So what is the common thread to those defenses? Let me go back to them for a minute. The common thread to these defenses is that there's some event that has deprived that person of control over the oil. And what occurred in this accident is a classic example of that. Eagle's driver lost control of the oil in the truck and its load because of the acts of another driver. And again, if you see that this is just one of several third-party defenses. Now, I mentioned this in our submission. Under DEQ's interpretation, it's pretty harsh. There are a number of events you can think of where a person in control of oil loses that control. A hurricane-induced flood, and you have a tank that ruptures on a farm. Vandalism of a fuel tank at a gasoline station. So a driver pulls out in front of a tanker truck. I mean, you can think of a number of events where this is the case. So under DEQ's position, under any of those circumstances, sorry, there is no defense available. You were allegedly in control of the oil. You have to spend the money to clean it up. Now, I mentioned this and just sort of to give you the context. So the Oil Control Act that's an issue here is modeled on a federal one, right? And we mentioned this in our submission, that it follows the federal in providing these defenses. If you go to the Federal Act, you'll see this exact slate of defenses available for anyone who is held responsible to respond to an oil spill. It's no different than the federal model that we follow. And I know we have some Superfund lawyers on the bench here in the commission, and the same under our federal Superfund laws. That's strict liability. Merely by owning property, you may have potential liability, but these very same defenses are available to you. Now, you have to prove them, but the defenses are available is the point. Now, DEQ's position is any person who's cited, like we have, has absolute liability, right? So these defenses are not available to them. In order to do that, though, what does DEQ do with these defenses? I mean, the defenses are in the act, right? So DEQ has to posit that the act isn't back to absolute liability versus strict liability, that's kind of a hybrid. That it's strict liability if you're cited for causing the discharge, say Miss Haley in this case, the other driver. But for cleanup responsibility due to control over the oil, it's absolute liability. Now, to do that, DEQ has to do two things. One, I've given you both of the key statutes there. DEQ has to sort of ignore the relationship between those two statutes. Let me go back to 84, which is the basis for citing us. Removal of prohibited discharge. Discharge in violation of the article. Okay, where do we go to determine whether something's a violation of the article? We go to 83, which is what I focused on, where the defenses are. DEQ tries to create this silo between those two provisions in the law, which simply does not exist. Secondly,
Mr. Johnson, if I may, you have about 1 minute
okay.
of your 15 minutes.
Well, I'm gonna give it to Mr. Dunn, and I thank you for that. But basically, the other thing that DEQ has to do is a rewrite of that statute so that the defenses, instead of being available to any person with liability under the article, they have to reduce that to just liability under that specific statute. So they have to rewrite the statute in order to get to their conclusion. Thank you, and I'll give it to Mr. Dunn.
Try to sum up quickly. As Keith has explained, I think very clearly, the General Assembly imposed strict liability with certain defenses so that negligence wouldn't have to be shown and so that more spills would be cleaned up. But with defenses, as I said, and three keys to those defenses, they apply throughout the act, to the entire act, including 84, which says who must clean up. There are circumstances where the party in possession loses control of the oil, as in this case. And if you have a defense, then it says in the statute, it is not unlawful. The discharge is not unlawful. So you go to 84, and in order to be required to clean up, it's got to be a violation of the act, or if it's not unlawful, it's not a violation of the act. And because of the defense, Eagle was not in control. So 84 does not apply to make Eagle clean up. We think that is clear. It's just you have to follow the language. But I mean, I know time is up, so I want to close by saying we're not here to try to set a precedent. This is a very unique, unusual set of circumstances. And I think the appropriate role, a good role for the EMC and for the department in this situation is, since there is a fund set up in one section of the statute and authority for DEQ to step in and clean up, the appropriate role for the commission is to try to get the General Assembly to fund the fund. Clearly, the General Assembly, by setting up that fund, anticipated there'd be circumstances where there is no one either liable or who can pay for a cleanup. So we think that that is a good role, a positive role for the commission to take, but in these limited circumstances, we submit that the statute clearly indicates that Eagle does not have to clean up because of its defenses. Thank you.
Thank you. I will have a couple of questions, but before I get to my questions, or do other commissioners have questions of Mr. Johnson or Mr. Dunn? Yes, Commissioner Bailey.
My question is, do you think there's an unlawful discharge at all? I mean, with respect to the driver of the car, is there any unlawful discharge in this exact situation?
Well, I'm not sure there is a good answer to that. I think you could say that it's unlawful as to the woman who caused the accident. but to take the interpretation, because the person who caused the accident and gave rise to the defense for Eagle caused the violation of the act, then Eagle has to pay hundreds of thousands or millions of dollars to clean up. That cannot be what the General Assembly intended when they set up these defenses.
If you look at their brief, they say, okay, if the defenses are available to Ms. Haley, and we can only benefit from those defenses if she can make a defense. That's one of the problems with this sort of hybrid strict liability absolute. It just gets so messy. I mean, I can't think of any precedent where the ability of the party in our position to benefit from a defense under the law is dependent upon whether someone else can make the showing of the defense.
Yes, Commissioner Solomon.
Either attorney, I know this came to us before. It didn't have a really good definition of what you wanted then. It's gone to court, it's come back. I still don't see a really good definition of exactly what you're asking this commission to do. So could you clarify that in case somebody wants to make a motion in your favor?
Well, there's a notice from the Department of State telling Eagle that it needs to assess and clean up what is still out there. That is the results of the discharge. I'll add that Eagle did notify the department and did remove the oil program. What we're asking is that Eagle not be required to continue assessing and cleaning.
Let me read directly from our petition just to give you that language.
Right, and I know the court sent it back, so I'm struggling with exactly what you're asking for based on what the court sent back and what you guys have asked for.
Yeah, we asked for a petition, a declaratory ruling that Eagle is not responsible for any further assessment or corrective action in response to a fuel spill that resulted from a highway accident caused by a third-party driver.
And that request.
Mr. Solomon, I'm sorry, do you have a follow-up question?
I do. And that request is essentially the same as what it was when the court.
That has not changed.
That has not changed. Just clarifying. Thank you.
Are there other questions? Commissioner?
Arruda.
Yes.
It's a two-parter. Part one, our agencies typically granted deference in interpreting the statutes that they implement. And part two is, if that's the case, what threshold do you have to overcome for us to disregard the agency's interpretation?
I don't think that deference comes into play unless there's some ambiguity in the statute. And we believe that it's clear from that language on the first point, when any person subject to liability under this article proves the discharge was caused by one of the defenses, they have no liability under the article for the discharge. So there's no room for deference under these circumstances. And I will add, you may get a journey through other portions of the act in a minute from my good friend, Mr. Davis. None of that changes that language. That is the key to the whole case.
Any other questions? I have a couple of questions. So one is, there is a reference, and you mentioned this, I believe, Mr. Johnson, there's a mention in your brief of a particular section of the Water Pollution Control Act as a comparable sort of provision. My understanding of those sections of the Water Pollution Control Act is that they actually do place cleanup liability on the person in control at the time of the discharge, but they allow that person to seek reimbursement if a third party was responsible. So as I understand the way it works in the federal statute, a person in the position of controlling a facility or a vessel that has a discharge is responsible for the federal cleanup cost. They can then show a third party was the actual cause of the release and seek reimbursement of those costs from the third party, just as the federal government might be able to seek reimbursement. Is that your understanding?
Madam Chair, I think that's where the defenses under the state law changed that. That's why it's important That's the defense of circumstances where control is lost. So
Can you come to the microphone? I'm sorry. Make sure I'm recording this thing.
the defenses under the State Act are circumstances where control is taken from the party. The party carrying the law, in our case, lost control. So literally under the act, there was no control. But also the statute says there has to be a violation of the act. And so the wording is different from the federal law in that sense.
I'm not sure I read them as being that different in terms of how the control versus responsibility for cleanup works, but thank you for that response. So, and my other question is in looking at the North Carolina statute, so 215.83, which talks about illegal discharges versus 215.84, which talks specifically about cleanup and cleanup and control of the release. 215.83 talks in terms of what is an unlawful discharge, and it has the defenses that you mentioned. 215.84, which deals specifically with the question of who has responsibility to do the immediate cleanup, does not talk in terms of who is responsible for the illegal discharge. It talks in terms of who was in control. Is it not the case that the legislature used different terms in those two statutes, and the fact that it used different terms, and in one case talks about illegal discharge, and the other talks about control over the substance, the oil or hazardous substance? Wasn't that a deliberate decision on the part of the legislature? And how would you explain the different choice of terms in those two contexts?
Well, I would, based on long experience that you have also, don't know for sure what was a deliberate decision by the General Assembly when it enacted a complex statute. But the key here again is under 84, a discharge in violation of the statute. There has to be a violation. If the discharge as to Eagle was not unlawful, then it is not a violation of the statute. And that's it in a nutshell. I mean, I think that shows the General Assembly's intent that changing, like, I don't see how you can make the case that if a defense explicitly makes the discharge not unlawful, then it is not a violation of the act, because that defense applies throughout the act. So therefore, it's not a violation as to Eagle. Now, you brought it up a minute ago. Somebody could argue it's a violation as to Ms. Halley, who caused the accident. But that leads you to what I think is a pretty absurd rendering, that she violated the statute, caused the problem. She didn't have the defense. She caused the problem, and Eagle has to pay for the cleanup. I just don't think that can be what the General Assembly intended.
So one follow-up on that. So is it the petitioner's position then that the third party was in control of the oil at the time of the discharge, and the third party is solely responsible for immediate response and any cleanup?
Not necessarily. I mean, how do you interpret control? I think somebody could make that argument, but I don't, we haven't analyzed the case from that side of it. I just don't think that can be passed back over to Eagle to say they were in control and therefore have to pay for a cleanup.
Thank you. Thank you.
Madam Chair, I need to address that last point. It's my understanding, Mr. Dunn, please correct me if I'm wrong, that Eagle had stipulated that they were the person having control of the substance under the act, because if that's the case, then that's a question of fact, because the department has in fact asserted that they were the person in control. The briefs before the commission before demonstrated that Eagle stipulated that they had possession prior to the discharge in their truck. And if that's the case now, that they're saying that they're not in possession, then it's not proper to consider under declaratory ruling because declaratory rulings are not intended, Madam Chair, to resolve questions of fact. And so that, I just wanted to point out that is a significant departure from the stipulations that have already been agreed to prior to this coming before the body.
Mr. Dunn, can you clarify the position of the petitioner with respect to who had control of the oil at the time of the discharge?
Got it. We did not have control. If someone pulls out in front of a truck, causes our truck to veer or turn over, catch on fire, and the oil leaks out, our position is that we lost control. Eagle lost control.
Is there a stipulation in the materials submitted in connection with the declaratory ruling that Eagle Transport was in control?
We were carrying the oil before the accident, but not in control. And by the way, let me say, the statute says that it's 84 says in control immediately before the discharge. And I think that tells you something about what was intended.
Madam Chair, then we have a different matter entirely, because if they're not continuing to stipulate to the fact that they were considered the person in possession immediately prior to the discharge, whereas the department is saying that they were, and that was exactly one of the, you can look back at the previous decision, that was a primary and necessary part, because otherwise it's a factual dispute and we can't resolve factual disputes.
Can you, let me ask first if council can identify in the materials, and I don't know if this will take a few minutes, but if you can identify in the materials where there was a stipulation to that fact, that would be helpful. I will simply note that the statute, so 215.84, does refer to control before the discharge. It seems to be an agreement that Eagle was in control of the oil immediately before the discharge. But I will ask Mr. Reynolds to see if he can identify an actual stipulation in the record. In the meantime, let me just see if there are other questions for Mr. Dunn and Mr. Johnson, and then we'll go to Mr. Davis for his presentation. Commissioner Carter.
It's not a question, but I'm a little concerned here because council seems to be conflating possession and control, and those aren't necessarily the same thing in this context. Yes, I don't think they would contest that they had possession of the oil, but they're arguing that they didn't have control once the event took place, and those are not the same terms.
Well, I'm not suggesting that they have stipulated that they had possession after the oil had spilled, but what they had stipulated to previously, and we can look back in their brief, both their original brief and original petition, as well as their briefs before the Superior Court, and what the commission's decision said as part of the stipulated facts was that they met the definition of having control over the oil or other hazardous substance, which is defined as being any person using, transferring, storing, or transporting oil or other hazardous substance immediately prior to the discharge. So there's the dividing line of discharge and everything after.
Right.
Having control being before the discharge, they were in control of the oil, and that's what was stipulated to. But now, if they're saying that we weren't the person having control, as that term is defined and as had been stipulated previously, then this commission now is faced with a factual dispute because the department itself has said they had control. We understood that the stipulation had been that they had control prior to the discharge. And so if you have the department saying one thing and the petitioner saying another, then you have a factual dispute. And the law is very, very clear on this, that this commission doesn't resolve, this commission or any other commission under declaratory rulings do not resolve factual disputes. It's just a matter of how does the law apply to a given, meaning undisputed, set of facts. And what you just heard was a dispute as to that fact.
Well, I guess I'm not clear on that, Philip. And you just said that the department said they had control before the accident.
Mm-hmm.
They agree with that. That's not the issue. The question, that's why I focused on what your comment about possession. Nobody's, I think, doubts on possession. I think I understand their argument clearly. It is they lost control.
Oh, sure.
as a result of the accident. That's what I think we should be focused on, and not the question of who possessed the oil before the accident. We know that, and we know they had control up to the point of the accident.
And I'll let the department speak to that. Sure, certainly, Commissioner Carter. And I think maybe you're on to what the question was, but I understood the chair's question to be, are you suggesting that you didn't meet the definition of having control?
Well, Madam Chair, point of order.
Commissioner
It
Solomon.
seems like we're having a legal debate among ourselves and not asking the petitioners. I'd like to ask the petitioner to go back to his original slide 1 or 2, and talk about, he mentioned possession and control and the difference, and let him answer for himself while we look up exactly the finding of fact here. So can I ask that question for you guys to do that, to go back to that earlier slide? And you pointed it out early about the difference between possession and control. You said that the department's going to argue that the word possession, not control. There it is, that slide. Can you clarify that slide for us in your opinion?
Yeah, it's just what I said. The key legal term there is control, but the term that's going to be used many times here is possession. I think what I would suggest you do is just go back to the basic stipulated facts, which is what I stated from the beginning. And you can make a ruling with us or against us just based on those stipulated facts alone. There was our driver was unable to avoid a collision when a car failed to yield while turning in an intersection pulled out in front of him. The truck overturned and caught fire. At some time after the truck overturned, petroleum from the tanker spilled onto the highway. Those are just the basic, undisputed facts. And I think based upon those undisputed facts, you can make a decision one way or another in applying the statutes to those basic statutes. And I respectfully submit that whether there's some stipulation in the record about control or not control is a red herring here. Let me add, even if you were to find that we were in control of the oil immediately prior to the discharge, that does not change our legal position that the defenses are available, since they are available to any person subject to liability under the article. So,
Thank you.
Thank you, Mr. Dunn. I think we'll probably come back to this discussion of what it means to be in control. In the meantime, if there are no other immediate questions, yes.
Yes, gentlemen, just a quick question. Are you saying that there was no discharge in violation of the act? In fact, its basic essence, was there a discharge, no matter who controlled it, no matter who caused it? Was there a discharge in violation of the act?
we're not saying that there was no discharge. We are not saying that there was no unlawful discharge. We are not saying that. If you look at 83A in the declaration of a unlawful discharge, that's what occurred. But the inquiry doesn't stop there. You have to look at subsection B and the accepted discharges.
And I don't mean to, forgive me, I don't mean to jump in on you, but
Yeah, it's fine.
I understand what you're saying, that, you know, this section shall not apply to discharges of oil or other hazardous substance in the following situations, and that's where the exceptions come in.
Yeah, you're on
So-
subsection B.
Right, so the subsection A doesn't apply if you meet one of subsection B's.
That's right.
Okay.
Basic two parts. Here's an unlawful
Right,
event. Here are exceptions.
so then when you go to 84,
Right.
except for A2, any person having control over oil or other hazardous substances discharged in violation of this article.
That's right.
Okay, so I guess that's where my question is was this oil discharged in violation of the article?
We covered that. This was not a permitted discharge. The bottom line, whether you up or down with me, is it's an 83B2.
But does,
Accepted discharges. When any person subject to liability under, we go back to my last slide. Not this section. When any person subject to liability under this article, the entire act proves that the discharge was caused by any of the following. It is our contention that by virtue of that language, those defenses are available to Eagle by virtue of being cited under any provision of the article for cleanup responsibility. The position, that's our position.
yeah, and I see what you're saying, I guess, and I apologize for taking so much time. I'm just having a hard time. Is there a conflict between a discharge in violation? If there's a discharge in violation, then 84 says a person having control or other over the hazardous substance, and control is defined as immediately prior to. Is there a conflict between that sentence there and the exceptions?
Once again, you cannot create a silo between 83 and 84. You have to look at the relationship between the two. 84, which is the basis for the department's position, prohibited discharge, discharged in violation of the article. Where do we go to determine that? That sends us back to 83. What does 83 tell us? Unlawful and then exceptions. So you have to read them in a way to construe them together, not in separate silos. That's the statutory construction argument, which you're well familiar with. Read them together in harmony with one another.
Commissioner Duggan, did you have a follow-up?
Mr. Dunn, did you?
I'm willing to say that I think in these circumstances, there's no one liable under 84. There wasn't a violation of the statute. This Hallie, there was an accident, but she wasn't in control of the water. And Eagle has the defense. And that's why I tried to emphasize the point the General Assembly anticipated this and set up the fund and authority for DEQ to clean up from time to time. That's the appropriate route. It'll be rare. This is a rare circumstance, but there will be circumstances where there's not a party either responsible for cleaning up or can afford to clean up. So we're not trying to run from that possibility, no.
Thank you.
Madam Chair.
Thank you. Commissioner Keen?
Thank you, Madam Chair. It came before us before, and sitting in the same place as I was before, listening to this, it was the interpretation of possession before the accident and after the accident, and a spill after the accident, not before.
Right.
And so the control piece, Eagle had control in their possession. It was their product. They could not control what happened to that product in any way, shape, or form. It was a spill. So the interpretation, Madam Chair, at our last meeting, and I'm not sure what that vote was from this, but there were some that were not here, that are here today, listening to this for the first time. And the control versus the possession, before, after, that's the interpretation of the 83B2 is the omission of a third party, whether any such act or omission was or was not negligent. That's my interpretation
you.
of where we are right now.
Commissioner Keen?
Yes, ma'am.
So let's hold debate and limit ourselves to questions at this point. We're going to hear from Mr. Davis. I will, I guess, forecast, and Mr. Davis may answer this question, but I'll forecast for the petitioners as well. I do have one more question, which is, do the statutes define what it means to have possession and control of oil in this circumstance. But let's hear from Mr. Davis.
If I want to switch over to my PowerPoint, should I be able to do that right here?
I cannot answer that question.
We're gonna make you talk from theirs. Try to do that, but I didn't know that. I'm trying to bring it on. Sure, I've got. He just did your slides and put a different Get right after. This was a funny, but you have to say business.
So we'll hold for a couple of minutes if anyone wants to get a bottle of water. Don't go far. We did have issues yesterday with being able to pull up some of the PowerPoint presentation.
Yes.
Oh, no.
Yeah, that's.
That's more serious.
More serious than my part.
Oh, there you go.
Good morning.
Is it something? I'm in a meeting right now.
How are we doing out there? Okay.
Surrender. Yeah, they should be equalized. Yeah.
Thank you. Let's call the commission back to order. Thank you to the technical staff again. Mr. Davis, if you'd like to proceed.
Yes, thank you. Thank you to the commission for your patience. My name is Phil Davis. I'm here today on behalf of the Department of Environmental Quality to present the department's position on Eagle Transport petition for declaratory rulings. Before we get into the statute, I just wanted to follow up on what Mr. Reynolds said and clarify what the Superior Court asked this commission to do in its order. The Superior Court in its order didn't in any way endorse one particular interpretation of the statute, and that is the issue before the commission today. As Mr. Reynolds said, all the Superior Court did was send the matter back to the commission and ask for a decision on the merits. Now, at the Superior Court hearing, Eagle did ask the Superior Court to go ahead and rule in Eagle's favor on the merits, but the Superior Court did not do that. So the commission today has complete freedom to decide on the law however it sees fit. Turning to the specific statutory provisions that are at issue here today, sections 84 and 85, I'm going to call those the cleanup provisions of OFSCA. The department's position is here in a nutshell. If you're a transporter of the oil and that oil is discharged from your truck, you're responsible for cleaning up the discharge. Before we get into the specifics about why the legislature would have made that decision, I just want to talk generally why the General Assembly might have chosen the Bright Line Rule. And that's because the Bright Line Rule makes sense here. It best fulfills the legislature's stated purpose in enacting OFSCA, which was to protect human health and the environment. Transporters and carriers of oil, like Eagle, they have greater insurance requirements than a regular motorist. They're better able to pass on the cost of the inherent risk in being in this type of business to their customers, and they have more expertise in both transport and cleanup. In fact, North Carolina statutes require commercial transporters like Eagle to have much more insurance than a regular motorist. For Eagle, the minimum, I believe, is $1 million. For a regular motorist, the minimum property damage coverage is only $25,000. So in requiring that commercial transporters have additional coverage, the legislature is showing its intent that these businesses are going to be held to a higher standard than your ordinary non-commercial driver. Eagle created the risk by putting the oil on the road, and it's only fair that Eagle pays the cost for doing the cleanup, especially since they are also the one who profits from the transport of this material. A ruling in favor of Eagle here today would also completely change how the department handles cleanup of oil spills. It would require the department to determine fault before requiring cleanup. That'd be a big change. That's not something that the department typically does. That's typically the job of a judge and jury in our state's court system, to determine liability in accidents like these. DQ has to wait on a determination from a court about who's at fault. As we all know, that process can take years. Meanwhile, the oil's sitting on the ground. It's not being cleaned up. It's getting in the groundwater. It's running off into the surface water. It's doing whatever else it does. Now, Eagle has pointed to the fund set up under OFSCA and says, hey, why don't the state just go ahead and do it? But as they can see, that's not currently funded in an amount that would allow the state to do a cleanup like the one in this case. My understanding is there's 15 to 25 of these types of accidents a year, tanker accidents in the state of North Carolina. The fund is simply not equipped to handle cleanup from those events and from everything else in the state having to do with oil. And the fact that that funding is not there, again, is an indication of legislative intent, that the legislator didn't intend for the state to be, the state's taxpayers to be the party of first resort on the cleanup. They should only be the last resort. Even though Eagle's required to do the cleanup in this case, Eagle's not without recourse. It's got some remedies of its own, and these are provided for in OFSCA. Section 89 there, you'll see that Eagle is allowed to, under OFSCA, to go and seek recovery from any other party that's at fault, like the driver in this case. And I think Eagle has, in fact, done that in this case. Also, if you look at that provision in Section 94 of the statute, that creates joint and several liability between the person having control over the oil, and we'll get into that in a moment, but that's Eagle here, or the person causing or contributing to the discharge. So again, there's liability for the person contributing to the discharge. They just don't have the cleanup responsibility. But Eagle can go after that person and seek to be made whole. I'd also note that there's no reason for there to be a joint and several liability provision in OFSCA if the person in control can't be liable if there's a party at fault, because then all that we would need to say is that the person at fault is liable. There'd be no reason to say that the person having control over the oil can also be liable. Section 83B, those exceptions that Eagle points to, they don't absolve Eagle of responsibility for the cleanup. So what is the purpose? Well, we're going to see in a moment. There are the exceptions in 83B are actually expressly incorporated into other parts of OFSCA, and so they provide protection to Eagle from those other provisions of OFSCA. They're just not incorporated into the cleanup provisions in sections 84 and 85. The exceptions in 83 also help to protect the Eagle from civil and criminal penalties that resulting just from the fact of the discharge itself. Section 77 of OFSCA is the definitions section that defines the terms that are used throughout the statute. And this is the one I think that we've been focusing on a lot this morning. There's a specific statutory definition in OFSCA for the person, quote, having control over oil or other hazardous substances. And you'll see that that's defined here in this statute as any person who's transporting the oil immediately prior to discharge, and specifically includes carriers. So my understanding on what's been stipulated here is that Eagle has stipulated that they were carrying the fuel immediately prior to discharge. So then by the definition here in this statute, they are the party with control as far as OFSCA is concerned. If you had possession immediately prior to the discharge, you're transporting it, you were the party in control under OFSCA, because that's how OFSCA defines having control. So taking a look now at Section 84, the key cleanup provision that's at issue in this case, it says that any person having control over the oil discharged in violation of the article is required to do the cleanup. You'll notice that there's not any fault-based language in here. It doesn't say the person causing or contributing to the discharge. It doesn't say the person that's to blame for the discharge. It's only about control. As we saw in that definition on the last slide, the person having control here is Eagle. Also want to point out this statute doesn't make any reference to the exceptions in Section 83B, which Eagle is relying so heavily upon. In contrast, it does make an exception for, specifically addresses the exceptions provided in subsection A2 of this same section, but that has to do with just discharges of mineral oil, so it's not applicable here. But what that does show us is that if the legislature wants to incorporate an exception in a particular part of OFSCA, it does it expressly. It writes it into the statute. One other point before we move on, if the legislature had wanted this to be fault-based, there's no reason to write the statute this way. The legislature could have just said the person at fault is responsible for cleanup. But if it's all about fault, this language is superfluous. And so the legislature must have intended something other than fault in writing the statute in this way. And in fact, you can see in other parts of OSCO where the legislature does want liability to be based on fault or on causation, it writes the statute that way. So in section 90 there, any person who discharges oil or other hazardous substances, not the person in control, but the person who's doing the discharging in violation of the article, is responsible for natural resource damages. So that's language based on causation and responsibility. Again, if we look at that joint and several liability provision, there's causation language there. One of the people that is responsible for damages ultimately is the person causing or contributing to the discharge. Again, that's not the language that the General Assembly used in section 84 in the cleanup provisions. So that can't be what they intended. They can't have intended for it to be based on causation, because the General Assembly knows how to use causation language if it wants that to be determinative. Also, Eagle's argument is that the exceptions in 83B have to be read through into every other statute in OSCO. Again, that's not correct. And the reason that's not correct is because the General Assembly knows how to write exceptions into specific statutes. You'll see that in these statutes here, in the highlighted language, these are other provisions of OSCO, other statutes in OSCO, where the General Assembly wanted the exceptions in 83B to apply. The General Assembly specifically wrote those exceptions into the statute. So the first one there, section 93, if you have control over oil and it enters the waters of the state, you're liable for natural resource damages subject to the exceptions enumerated in section 83B. And it's the same thing in that statute below. But again, that language, nothing about subject to the exceptions in 83B, is in the cleanup provisions, sections 84 and 85. If, as Eagle contends, the exceptions in 83 carry through to the entirety of OSCO, to each individual statute in OSCO, there's no reason for the General Assembly to have put this language in there, incorporating those exceptions in these specific statutes. So again, that shows us the General Assembly's intent was that the exceptions not apply to the cleanup provisions, because the 83B exceptions are not incorporated there. Wanted to look also at the cleanup provision in section 85. This is about immediate response and immediate corrective action following a spill. Again, this is based on who has control over the petroleum. Again, that's Eagle here. I just want to additionally note that this statute, again, there's no fault-based language. This statute doesn't have any exceptions whatsoever. And it doesn't say, this statute doesn't even say in violation of the article. So again, Eagle argues that the exceptions in 83B should apply here, but it's not incorporated in the plain language of the statute here. So turning to that section 83 that contains the exceptions. This is the whole statute, and I just wanted to start by noting the basic structure here, which is that under subsection A, a discharge is unlawful regardless of fault, unless under subsection C, a permit is received. Now, turning to the exceptions in section 83B, which are the focus of Eagle's arguments. The department doesn't disagree with Eagle that this exception applies to Eagle, the one that they cite. But what the disagreement is what does that mean? And as you've heard me say, there's strong disagreement there. The department thinks it's irrelevant to cleanup responsibility under sections 84 and 85. And why is that? Well, for one reason, if you see here, again, Eagle keeps saying that it carries through to the entire article. But if you look here, it says under subsection B, it says this section shall not apply to discharges of oil or other hazardous substances in the following circumstances. This section means this specific statute. That's a legal term of art. When it says section, it means this statute. It means section 83. So it doesn't mean section 84, it doesn't mean section 85, doesn't mean the other parts of OSCO. It only means this section here unless there's something in those other statutes that would incorporate these exceptions. As we've seen, some parts of OFSCA do incorporate these exceptions expressly, but again, the cleanup provisions not incorporate them. So then what is the purpose of this provision? Well, it is incorporated into other parts of OFSCA. It does, excuse me, let me take a step back. If we look at 83 in its entirety, what is that doing? That's defining what an unlawful discharge is. So the exceptions here in 83B say that if you meet one of these exceptions, the discharge is not unlawful as to you, as to Eagle Transport here. But again, it doesn't say anything about what you have to do as a result of that. So that does provide some protection to Eagle, but again, that doesn't mean that Eagle's not going to have to do the cleanup. It just means they're not going to be subject to civil penalties. They're not going to be subject to criminal penalties. And then where these exceptions are expressly incorporated, Eagle will be able to use those exceptions to those statutes. But again, if they're not incorporated, Eagle can't use them because this statute only applies to this section. So let's look back at section 84 again. I want to note too that this section doesn't say unlawful discharge. The General Assembly is using different language here. It's a discharge in violation of the article. Because different words are being used, the General Assembly, we should assume the General Assembly intended a different meaning. Here, the discharge was in violation of OFSCA because it was a discharge without a permit. But even if we accept that the discharge wasn't unlawful as to Eagle and that is equivalent to not a violation of the article as to Eagle, as Eagle admitted initially and then maybe hedged a little bit, but the discharge was still unlawful as to the other driver. There's no way that there's none of those exceptions in 83B apply to the other driver. And because the discharge itself was unlawful, this doesn't say who's, again, there's no fault-based language. It doesn't say unlawful as to somebody in this statute. Because the discharge itself was still unlawful, this statute says that Eagle, as the party in control prior to the discharge, is the party responsible for performing the cleanup. So again, was Eagle the carrier of the oil immediately prior to its discharge? Yes. Eagle is therefore responsible for performing the cleanup. Happy to answer any questions. Thank you.
Thank you, Mr. Davis. Do you have questions for Mr. Davis? Commissioner Solomon?
Yeah. Remember going back to this last time when we was talking about this, but I just want to ask a question. Have you ever served in the General Assembly? Or worked in the legislature?
I have not.
Okay. Yes, a lot of your arguments. What do you base that expertise on? A number of us have worked very closely with the General Assembly. And a lot of your arguments are based on, we can assume different intentions and whatnot. They would do this. That seems speculative from your standpoint. So what do you base that on?
Well, the purpose of the commission's decision here today is to decide what the General Assembly intended. So we're having to make, we're having to glean that as best we can from the statute. The statute is what we have to work with. A lot of those are rules of statutory construction. If in the legal system, those are canons of statutory construction that we lawyers use when we're looking at statutes to glean what the General Assembly intended.
Yeah, two more questions, because I'm a strict term. Can I ask two more?
Let me just say, in response to that question, I do think it's important to keep in mind there are legal rules of statutory interpretation based on prior case law. Both parties are using those types of interpretive approaches. So attempting to understand the intent of the General Assembly based on language used in different sections is not something unique to DEQ's attorney in this case. The petitioner's attorney is making the same sort of argument. So I would keep the questions to the legal arguments and not the personal experience of the lawyers. If you have other questions.
As a, I
Commissioner-
do, but as a fellow member of this body, his arguments are based much more on subjectivity. And I'm a strict constructionist. I'm trying to read the exact words, and I found their arguments to be more along the lines of the exact way it was written.
And
So-
we can have that debate once we've completed questions to the party. So if you have additional questions for Mr. Yes.
Two, and we talked about this last time. It goes to the petitioner's comment too, but you made some statements, I'll be on the record, that basically Eagle puts the trucks on the road and profits from it. And so therefore they must be accountable. So if they were a nonprofit corporation or a small corporation, would they have the same liability as you read the Oil Pollution Control Act as they do because they profit from it? The question is, that seems a lot like policy and interpretation that I don't read as written. So can you clarify that for me?
Yes, again, we're talking about general rules here. It would apply in those circumstances that you mentioned as well. But as a general rule, does it make sense to hold someone like Eagle responsible? Is that more protective of the health and safety of North Carolina citizens and the environment, as OFSCA states as its purpose in the act? Again, those are just tools for considering what legislative intent may have been here.
Okay. And then another question along this policy line. You also speculated again that as a person who understands the General Assembly, if OPSCO was funded, then the legislative intent would be we would pay for it. Because it's not funded, there's not a legislative intent. And again, is that not a policy question? And there's a lot of things that the General Assembly doesn't fund that's still important to the state. So what do you say about that kind of flow of your argument there?
Yeah, just say again, taking kind of everything into consideration, that's just another data point. You know, if again, there's multiple occasions of these types of accidents happening every year. The General Assembly had intended for the department to take the lead on all those cleanups. You know, you could assume that there would be more funding. Is it definitive? Not definitive, but it's a data point.
Okay, that's good.
Did you have a follow-up question?
Nope, that's it.
Yeah,
Madam Chair?
I'm sorry, Commissioner Keene.
Thank you for recognizing me, Madam Chair. Going from the comments made by Mr. Tu, correct? I'm sorry.
Mr. Davis?
I'm sorry, Mr. Davis?
Yes.
I'm sorry, Mr. Davis. Apologize. You mentioned earlier, and you started out by the funds being somewhat maybe not available or they're limited because several of these happen each year, of these tanker trucks. But going into this particular case, Madam Chair, you had mentioned that the discharge piece and now the cleanup. And it is, the way I understand it is, has Eagle, did they start cleanup immediately after the discharge?
That is my understanding, but their argument is that they didn't have to. They only did that as a good citizen.
But did they start the cleanup immediately? Because that's one of the statutes that are demanded of those who are in control. So did they start up the cleanup immediately?
Yes, to the best of my knowledge, they did.
Okay. So they're in compliance with the discharge, and they're arguing control or not control or third party. I understand the argument, but I was just asking to clarify, just for clarity, if they followed up with to stay in compliance with the rule to start cleanup. Did they do that?
So my understanding is that they have, they did do the initial response under Section 85. What remains to be done is further site assessment to ensure that the initial cleanup, to see if the initial cleanup was effective in removing, all the contaminated soil and preventing further contamination.
Perfect. That leads up to my follow-up question to his statement.
Yes.
I'm just stay into the facts here. And my follow-up question then would be on your slide of 21590A. If you can fall back to that, please.
Sorry.
In reference to damages on 21590A, cleanup and damages, Okay, if being speculative here and trying not to do that, but we'll stay to this fact. Is it ongoing? Is the cleanup ongoing? And how do you define damages? Is it, and a little sub question to that, would the damages in ditches, down water streams, lakes, seepage, drifting, any of that, is that ongoing and has that been defined, or how do you define damages in the cleanup process under 21590A?
So I'm not sure that we're aware of any, again, that's kind of what the site assessment I think would tell us, would be the extent of the pollution that's still out there. The state is not at this point, making any claim under Section 98 here for natural resource damages. That was just included to show an example of a statute where the General Assembly had put the responsibility on the person who causes the discharge, not the person in control. So I don't have all of the facts on that at my fingertips. But did that answer your question?
Madam Chair, it's just a concern of mine that if that's part of the article and the cleanup and of discharge is certainly a part of this, of the facts in this particular case, then the damages I would like to know, are they ongoing? And are we aware of the cost, or the parties involved, the state and Eagle, are they abreast of the damages defined by the state, because it says state damages? And that's just a concern I have, Madam Chair. But thank you for the time. Thank you.
Thank you, Commissioner. And let me see if I can perhaps clarify a little further your question. My understanding, and Mr. Davis can correct me if I get this wrong, but my understanding of this particular statute is that it allows the state to recover cost of damages, for example, for a fish kill. So if a spill of any sort causes a fish kill, the state has the ability under the statute to put a dollar amount on that natural resource damage and collect those damages from the person who caused the fish kill. These types of damages are like civil damages. It's like suing someone in civil court for causing harm. That's a different thing from the question of whether cleanup is ongoing. So cleanup is a separate issue from natural resource damages, which typically, if they're assessed at all, get assessed very late in the process after everyone's had a chance to determine whether there's ongoing harm to a natural resource. So, and I'll let Mr. Davis, is that a correct
Yes, I think you said that much
explanation?
better than I did.
So if your question is whether cleanup is ongoing and there remains cleanup activity or remediation that needs to be done, then perhaps that's a question that Mr. Davis can answer.
Thank you, Madam Chair.
Let me go to Commissioner Monist and then Commissioner Duggan.
Commissioner Keene actually basically asked my question, which was whether they started to clean it up after it happened. Yes. So is that what typically happens in the aftermath of a spill? The person, the entity in control or the carrier starts to clean it up?
Yes, my understanding is that that's typical, that's who the department typically looks to. And
I'm Vance Jackson. I'm the section chief for the underground storage tank section in Petition Waste Management. And yes, the Eagle did perform an emergency response. Did remove a significant amount of soil from the site. The on January 20th of 2020, we issued a notice of regulatory requirements to Eagle. That was followed by a second notice of regulatory requirements, requiring that they do what we term a comprehensive site assessment, which means essentially that they need to assess whether there's impact to the groundwater. Our concern there is a nearby surface water, and while there was no direct runoff contribution from the release to that surface water, there was soil remaining at the site that was contaminated And our concern is that there could be an ongoing groundwater discharge to that stream at some point based on that residual petroleum that's still there.
So thank you. And let me just say, it's my understanding that all of this information in terms of the notice of regulatory requirements that have been issued to date are in the record of this declaratory ruling. I just want to caution everyone, we can't go outside that record. So let's stay within that. So do we have other questions for Mr. Davis, Commissioner Duggan?
Mr. Davis, which section of the act makes this specific discharge in violation of the act?
It's in violation under 83. Section 83 says it's unlawful regardless of fault, unless there's a permit. Then there's an exception. But again, the exceptions here don't apply to the other driver in this case. The other driver, pled guilty to being at fault here. So she had fault. The accident as to her was therefore, the discharge as to her was therefore unlawful. The department's position is that it's in violation of the act as separate from being unlawful, simply because there wasn't a permit, regardless of whether these exceptions apply. But even if we think we should take the exceptions into account, even if the commission thinks the exception should be taken into account, the exceptions don't apply to the other driver. So that discharge is still in violation of the act, however you look at it. And therefore, what 84 says is the person, if there's a discharge in violation of the article, it doesn't matter who caused it, who's responsible, who made it be in violation of the article. It's the person who had control. That's who to clean up. As we've seen, that's equal here.
Did you have a follow-up?
Yeah, I do. And so 84 says is titled, or I'm sorry, 83 is discharges. So that talks about the discharges, but B says that this section, which is 83A, 83B, and 83A and 83C don't apply if you meet one of B. So they don't need a permit to have this discharge, correct?
Again, the department's position is that you have to have a permit to do the discharge, or else it's in violation.
Okay.
We could say that's again separate term from being unlawful, but even accepting, accepting for the sake of argument that it would not be unlawful if the exception applied, it would have to apply to everybody. So here, because the driver doesn't fall within these exceptions, the discharge is still unlawful. It's still in violation of the article.
As to the driver, but not as to the carrier.
Yes, you could read it that way.
Okay. And then one follow-up, if I may. 93, 21593, liability for damages caused. Any person having control over oil or hazardous substance which enters the waters of the state in violation of this part shall be strictly liable without regard to fault for damages to person, except if you fall under 83B. So if this accident occurred right next to a body, a water body of the state, they would have no liability?
That's a good question. They would still be responsible for the cleanup under Section 84. Again, there's no exception there. What this is saying is that they're not going to be liable for those kind of civil damages in a lawsuit for, damage to the property as a result of the spill, as a result of the cleanup, as a result of, loss of use of the property while the cleanup's happening, as a result of, residual contamination that the department says is within the standards, but now you've got a little bit of contamination there that you didn't have before. Typically, if it happened on private property, the owner of that property would be able to sue and say, okay, well, you've got to pay me kind of the diminution in value of my property. What this is saying is that a person like Eagle isn't going to be liable for those types of damages, those types of money damages. But again, because there's no exception, because the cleanup provisions 84 and 85 don't incorporate the 83B exceptions, they're still going to be responsible for doing the cleanup.
Thank you. Thank you, Madam Chair.
Any other questions? Yes, Commissioner Arado.
I have two, if I may. Has the department's interpretation of the statute changed today from what it was from the time of the spill up until the challenge was brought?
No, the it's been consistent.
Is there anything in the record indicating that Eagle did not, let me rephrase that, is there anything in the record stating that Eagle believed it fell under one of those exceptions between the time of the spill and the time the challenge was brought down the road?
My understanding, and I'm going into my memory a little bit on this, is that Eagle, at the first hearing, Eagle said they did the initial cleanup because they got bad legal advice, and then they got new legal advice, and that's when they determined that they did not have to do any further cleanup. That's my recollection of what's in the record on that.
Thank you.
Other questions from Mr. Hill? Thank you very much.
Thank you.
So having heard the two presentations, I guess the floor is open for motions and debate. And again, the issue is specifically interpretation of the statutes in terms of whether Eagle, as the party in control of the oil immediately prior to the discharge, is responsible for cleanup. So on that point, I guess Commission Counsel reminds me we did leave one issue outstanding, which is whether there's a factual dispute over Eagle's position with respect to having possession and control as defined by the statute, and what position Eagle has taken on that point in the prior filings and the declaratory ruling stipulated facts. So I will let Council Reynolds address that, and then we'll return to the commission discussion.
So thank you, Madam Chair. And just so I don't drag the commission into a rabbit hole, I just like to ask counsel for Eagle, for the petitioner. I want to make sure I understood what you were arguing. You're not disputing that it was Eagle's truck on the road. Is that correct? And you're not disputing that there was fuel in that truck at the time, correct? Okay. So the definition of having control for the commission, the definition of having control over oil or other hazardous substance is that it shall mean, but not, shall not be limited to any person using, transferring, storing, or transporting oil or other hazardous substances immediately prior to a discharge of such oil or other hazardous substances onto the land or into the waters of the state, and shall specifically include carriers and baileys of such oil or other hazardous substances. Is it the petitioner's contention that they don't meet that definition of having control immediately prior to the discharge? Not when the accident happened and then the fuel occurred, to Commissioner Keene's point. Once the fuel is out there, it's no longer control. But I just want to make sure that the petitioner is not suggesting that they did not have control immediately prior to the discharge.
I'm going to state the undisputed facts again. It's our truck, it's our fuel, it's going down the road, it's in a collision. The truck overturned. The truck caught fire as a result of the collision. At some point after the truck overturned, there was a discharge of fuel from the truck.
Okay.
Thank you for that clarification. If there are no further questions, is there a motion on the declaratory ruling request?
I have a question of what was just put on the board. DEQ rewrites the discharge statute, and Commissioner Arata asked about a time frame, and I'll ask the same with staff. DEQ rewrites the discharge statute. When was the rewrite done? I don't understand that.
I think Commissioner Keeney's suggesting that their argument should be considered a rewrite. Is that fair? There's not, I don't think the statute was actually rewritten.
Yeah, maybe it's time to take this down, even though it's my PowerPoint, since you're in deliberations. But this was sort of my concluding argument, so.
Okay. Yeah, again, Madam Chair, it's interpretation in that threw me off.
Do we have a motion? Again, the issue in the declaratory ruling is specifically the interpretation of GS 143-215.83 and 143-215.84, and particularly under 215.84, whether that statute requires or makes Eagle Transport as the person or company in control immediately prior to the discharge and therefore responsible for cleanup. Mr. Solomon?
I'll get the debate going there. I'll make a motion, we uphold the petitioner's request.
And so if you could find the wording again, Phil, or perhaps Mr. Johnson can find the wording specifically. I can paraphrase. I think yes, that's fine.
I would, yeah, if you could.
If
give
you
that
would
to council.
identify what that document is, however, for the record.
Yeah, it's the petition for declaratory ruling. Madam, if you'd like, I'll read it.
That's fine.
Petitioner Eagle Transport petitions for declaratory ruling that Eagle is not responsible for any further assessment or other corrective action in response to a fuel spill that resulted from a highway accident caused by a third-party driver, which involved one of Eagle's tanker trucks.
That is the motion on the floor. Is there a second?
I second that, Madam Chair.
Is there a discussion on the motion?
Discussion, I would like to add as the motioner, if I may.
Commissioner Solomon?
Yeah, I think the motion that I asked in the very beginning was what, and the key word there is further assessment based on my reading of the statutes. And I do find it compelling as we've looked at other things, how things are strictly written and not speculative. And I just, for my own discussion, I found the idea that going after deep pockets or intending to read into the statutes that are very literally written, how the General Assembly funds something from one session to another. For me, it doesn't seem right that we put people on the hook. This was either the local government or a small person. We have a different standard for that. I don't read that as how the Oil Pollution Control Act reads. So that's the source of my motion.
Is there further discussion on the motion? Yes, Commissioner McAdams.
Madam Chair, I say this, first of all, with considerable respect for Eagle Transport, good folks, good business. And also it's frankly intuitively unsatisfying for Eagle Transport to have suffered the losses in many respects that they have, and yet the state still be barking at them to clean this up. But I do see this situation differently. I do believe that there is a separation between this rule, is it 84, removal of the prohibited discharges. It is really clear that Eagle had control before the incident. They are the party that had control. And in Section 84, the ones who had control are the ones who were responsible for cleaning it up. For commercial licensure purposes, as has been explained. Section 83, discharges, describe what it shall be unlawful for and provides exceptions to that. And 83D to B2D, it says an act of remission by a third party. And yes, indeed, there's a third party that caused this, not Eagle. Eagle did not cause this. But the exception is as to their responsibility under the law? Did they do anything illegal? And as Attorney Davis has pointed out, also that is restated in several other provisions of the statutes. I believe it's clear enough that while it offers Eagle appropriate protections as to several aspects of this incident, it does not remove the responsibility for the entity that was in control of the oil in this incident immediately before it to perform the cleanup.
Thank you. Yes, Commissioner Carter.
I want to second Commissioner McAdams' comments.
I have not made a motion. I'm speaking to the motion on the floor.
Oh, I'm sorry.
I could
Well,
make
wait
a
a minute. Let
substitute
me
motion.
step back a second. Then, is the motion actually been seconded?
Yes.
Yes.
Yes,
Okay.
the motion was
All right,
made by
I'll be-
Commissioner Solomon and seconded by
Yeah,
Commissioner
I'm
Keen, and that
simply-
was to approve.
Well, I shouldn't use the word
Requested
second. I guess
declaratory.
I'll say I'm endorsing the comments of Commissioner McAdams.
Madam Chair, I'll offer it as a substitute motion. We can see if substitute gets approved. I leave that to the
You
discretion of
tested
the
my
chair.
parliamentary procedure at the January meeting, and you're about to do it again. So a substitute motion, as we discussed in January. First, there has to be a vote on whether to substitute Mr. McAdams' motion for the original motion. If that passes, then his motion would become the motion on the floor, and there would be debate of that motion on the merits. So is there a second to Commissioner McAdams' substitute motion?
Well, I guess I said the wrong thing when I said that word, because I didn't intend to set this up.
Madam Chair,
What I wanted to do was support Mr. McAdams' position, and I agree with it. I'm highly sympathetic to Eagle. I think they're really gotten, it's a terrible situation with him. But the problem for me is the statute in the definition of having control over oil is just, I think, clear as a crystal here. Whether I agree with it or not, it says immediately prior to the discharge. And it seems to me that settles the issue on control under 84. So I'm in agreement with Mr. McAdams on this. And if he's going to put forward, I guess your motion is to deny that, or is the substitute is to deny the
Actually,
petition?
I offered my comments
Yeah.
in the context of discussion of the motion that is on
That's
the
what I
floor, the
thought.
seconded motion.
That's where I was going.
And I am entirely good with allowing other conversation around there. I find conversation informative, even to myself. But I currently feel, as I have stated, and I'm ready to make a motion for that in the course of
So
this procedure.
So let me ask this question. Mr. McAdams made a substitute motion. I have not heard a second to the substitute motion. If there's no second, we'll continue debate on the original motion, and the debate will go on.
So, and Madam Chair, just for clarification, and I'm feeling a little bit like Commissioner Solomon's statement about nonprofits, that's this guy right here. I'm your nonprofit. But the motion is that from Commissioner Solomon, seconded by Commissioner Keen, is that the commission would be ruling on the merits in favor of Eagle's position. And because again, it's not about denying the petition, it's about ruling on the actual merits. Because that's where we're at now based on remand. So if Commissioner McAdams is withdrawing, I think, his motion to substitute, or if it just fails for lack of second, then the debate will return to Commissioner Solomon's motion, which will need to be voted up or down. If it's voted down, then another motion would need to be offered. If it's voted up, no more motions, but if it's voted down, then a second motion would need to be offered as to the merits.
And Madam Chair, I was putting forth my view on this to advocate against voting for the motion on the floor. That's what I was doing.
I understand. And again, I've not heard a second. So in this,
Let me clarify to everybody. We're having a hard time making a motion. I was going to throw the motion out so we could discuss it and vote it quickly. But now we've got a motion on the motion. I was trying to expedite this discussion on an up or down vote and then another vote.
I have not, Madam Chair, I have not made a motion. Okay.
I'm sorry if I misunderstood what you said.
And thank you, Charlie, for seconding my non-motion.
I'm endorsing your remarks. That's what I did.
So return to the motion on the table, which as council said, is to grant the declaratory ruling request of the petitioners. Is there further debate on the motion?
Madam Chair,
Commissioner Keen?
thank you. Because I second it is, again, going back to discussions of what we heard, but the petitioner has asked that they not be responsible for further assessment. Am I correct there with that? Was that part of the motion?
Commissioner Keen, I guess my response to that, and I'll defer to Mr. Johnson if he wishes to add anything. My understanding is the fundamental question before this commission is the interpretation of the statute. Now, the practical result of interpreting the statute, as petitioner has argued, would be to free the petitioner from further responsibility for remediation. But the issue for us is not actually the practical question of how much, if anything more, the petitioner needs to do. It is what the statute means and whether they are responsible under 215.84 for remediation of the discharge.
Yes, ma'am. And the reason I asked that question is that's exactly what he read when he stepped back up to the podium, that he included the further assessment. Is that not clear? Was that correct, sir? You read it.
Just quickly, that was just solely to account, further is there to account for the fact that, as you have heard, there was some initial remedial efforts that Eagle undertook. And the petition for declaratory judgment ruling was filed in response to the second notice of regulatory requirements that you heard about, which is still pending, that we go now and conduct a comprehensive site assessment.
All right.
Chair, since I made the motion.
And the second part, I got follow up?
Yes.
In my follow up.
We are in debate of a motion on the
Yes,
table. And so
Questions.
we have completed the question portion of the program. And I would encourage commissioners to focus on debate on the motion that's on the table, which is to grant.
Okay, but that's what he got up and read, and then Commissioner Solomon made the motion, but the further assessment, I'm concerned about the cleanup piece, and I'm also concerned about the general statute, that the 83B is a part of moving forward. And that's why I seconded the motion.
Commissioner Solomon?
If I may, the further assessment, and that's why I was very clear when I first started asking questions and what I did before I made the motion. To me, I've heard people say this sets a precedent, and maybe it does. We are going back to the rule, but here it's very narrow. They cleaned up the dirt. They cleaned up. There's been no discharge to the water. That's been in the finding of fact, even from the state. Right now, we're worried about some residual runoff. And all the motion says exactly how it was written was they're not responsible in this case for further assessment by those rules. Now, if somebody wants to take this ruling and say that's a precedent in the future, that's not what we concluded here. We concluded that they're not responsible for further assessment in this particular case per those rules.
I have to respond to that.
That's fine.
In a declaratory ruling, the position of the commission is to interpret the statutes and rules.
Yeah.
And so the question before the commission brought forward by the petitioners is the interpretation of two specific statute sections. Whether petitioners are responsible for any additional cleanup on the site or not those are judgments made by the department in implementing the statutes and rules in a particular instance. But in this case, the question is, what does the statute mean? Who under 143, 215.83 and 215.84 has responsibility for cleanup? So I think we need to be careful not to turn this into a factual decision about a particular party and what the remediation requirements are on an individual site, that's not the issue before the commission. The issue before the commission is the interpretation of the statute. That has practical implications. There's no question about that. But that is not the subject of the declaratory ruling. So I would highly recommend that we stay focused on what the interpretation of the statute is and whether the interpretation proposed by the petitioners is the appropriate interpretation of those statutes, whatever the implication is for their obligations in the future.
So at the direction of the chair and council, she's going to weigh in here in a second. I know him too well, right? I'm sat where you sat, so I know what he's going to say. If that is it, I was very specific about asking from the beginning what the court has asked us to do and what we were supposed to do, and I made a motion exactly to that effect. If that's not the right motion, even though we took it as a motion, then I would like to withdraw the motion and let somebody else come up with the correct motion. I did my best to bring us to a vote on the motion I thought we were supposed to consider and do it quickly, but I will withdraw if the second is withdrawn, and we'll listen for another motion that, Counselor, you may need to come up with in this case.
Do you have advice on this point?
This is where I get to enjoy my position as counsel. The only time I get to enjoy my position on council is that I don't have to make the motion. But I would like to reiterate and echo your points earlier, Madam Chair. Again, petitions for declaratory ruling have to be on a given set of facts, no factual disputes, right? Eagle has said that they cleaned up enough. The department has said they have not. Therefore, that's a factual dispute. And while the practical implication of ruling for the petitioners is that they will not have to go further, the underlying question is this: whether a discharge that has been caused by a third party is, or whether the person having control over the fuel is responsible for the cleanup where the discharge has been caused by a third party. So yes, they've already started to clean up, and yes, they've gotten to a certain point, but the argument and the question goes all the way back to the beginning of whether the article ever applied to them in the first instance, whether they cleaned it up or not, right? And it sounds like Commissioner Solomon is wanting to withdraw it because we can't limit the ruling to say you've cleaned up enough, because that's a factual dispute. We can only say whether the article applies or doesn't apply to Eagle, as the case may be, under these factual circumstances. And so that's where we're at now.
So let me just say, it did not strike me that Commissioner Solomon's motion was inappropriate. I took the final wording with respect to future cleanup to be basically the petitioner's indication of what the result would be, the practical result would be. So, and I don't recall or have in front of me the exact wording of your motion, but it would not be my suggestion that it's a completely inappropriate motion, understanding that any implication about future cleanup requirements for this particular petitioner are a factual matter that isn't before the commission. What's before the commission is the interpretation of the statute. So I will leave it to you whether you want to continue debate on your motion or not. I don't think it's an inappropriate motion. I just think commissioners need to be clear about the difference between interpreting the statute and the practical implications. Now, clearly that matters to the petitioner, but that's not directly what's in front of us.
Commissioner Keene, I'm withdrawing. I'm probably now as turned around as I've ever been. I tried to say exactly what we told to do, and I thought I made that motion. And if it's I'm out, as they say, on whatever show it is, I'm out. So I'll let somebody else get in a minute.
So, Commissioner Solomon, Commissioner Keene, do you agree to withdraw the motion on the table? Since we've had a motion and a second, and we will ask for a new motion.
I withdraw.
Do we have a new motion? Commissioner McAdams.
Madam Chair, if I may. Whereas Eagle Transport was in control of the oil immediately before the spill, and whereas General Statute 143-215.84, removal of prohibited discharges requires the party who is in control of the oil to be the one to clean it up. And whereas General Statute 143-215.83 discharges provide certain exemptions, but those exemptions apply to whether or not the discharge itself is unlawful, and does not apply to removal of prohibited discharges. Now, therefore, the North Carolina Environmental Management Commission declares that the responsibility for the cleanup continues to reside with Eagle Transport.
So the motion would be that the statutes are interpreted to place cleanup responsibility on the person in control of the oil or hazardous substance immediately prior to the discharge, without regard to fault. Is that a fair
That is correct.
paraphrase?
Yes, thank you.
Is there a second to that motion?
I'll second.
Yes, and to clarify, let's stay with the second to the motion by Commissioner Carter. Is there discussion of the motion?
Just for clarification, again, we're not denying the petition, we're ruling on the merits. Denying the petition is not a ruling on the merits, we're ruling on the merits, so it's not a denial. It's how you're ruling on the merits.
Yes, Commissioner Lazarek.
I just want to express gratitude for the clear way that you expressed that, because I was also very informed by following the aspects and the sort of the key distinction between the finding of fault and the cleanup. It seems very clear that the responsibility for the cleanup falls on the person who controlled the oil, and transporting the oil is part of control. So I just want to thank you for the way you expressed that. It helped me sort that out.
Is there any other discussion on the motion? Commissioner Duggan?
I'm still struggling, Chairman. My issue is that I don't see, if we go along this route, and I want it cleaned up like the next person. I don't want it to go to any waterways. I don't want it to go to any damage to any property. The problem I have is that if 83B has no effect if you're a possessor or owner or in control of it, 83 has no effect whatsoever. 83B2 has no effect whatsoever, because no matter what happens, it could be an act of God. We're all listening to the sad situations going on in Ukraine. An act of war could happen. It doesn't matter. As long as you had control immediately before the spill, you're going to be responsible. It seems to me that 83 sets out two distinctions. One, an unlawful discharge, and one, a discharge by permit. But 83B2 says you don't have to have a permit if it's an act of God. It's not an unlawful discharge, it's an act of God or somebody else did it. I'm just struggling to find out what the real purpose is of 83B2. If you're going to have responsibility at the end of the day, why is that even in place? And if you look at what the statute says, so 215.83, its title is discharges. Then 84 is removal of prohibited discharges. Okay, so what's a prohibited discharge? It's either A or C. You don't have a permit, or it's an unlawful discharge. And again, I'm struggling with the reasoning behind 83B. If you're going to be responsible at the end of the day, why even have it in there?
Commissioner Carter, did you have a comment?
Well, I guess I would simply make this distinction, Mr. Duggan. Recognize we've been pretty much focused on cleanup and the responsibility for cleanup in this whole discussion. But remember, there's the entire separate issue that came up, I guess, tangentially toward the end of responsibility for damages. And in this case, it doesn't sound like there are likely to be any real damages, but there can be other cases where there could be huge damages. If this had gone into a waterway, if the fire had gone over, so let's say several houses had burned down or something, that's where they would, that's what 83B does for them. Eagle Transport would not have been responsible, would not have been liable for those subsequent damages. That's the key distinction here. It's the cleanup, control goes to cleanup of the immediate discharge. But the exceptions in 83B go to broader liability for anything else that may result from the discharge.
And I'll just add to that, I guess, there are also obviously other provisions in the law for civil penalties and criminal criminal penalties that also would be forestalled if you were entitled to use one of those defenses. Any other discussion on the motion? Seeing none, all in favor, please raise your hand. All opposed?
I wish I could abstain, but I won't vote.
I'm sorry?
I wish I could abstain, but I've made a pledge to come on this commission to vote up or down, so I'll vote down. I'll vote no.
So I believe we have 8 in the affirmative and 4 opposed, so the motion passes. Thank you very much for the discussion. Thank you, the attorneys involved, all of you. Let me suggest, I don't know if there's a PowerPoint for the next presentation. I assume there is. Given our technical challenges this week, I would suggest we take a 5-minute break to allow time to get that teed up and give everybody a chance to stretch their legs. But 5 minutes, please.
I was. I read through this twice.
The mouthfeel up and down. The movement by the right.
I think you selectively enforce it, but I think you know how that goes. Pursuing this, sure. They don't pursue it. The guys there.
You talked about going outside the record, but that would be outside the record. By policy intent. No, I'm saying, that's why I said, about policy intent.
So proceed to public notice and hearing on amendments to the 2P rules on commercial leaking petroleum underground storage tank cleanup fund. So you'll identify yourself for the record
Thank you, Madam Chair and members of the committee.
and please speak up and into the microphone so we can hear you well.
Thank you, Madam Chair, members of the committee. My name is Wayne Randolph. I'm with the Division of Waste Management Underground Storage Tank Section. I'm the Trust Fund branch head. Today, I'm presenting the readoption and amendments to 15A Ncac 2P. The Division of Waste Management is requesting approval from the Environmental Management Commission to proceed to public notice and hearing amendments to 15A Ncac 2P Commercial Leaking Petroleum Underground Storage Tank Cleanup Fund and the Regulatory Impact Analysis. These rules are required to be readopted pursuant to General Statute 150B-21-3A by the deadline established by the Rules Review Commission of January 31st, 2023. The Office of State Budget and Management approved the regulatory impact analysis included in Attachment B on December 9th, 2021. The proposed amendments are not expected to impact state or local governments, private households, public health, or the environment, with the exception of providing the benefit through clarification to applicants and to state employees, and the benefit of adding an informal appeals process. The proposed amendments do not cause a substantial economic impact. The proposed amendments include the following technical changes: updates to information such as department name, addresses, websites, and references, clarification of vague or unclear language, corrections and typographical edits, citation updates, updates to be consistent with statutory language, removal of redundant or unnecessary language. Amendments are also proposed to be removed references to the non-commercial leaking petroleum underground storage tank cleanup fund, which was phased out to be consistent with the changes made to General Statute 143-215.94 under Session Law 2015-241, Section 14 or Section 14.16A. Summary of rule changes. Rules 0101 and 0103 make technical updates and provide clarification. Rule 0102 is proposed for repeal because it's no longer necessary, since copies of the rules can be found on the website of Office of Administrative Hearings or the department's websites. Rules 0201 and 0202 make technical updates, provide clarification, remove references from non-commercial USTs, and remove some definitions that are no longer necessary. Rule 0301 is proposed for amendment to remove language regarding fees and payments and replace the text with a reference to the statute where these requirements are outlined. Rule 0302 is proposed for amendment to be consistent with current practices under the existing rules, including the documentation that must be submitted in a notification for acquiring ownership of a tank. Rule 0401 is proposed for amendment to remove references to requirements of the non-commercial tank fund and clarify existing procedures for determination of eligibility and documentation required to be submitted in an application. Rules 0402 through 0406 are proposed for amendment to make technical corrections and updates, make the rules consistent with statute requirements, clarify references to the non-commercial fund, clarify existing procedures for approval timeframes, clarify existing procedures for determination of eligibility and request for reimbursement, and clarify the documentation required to be submitted in an application for eligibility and request for reimbursement. Rule 0407 is proposed for amendment to provide the applicant with an informal appeals process for departmental discussion made under these rules. Stakeholder discussion. The division provided the proposed amendments to the North Carolina Petroleum and Convenience Marketers for distribution to its members to provide comments. The division held a meeting with Doug Howey with the North Carolina Petroleum and Convenience Marketers on February 7th, 2022. The stakeholders' concern was pertaining to Rule 0401-2. In the case of multiple releases that commingle into one plume, the deductible is established under the first date of release. The division and stakeholder determined that it is more appropriate to address the concern by changing the fund cap in General Statute 143-215.94b, While the division was not proposing any additional changes to the rules based on stakeholder feedback, the division has made a minor change to Rule 0402 from what was approved by the Groundwater and Waste Management Committee at the January 12th, 2022 meeting. The revision to Rule 0402 is shown in Attachment A in blue text in paragraph C, and the revisions provide clarification of existing procedures for pre-approval timeframes. The proposed rulemaking schedule. The Groundwater and Waste Management Committee approved the rules to go to the EMC January 12, 2022. EMC approval of rules and fiscal note for public comment, March 10th, 2022. 60-day public comment period. 60-day public comment and hearing, April 18th through June 17th, 2022. Earliest date for public hearing, May 3rd, 2022. EMC approval hearing, officers report, fiscal note, adopt rules, July 14th, 2022. RRC final approval rules, August 18th, 2022. And the proposed effective date, September 1st, 2022. The division is requesting approval to proceed to public notice and hearing on attachment on amendments to 15A NCAC 2P, Commercial Leaking Petroleum Underground Storage Tank Cleaning Fund, and the Regulatory Impact Analysis. At this time, this concludes the presentation. Thank you, Madam Chair and members of the committees. Are there any questions?
Are there any questions for Mr. Randolph concerning the proposal to send these rules to public notice? And that is the only action. It would be simply sending them to public notice and hearing. No questions? Is there a motion? Commissioner Bailey?
Yes, I so move to send these rules to public notice. We had a discussion about them and approved them in the January committee meeting. And then I wanted to note that, yes, there was a stakeholder meeting after that. So there is this slight change to the rules that's separate from what we saw at the committee meeting in January. But this issue was discussed with us yesterday at our committee meeting. So I move to go forward with public notice as they're now written.
Is there a second to the motion? Commissioner Duggan?
Second motion.
Commissioner Duggan seconds the motion. Is there any discussion on the motion? Seeing none, all in favor, please raise your hand. Any opposed? A like sign. Thank you very much.
Thank you.
Approved for public notice. I need to say, at this point, my computer is not capable of accessing the EMC webpage with the agenda on it. So if there's a hard copy of the agenda that someone can loan me, that would be helpful. And thank you very much. So the next item on the agenda is request for adoption of amendments to the 13B rules, general provisions for septic management, Division of Waste Management.
Good morning. I'm not sure exactly how to bring it up. Okay.
You were in very good company today.
Right. So I have all these. So. Oh, thank you. And I suppose I have to move it forward too, right? Okay. Good morning, Madam Chair, and Commissioners. My name is Perry Sugg, and I'm with the Division of Waste Management, Solid Waste Section. This morning, the Division of Waste Management is requesting that the EMC adopt the following amendment to 15A NCAC 13B 832, general provisions pertaining to septic management. Specifically, the amendment to the rule is 832A8, and it states the subsequent permits shall be valid for 10 years rather than, let me switch that. There you go. Subsequent permits shall be valid for 10 years rather than 5 years. And the division may issue subsequent permits less than 10 years based on criteria listed as A through D as it currently exists in the rule. What is the rule? Rule 832 establishes general requirements for the handling of septic and for the permitting of septic management facilities. The proposed amendment was required by Session Law 2021-83 and amends the subsequent permit limit lengths of both the septic land application permits and the septic detention and treatment facility permit from 5 years to 10 years. Note that subsequent in this case means a renewal application. The proposed amendment does not affect the initial permit length of 1 year for both of these types of permits, nor does it affect annual permits for septic management firms, those that are collecting and transporting septic. These changes to the permit length were made directly by Session Law and remain in effect until Rule 832 is amended. Since July of last year, as required by the Session Law, the division has been issuing permits to be valid for a period of 10 years where it's allowed by the rule. Further, Session Law 2021-83 included a provision that the amendment is not subject to review by the Rules Review Commission and shall become effective as though 10 or more comments have been written, objections have been received as provided General Statute 150B 21.3B2. On July of last year, the Office of State Budget and Management determined that the proposed amendment would have little or no impacts. And the regulatory impact analysis is provided in attachment A for this. The analysis also showed the increased permit limit will provide a minor benefit to both private industry and state government, and also will not affect the fees paid to the division. Last November at the EMC, the amendment was approved to go to public comment. I was assigned to serve as a hearing officer on that. The proposed rules were published in the Register. The proposed rules and the regulatory impact analysis were published on the DEQ's proposed rules website throughout the public comment period, which ran from December 15th last year to February 14th, 2022. A division also sent a link to the published notice, the rule text, and the regulatory impact analysis for both for public comment to interested parties, including industry stakeholders, environmental groups, septic and waste management organizations, licensing boards, the League of Municipalities, and the Association of County Commissioners through email on December of last year. During the public comment period, division held our virtual public hearing through WebEx on January 20th, 2022. One comment in favor of the amendments was provided by Dr. Robert Rubin at the hearing. He also submitted the same comment in writing. And these are included in attachment C. And based on the comments received during the comment period, the division is not proposing any additional changes to the rule text from what was published in the North Carolina Register. And here's the schedule that we went through, starting with the EMC approval last November. And if approved today, the next step for the rule is submitted to the OAH. And as noted previously, the Session Law exempts the rule from being reviewed by the Rules Review Commission, and the effective date of the rule will be based on legislative review. So with that, the division is requesting adoption of the amendment to 15A NCAC 13B Rule 832, General Provisions for Septic Management. and for approval of the regulatory impact analysis and the hearing officer's report.
Are there any questions for Mr. Sugg? Commissioner Keen?
Ma'am, I'm just ready to make a motion that we accept this request action.
So Commissioner Keen has moved to adopt the rules as proposed by the division following public hearing and comment. Is there a second to the motion?
Commissioner Kelvington, I second it.
Commissioner Kelvington seconds the motion. Any discussion on the motion? Commissioner Arado?
Just one question. Do we also need to move to include the regulatory impact analysis and hearing officer's report?
So the question is whether the motion would include approval of the regulatory impact analysis. Is that accepted as a slight amendment to the motion?
Yes, ma'am.
So the mover and seconder both accept that as an amendment to the motion. So the motion is to adopt the rules and approve the regulatory impact analysis. All in favor, please raise your hand. All opposed? Thank you. Thank you very much. The next item on the agenda is a request for approval to proceed to public and notice and hearing on amendments to the 13B rules for C&D and MSW landfill facilities and the regulatory impact analysis. And before we start into that, let me just mention for the technical staff, we have lost contact with the web page with the commission materials on it. So we can access, I can access the other committee materials, but the materials for the EMC meeting itself, we're getting an error message. If anyone can do anything about that. So the next agenda item, Ms. Stanley.
Thank you, Chair Smith. Good morning, Commissioners. My name is Sherry Stanley. I'm with the Division of Waste Management, Solid Waste Section, and I head up the permanent branch for that agency. If I can see better here, the screen or just, I think I'll go here. Okay, let me give you an overview of why we're here this morning. We're requesting approval from the EMC to proceed to public notice and hearing for the amendments to the rules listed below for C&D and MSW landfills and the regulatory impact analysis. And let me start by giving you a little background because these have a little bit of history to them. The rules proposed for amendment establish requirements for permit application and also for groundwater monitoring, assessment, and corrective action for C&D and MSW landfill facilities. The rules were originally adopted by EMC in July 2020 and approved by the RRC in October 2020. However, the RRC received 10 letters of objection, so a subset of the readopted rules were sent for legislative review. The division requested that the remainder of the readopted rules in the package be delayed to the effective date of the rules sent for legislative review. Senate Bill 60 was filed at the General Assembly in February 2021, and the bill originally was intended to disapprove certain rules that were in the readoption package. The division, however, worked with stakeholders to draft a revised bill that did not disapprove any rules, but instead made the readopted rules effective when the session law became effective. The revised bill also required that the rules be implemented with the changes described in Section 1C of the session law, and that the rules listed in law be amended to be substantively identical to the session law's implementation section. Senate Bill 60 was ratified as Session Law 2021-153 in September of 2021. A copy of the session law is included in the regulatory impact analysis in Attachment C. For the session law, all the readopted rules in the C&D landfill and MSW landfill rules were added to the administrative code effective September 16th, 2021. Session Law 2021-153 also included a provision that the current amendments are not subject to review by RRC and will automatically go back to legislative review as though RRC received 10 or more written objections. Give you a summary of the rule changes. The division has been implementing Section 1C of the session law since it became effective on September 16th, 2021. The division is proposing to make the required amendments to these rules, which are essentially identical to the session law implementation. The division is also proposing additional amendments to make minor technical corrections to the OAH clean versions of the rules. The rules related to permit application requirements are proposed for amendment to reduce the application requirements related to changes in ownership or corporate structure, and also related to closure permits. The division will issue permits for closure and post-closure care at the time of closure, and will incorporate plans for closure that had previously been approved at the permit to operate stage. It will be the responsibility of the owner-operator to submit a modification request to the division if they need to make changes or want to make changes. And that would be in the same manner as if they would in the permit to operate. The rules regarding groundwater monitoring, assessment, and corrective action are proposed for amendment to remove references to interim maximum allowable concentrations in 15A NCAC 2L that have been added to the rules during the readoption process. The IMAC references were added to the rules just for clarification purposes only and would not have changed the way the division enforced the requirements of 2L. Therefore, removal of these references will not change the division's enforcement of 2L. The regulatory impact analysis was approved by OSBM on November 16th, 2021, and indicated that no fiscal note was necessary because the proposed amendments will have little to no impacts on the regulated community, local government, or state government, and will have no substantial economic impact based on the following. The changes are related to the session law implementation only. The division has been complying with the changes implemented by Session Law 2021-153 since the law was effective on September 16th. The session law implementation remains effective until these rules are amended, and the amendments are essentially identical to implementation in Section 1C of the session law, or just minor technical corrections. The regulatory impact analysis provides a brief overview of the expected impacts of the session law implementation for information purposes only. Any impacts from the changes to the application requirements or removal of IMAC references are impacts from the implementation of the session law and are not a result of the proposed amendments. Here's the proposed rulemaking schedule. We were approved by the Groundwater Waste Management Committee in January to come here today to seek approval to go to public comment on the rule and regulatory impact analysis. We're requesting a public comment period April 18th through June 17th, 2022, with the earliest public hearing date of May 3rd. Hope to come back to the EMC for approval of hearing officer report, regulatory impact analysis, and adopt the rules on July 14th. 2022, get the rules submitted back to OAH late July with the proposed effective date pending the legislative review. Go ahead and repeat the requested action. The division is requesting approval to proceed to public notice and hearing on amendments to 15A NCAC 13B rules for C&D and MSW landfill facilities as included in attachments A and B in the regulatory impact analysis.
Thank you. Are there any questions for Ms. Stanley? Yes.
Yeah, if you
Commissioner
don't mind,
Carter.
could you go back to the slide that had the ended with the adoption of the session law and the effective date of the reg, let's see here. This may be it. Let's see. No, go back a little bit farther.
Okay.
Keep going.
Okay.
Well, the question, well, in any event, I don't see it right this second, but what I was curious about was I noticed you had the effective date of the rules as the effective date of the bill. And I just want to make sure I understood that. Was that the effective date for those portions of the rules that RRC did not object, or that the 10 letters didn't object to? Is that what that was about?
That's correct, but the rules that are being amended today, I guess, are kind of in effect since September 16th because we're implementing what the session law said, and they pretty much are stating what these rule amendments.
Okay, so the whole set of rules went into effect, and now we're making the amendments consistent with the session laws.
That's correct.
With the session law, okay. All right, that's fine.
Any other questions? I have one, I guess, comment, not so much a question we need to discuss today, but as these move forward and we get comments through the public hearing process and it comes back to the commission, I'm going to be interested in understanding a little bit more about removal of the IMAC references and whether that in fact allows us to go back to the status quo, because it does seem to me it's a little bit different to have been applying the IMACs previously, added a reference to the IMACs, and then as a result of legislation, the legislation removes that specific reference. It seems to me that's at least going to raise a question about whether we can apply IMACs in the context of these types of situations. And again, I don't want an answer to that right now. It just flags something, I think, for future discussion in terms of what the intent and impact of that legislative action was. So, any further discussion? Motion to approve the request to send these rules to public notice and hearing?
I so move. This is Commissioner Bailey.
Commissioner Bailey has made a motion. Is there a second?
I'll second the motion. Commissioner Harris.
And again, I guess this includes approval of the regulatory impact analysis, just to clarify that's part of sending these to public notice. So Commissioner Harris seconded. Everyone in favor of the motion, please raise your hand. All opposed? Thank you very much.
I have a question to the point here. Probably switching.
Sure, Commissioner Solomon, as long as you keep your dog mask off.
I'll keep it off. For now, I'll need to wear a mask. But to Commissioner Carter's point, do we need a temporary rule for part of this and not all of this? It seems odd that the response was, well, sort of, but why would we not have to have a temporary rule in place for this too, since the legislation is changing? Are we in no man's land? I'm asking, I don't know the answer to that.
It appeared to me, and Ms. Stanley may be able to clarify this, but I believe my understanding is the legislature allowed the rules to go into effect, but also required the commission to come back and make amendments to those rules. Is that basically where we are?
Yes.
Okay, so it has.
So they are in effect. So we don't need a temporary rule, but we're acting under a legislative mandate to make specific types of amendments.
It goes to confusion when you get the public comment period. To your point later, we'll have an interesting time. when you get public comment, so.
Yes,
Very good.
but thank you. That's a good question.
No, man.
Yeah, we are,
No, I haven't. Don't remind me.
we are capable of dragooning people into doing that. The next item on the agenda is request for approval of the hearing officer's report on proposed rule revisions to the nitrogen oxide state implementation plan rules. Mr. Nelson, DAQ. And I don't immediately have a note about who the hearing officer was on these rules.
There was a member of the DEQ staff.
Okay, thank you.
She's here today. she need to speak prior to the
No.
presentation or after the presentation?
You may do that however you choose. I just want to make sure that a hearing officer had not been appointed among the commission, because in that case, I would also have recognized them.
Okay. A public hearing was held, I guess, on the amendments, I guess, for the NOC rules. We had a virtual public hearing on December 1st. Robin Barrows from the DAQ staff was the hearing officer. Comment period was October 15th, actually, to December 15th. Got two comments I received, I guess, one from Duke Energy and one from EPA Region 4.
Thank you.
Essentially what we were doing, we were proposing two amendments, and there were two proposed adoptions. One, the 1424 was allowed alternative monitoring for non-EGU sources, and 1425 was the actual NOC budgets. Some of the comments received from on 1401, we had a comment describing the definition for large non-EGU, which we removed the phrase. We had a kind of a difference. There was large non-EGUs included in both 1424 and 1418. The 1418 regulated these sources after the October 31st, 2008. So they will continue to operate under that rule. The sources that were regulated before October 31st will now follow the 1424. We didn't receive any comments on 1402. On 1424, EPA made a number of comments requesting that we include a testing every 5 years to verify the alternative monitoring values that were used were still valid. We, in our comments back, we said that we would prefer to address those in the Title V permitting process. And the EPA also requested that we include formulas and kind of the detailed steps, procedures on how to calculate the different emissions. We included those. And the same with the measurements with stack flow rates. Or actual, there's two different approaches that they could use. They could use the NOx emission rates or the NOx CEM values, the ppm values. And they also commented about paragraph E in there, which is kind of noting that if another rule, if they're subject to another rule, the more stringent of the rules would take effect. And we prefer to keep that in there. And we got two comments on 1425, one from Duke Energy that asked that we move the, rather than having a 120-day for submitting the report, that we had a specific date, and that date goes with the Title V's. So we went ahead and incorporate that language in there. And then I guess we had another comment from EPA to establish NOx provisions. We're going to do that in the 110L demonstration and not in the rule itself. The DEQ doesn't typically regulate itself, so we did not include that. after we finished this and we submitted the package for you all to review, we also sent the rules to EPA and they came back with some more comments, which aren't included on the slide here. I guess this is the older version of it. Okay. When we submitted the rules back to EPA with our responses to their comments, they had some more comments, and we were in discussion with them several times during the period for this meeting here. One is had to do with the testing. They wanted to include the 5 years testing requirements to verify the emissions for the sources. Our argument back to them was that they did not include that in their rule as a requirement. Therefore, we cannot include it in ours. And so what we did is we pointed to a citation in the EPA regulation that said periodic testing would be done, and therefore that's how we're going to do it. And then we'll put those dates, I guess, in the permits, which is what we intended to do anyway, and they seem to agree with that. And there was a clarification about sources that are subject to 1418. They would be included in our NOx budget emissions, and we included a change in 1425 that would include those sources. And we also, I guess, amended another part in 1424 that says that to clarify that if you're not operating under the conditions that you're using your factors for, that you need to do more testing, I guess, to establish new factors based on your new operating parameters. The regulatory impact analysis, there are, some various costs for doing reporting, but there's, for most of these sources, there's a benefit because they're no longer having to do CEM testing, which we identified in the 64,000, 59,000. So we have gone through all the steps, and we're here, I guess, looking for approval, I guess, for the public, for the hearing officer's report and the regulatory impact analysis.
Good morning. My recommendation as the hearing officer is that the proposed rule amendments with the recommended changes as presented in Chapter 2 and the OSBM approved regulatory impact analysis in Chapter 6 of the hearing report be adopted by the Environmental Management Commission.
Thank you. Are there any questions for Mr. Nelson or for the hearing officer? And this is for approval of the hearing officer's report and adoption of the rules and final approval of the fiscal note. Commissioner Arata?
I so move.
Commissioner Arata moves approval and adoption of the rules. Is there a second to the motion?
Second.
Commissioner Deerhake seconds the motion. Is there any discussion on the motion? Seeing none, all in favor, raise your hand. All opposed? Thank you very much. The next item on the agenda is request approval to proceed to public notice and hearing with proposed rule readoptions and amendments to the water use registration and allocation rules and the regulatory impact analysis. So Mr. Peel.
Good morning, Madam Chair and Environmental Management Commission members. Good morning. Today, well, introduce myself. My name is Lennon Peel, and I'm in the water planning section of the Division of Water Resources. And today, we're here requesting, kind of waiting to the presentation catch up on what am I supposed to be doing.
Chair Smith, the agenda's back up online.
Yes. Yes, for those of you who made the mistake I did and navigated away from it and couldn't get back, it should be back online. Commissioner Solomon is misbehaving in class again.
Clarifying Mr. Peel, I'm not sure I'm familiar with.
No,
I'll just take this moment to say.
Let
me just take this moment to say, if all the speakers would stand close to the microphone and speak up, it is still a little bit difficult to hear some of the speakers who are soft spoken.
Okay, well, I'll try to use my outside voice. Well, again, my name is Linwood Peel. I'm with the Water Planning Section of Division of Water Resources. And today we're here requesting that approval to proceed to the public notice and hearing with the proposed rule readoption and amendments to the water use registration and allocation rules in 15A NCAC 02E, the 0400 regulation of surface water rules and the regulatory impact analysis. And well, today is the last section, 0400, which is the regulation of surface water transfer, and then we'll be complete with the 02E rules. I would like to, provide a timeline of the 0400 rule readoption history. The Rules Review Commission determination was made that the rules were necessary with substantive public interest in January 2017, and we began rulemaking to readopt the 02E rules. But then in July of 2017, the Union County IBT was contested, and we were asked by the Attorney General's office in August of 2017 to stop drafting the IBT rules. The contested case was settled in fall of 2018, and then rule drafting continued. And in the summer of 2020, Session Law 2020-79 required the Department of Environmental Quality to study the statutes and rules governing sub-basin transfers and make recommendation as to whether they should be amended. The report was due January 15, 2021 to the Environmental Review Commission. It was possible that the legislative report would affect the rules drafting and readoption process. In July of 2020, we requested the Rules Review Commission to split the 02E rules. Therefore, the Rules Review Commission allowed us to split them. And so in March 1st, 2022, the 0100, 300, 500, 600 was due March 1st, 2022, and they became effective January 1st, 2022. And the 0400, they're due March 1st, 2023. And then the internal development of the draft rules was completed on March 1st, March 2021. And then the pre-review from the Rules Review Commission was done in April 2021. And then final comments was incorporated in 2021, June of 2021. DWR then created a stakeholders group, and we asked comments from all the local water supply plan systems, which is 556 systems we mailed out, and asked them for their comments, as well as the water allocation listserv, which was 309. And we received 17 comment letters with 107 different comments. And then following in November of 2021, Harold Brady gave an update to the Water Allocation Committee doing his IBT of the rule status at that time. And the Water Allocation Committee approved the taking the draft to the full EMC in January of this year of 2022. And thanks to Julie Ventilora, Harold Brady, and David Wainwright, we got approved from OSBM of our regulatory impact analysis. So our proposed schedule is that today we're asking the EMC to approve the draft to go to public notice. And then in between April, once we notice, between April and June of 2022, we're going to hold a comment period and the hearing during that time. Our schedule is also to request the EMC to adopt the final rules in November 2022 and the approval forward those approval to the Rules Review Commission and hopefully in December and have them review and approve the rules. And hopefully our ultimate goal is to have the rules become effective on January 1st, 2023. Looking at the summary of key revision, we are providing, some examples of in here procedure explanations provided in the draft rules that is not in the statute itself. But we haven't changed the statute. We're just trying to clarify the rules as much as we can because the IBT statute is very, very prescriptive. But we're trying to develop rules that help guide the water system through the process. And hopefully it helped them navigate the IBT process better. Just looking at the different sections in the 0401, we added a purpose of the rule because it didn't have a purpose given. But then in 402, we added definitions, and just give you an example, some of the definitions that during the stakeholder process that people wanted more clarification was like primary applicant, co-applicant, emergency transfer. And one of the things about major emergency transfer, they felt that it was very broad, but then several people thought it should be more specific than others thought it was broad in the statutes for a reason. So we tried to accommodate all the comments that was laid out. But also like major river basins, it didn't have a definition. We provided one, grandfather capacity, where it lays out the 3 system elements considered and defined the calculation for each. And then we move applicability from section 401 to 403, and then we added language for the grandfather transfer. And we spelled out the data that needed for the water balance transfer, which is worksheets that we have that we provided context and the time period that it went through. And then 404, we added notification language. And one of the things, this has been I guess a big controversy throughout the IBT process, is the notification is written in the statute in a single newspaper, but we just tried to make it a little bit clearer without repeating exactly what's in the statute. And then in 405, we added language of the types of environmental documentation needed. For instance, the planning period wasn't in the statutes, but we use a 30-year planning horizon, and we present in 10-year increments, just as the local water supply plan is required in 50-year planning horizon, but 10-year. And we want to be able to compare apples to apples, have the same information that we can look to make sure that the documentation that we get follows the local water supply planning process and they're saying the same thing. And then in 0406, we added language for requirements, in a petition, provides procedures for, meeting the water conservation required in the statute within that petition. Again, 0407, we added language clarifying this, settlement and mediation process, which directs affected parties to use the, the guidance already approved by the EMC. And last, the 408, we added language there clarifying the items that the commission may need in addition to the environmental documentation to make their final decision. And some of these procedures dealing with the water conservation information as well. And then, and that's just one example. Then 401, which is added clarification, emergency and temporary transfer information. And it basically defines what condition necessitates an emergency. And if you look at all the 9 rules we have here, out of the 107 different comments from the 17 comment letters, 43 of them came from the emergency and temporary transfer. And, a lot of them was, I guess, not contradictory, but some said we should have more flexibility. Some said you need to have a tighter definition for emergency. But in this process, it really helped us understand, how people interpret the statute. So therefore, today's request is a request approval to proceed to public notice and hearing with the proposed rule readoption and amendments to the water use registration in 15A NCAC 02E 0400 rules, which is a regulation of surface water transfer rules and the regulatory impact analysis. And with that said, if there is any questions.
Any questions for Mr. Peel? Commissioner Solomon?
Mr. Phil, we've been into this journey a few times together, but when you look at the changes, is there anything substantial? I see the changes to the public notification, but what other things are going to make the IBT more effective, where we don't get sued every time? Have you been able to do something about that, or do you think you have?
To be honest, I don't think we could ever do anything to keep you from
Okay,
challenges.
just asking. You don't think so?
But remember, the rules itself, we couldn't change anything that's in the statute. We just tried to, based on our history, as you know, working with the previous non-IBT certificate holders, we try to use all that experience and take what's there and try to make it clear in the rule. But one of the things that we were being told from the Rules Review Commission, we can't rewrite the statutes and rules. And that's what we was trying to convey, the same message, but in a way that we thought was clear. Like a lot of times we were repeating ourselves.
One of the things that I don't remember, but you know, we always had the debate about, do we hire third parties to check the modeling or do the modeling? There's nothing in here about that. There was no restriction in legislation about the department putting up a couple $100,000 in a third party.
No, but that's not, that's
But that's not in the rules, anything like that.
No. And it's not in the statute, but that point came up a lot of times, to have a third party review some of the things that's outside of our purview.
Right. Okay. All right. Thank you.
But it's not in the rules itself, because you know that would be an interpretation of the statutes that's a little bit beyond our ability to do.
Other questions? Commissioner Deerhay?
Thank you. This isn't really what I'm going to ask, but I did notice there's a little typo in 0406 line 9. There's a stray hyphen in there after this number 30. I just thought I'd point that out.
Okay. Is that in the rule itself?
Yes.
Okay.
0406B line 9 on the page that we have in front of us. So
There's space between the hyphen and the years, correct?
well, there's a hyphen that I don't think needs to be there. So that's all. But my main comment is about 0407.
Okay.
And forgive me I'm not a member of the Water Allocation Committee, so forgive me for not attending and mentioning it there. There are probably attorneys on this commission who are also certified mediators. Are there any? Well, I'm not an attorney and I am a certified mediator. I found it interesting with the language there that, and mediation turns out to be a very important part of this because of the contested cases, but why there's no qualification. We ask for qualifications of engineers like PEs, but we don't say anything about the qualifications of the mediator. And in North Carolina, the North Carolina Dispute Resolution Commission has a certification process for mediators, especially working in the superior courts. The attorneys can confirm that. So I think it's important that this be a certified mediator. I don't know whether the other attorneys or the attorneys on the commission agree or not, but they need to be properly trained in the North Carolina system, I think, familiar with the rules. How would we go about dealing with that during the course of this public process?
Well, personally, I think during the comment period, we can incorporate that coming from the commission to incorporate that in itself. But in the past, the reason this is in here is because in previous contested case, it was outside of the department and the EMC that chose the mediator. The chair of the EMC at that time chose, I wasn't a part of that mediation process, but it was a certified mediator at that time. But I understand you're asking, we should write a description of exactly that. And
I would ask for feedback from council or
Yes.
commissioners on that.
Mr. Reynolds?
Thank you, Madam Chair. I think the reason the rule is written that way is because the settlement discussions themselves are part of 143.215.22L subpart H. It says, upon the request of the applicant, any interested party or the department, or upon its own motion, the commission may appoint a mediation officer. Mediation officer may be a member of the commission, an employee of the department, or a neutral third party, which should not be a hearing officer under these sections. And it talks about what the mediation officer shall do. So what the mediation officer is and how that is defined is already taken care of by statute. So the neutral third party could be a certified mediator, but we can't say that it has to be something other than what the statute has said. And because the statute has included individuals other than a certified mediator that can be relied upon or designated as a mediator in this instance, then that's what we have to go with.
Okay, thank you for explaining that.
But it sounds like you're offering services in the event.
No. But I'm just advocating the point that certified mediators bring a lot to the table, and I think it sounds like the legislature's giving it a lot more
They're using
flexibility to choose.
Yeah, if you, I was gonna say, I don't think they are now, but they got on that kick for a few years that they didn't want any kind of board certification, like we're pushing a profession over another at one point. So I don't know if this is a holdover from that, but we seemed like we were defending ourselves to the EEC on the rule readoption, if you remember, on even required licensed engineers versus geologists or certified whoever's at one point. So I don't know if that's the relic of it, is the legislation.
Did you have any other questions?
No, thank you.
Any other question, Commissioner Modest?
Yeah, I had a question. I'm seeing in a few different places about the emergency or temporary transfer. In some places, it seems like it's described as an emergency transfer is automatically temporary, and in other places, it's described as emergency or temporary. And obviously, there's a big difference there. So we may hear about this in the public comments, but that's just perhaps something to take a second look at as we go through this process.
We'll do it, and I'm sure the stakeholders had the same issue. In the statute, it's all in one section, emergency transfer, and in the first process, we split it out with emergency and transfer, and it was overwhelming comments to put that we were going outside the statute by creating, because what we think is an emergency now, another emergency can come up that we didn't account for. So, and I'm sure it would come out in the public hearing, in the public comments that people that will be discussed. As I said earlier, 43 out of 107 comments was temporary emergency comments.
Any other comments by commission members or questions? Commissioner Keen?
Yes, and thanks again for your report. It's good. The 405, could you go back to 405, please?
Yes.
That's a 30-year piece moving down to 10 years.
Yes. Well,
that fall into the regulatory impact analysis, the 405. There you go. 30 years presented in 10-year increments. Why did you go from 30 to 10?
Well, we didn't go from 30 to 10. It's 30 years planning horizon, but we need it in 10-year increments because the local response plan, we can look at the projections to make sure they're saying the same thing in their annual local water supply plan updates as they are in the environmental report. So it's still a 30-year plan horizon.
Okay.
But it falls on the same 10 years, so we can compare. If they said the demand is this much in 2040, it would be the same in both reports.
Right. That's good clarity. In reference to that, then, where do you tie your 10 years? Do you tie it to a specific date on the calendar?
In the plan horizon, it falls on the beginning of the decade. The local water supply plan is the current year and the next 10 years every year. You follow it from this year, local water supply plan is being turned into 22, it's 21, then it jumps to 2030, 2040, 2050, 2060. So when the project comes in, they have to do that year and then fall on our cycle.
Right, so I guess would the census be can I follow up?
Yes.
Just the census?
Commissioner Gator.
Chair. So are you using the census to come up with your, I guess, review process?
Well, that's what the systems and the consultants, they do that.
Okay. Oh, I was just thinking of environmental justice piece, moving forward with the censuses and tying your need to the census, depending on what region we're working in North Carolina and the changing that goes on within the state. Just following the census of what the census indicates of the needs of the state in different areas, whether they're transfers, in this particular case, what we're talking about, but just for the environmental justice piece. Thank you. Thank you, Madam Chair.
Any other questions for Mr. Peel? If not, the requested action is to send the proposed rules and the draft regulatory impact analysis to public notice and hearing. Is there a motion?
Madam Chair, on behalf of the Water Allocation Committee, I move approval to proceed to public notice and hearing with proposed rule readoptions and amendments to the water use regulations in 15A NCAC 02E.0400 rules, the regulation of surface water transfers, and regulatory impact analysis.
Commissioner McAdams has made a motion. Is there a second to the motion? Commissioner Harris seconds the motion. Any discussion on the motion?
I commend Linwood Peel and his staff on an excellent rewrite. This clarifies and amplifies the regulations in a needed way. It replaces one page of regulations with about 8 or 9 pages, but there's so much more clarity. Well done.
Any other discussion? If not, all in favor of the motion, please raise your hand. Thank you. All opposed? Thank you. The motion carries.
Thank you.
Peel. Next agenda item is to request approval of the hearing officer's report for readoption of the 2L0100 groundwater classification and standards rules.
Good morning. My name is Morela Sanchez King. I am the regional supervisor for the DWR regional office in Wilmington. I am going to present today the hearing officer report summary and request for approval for readoption of the 15A NCAC 2L100 rules, and also to request the approval for the regulatory impact analysis. The purpose of this presentation is, first, present a summary of the hearing officer's report from the November 3rd, 2021 public hearing on the readoption of the 15A NCAC 2L100 rules. Request the commission adopt the rules as recommended by the hearing officer, I was the hearing officer, and updated by DWR as noted in this presentation. Request the commission approve the hearing officer's report, including the regulatory impact analysis. The summary of the rule process is, as I am going to tell you now. On September 9th, 2021, the EMC approved the draft rules and request to proceed to public hearing. Then notice of text was filed in volume 36, issue 8 of the NC Register dated October 15th, 2021. And then the announcement of the hearing and a WebEx link, password, and call-in number were published in the October 15, 2021 edition of the North Carolina Register. DWR held an online public hearing via WebEx regarding the proposed readoption of the 2L100 rules on November 3rd, 2021. Morela Sanchez King, DEQ Wilmington Regional Office Supervisor, was the hearing officer. 4 people attended the meeting. No one chose to speak. None of the attendees submitted written comments. Then the 60-day comment period for the proposed rule revisions began on October 15, 2021, and closed on December 14, 2021. One set of comments were received by DWR staff based on staff recommendations which consisted of minor technical corrections. The comments DWR made are these. To the 103 rule regarding policy. 103A, in this, the correction was delete citizens of North Carolina to be consistent and inclusive of all persons using groundwater in the state. The rule 104 related to restricted designation. This is the 104D, add predicted or in front of expected. This is for consistency. Then the rule 106, initial response, site assessment, and corrective action. First, the 106B, replace the term steps with requirements, as it refers to the requirements in paragraph C, D, and E. Then 106C, 6B, add the word the before corrective action, and this was for grammar. Then 106D2, don't delete the 2, the number 2, as this was an oversight. Continuing 106, initial response, site assessment, and corrective action. Now, regarding 106E6B, make wording the same as 106C6B for consistency. And this is to include implement the corrective action plan upon approval by the secretary. And then 106J, add prior to achieving the standards at the end of the second sentence, and this is for clarification. Continue with 106J1, combine with J, as this should be this should be only one rule. Then 106J2, make this the new I, as this should be a separate rule. And then 106J3, make this new L, as this should be a separate rule. Now, 106L, fix the reference from J1E to J5 after J1 is combined with J. This is a tongue twister. And then this is the rule 111, and this refers to reports. 111C6F, change the words that evaluates to evaluate, and this is for grammar. Then 111C6G, add or predictive calculations predictive calculations after modeling for consistency. 111C8, change wording to a copy of the calculations or model runs and all supporting technical data. And this is because of moving predictive calculations to C6G. And now this is a new rule, 111C9, add the following in C9, a demonstration that have A and B. A, all necessary access agreements needed to monitor groundwater quality have been or can be obtained, and B, the proposed corrective action plan would be consistent with all other environmental laws. And there is a note below that says this is in the current 12 rule, but was inadvertently left out of the proposed rule. 111 reports, and this is 111D, reorganized to be consistent with the 12 rule and wording in proposed rules. This is nothing added, just reorganization for consistency. Rule 11.3 for variance, and this is 11.3B. delete the words environmental management in front of the word commission as the term commission is already defined. 114, notification requirements. And this is 114B. Add predicted or in front of expected, and this is for consistency. Now let's go to the regulatory impact analysis, the summary. A regulatory impact analysis was completed for the 15A NCAC 2L 100 rules in May 2021, which determined that no fiscal notes were necessary for the rule package. The regulatory impact analysis is included as attachment A to the hearing officer's report. Now, the summary of the content of the hearing officer report has, as you see there, 5 sections, and in the section 5, it has 8 attachments. The sections are summary of rulemaking activity, 2, public hearing process, 3, hearing officer meeting, 4, summary of public comments and hearing officer responses, 5, this is the section that includes the 8 attachments. This will be the Office of State Budget and Management approved regulatory impact analysis, public hearing announcement, hearing officer's remarks, public hearing division of water resources staff presentation, public hearing registered attendees, public hearing speakers, written comments received, and the proposed 100 draft rules. The hearing officer recommendation. After considering the comments, the hearing officer recommends incorporating the changes into the proposed rules and that the commission readopt the rules in 15A NCAC 2L 100 with the proposed changes. The proposed rule changes are included as attachment H to the hearing officer report. Response to RRC comments. During review of 15A NCAC 2L 202, the groundwater standard rules, the RRC requested clarity to the PQL definition in 15A NCAC 2L 102. DWR is proposing the following. Practical quantitation limit means the lowest concentration of a given material that can be reliably achieved by a particular analytical technique operated within specified parameters of a given analytical method during routine laboratory analysis, while following all applicable state or federal quality assurance and quality control requirements. The 2L 100 readoption timelines are on March, April 2022, it was the RRC for final review. And then in May 2022, the effective date for the rule. Our request, we respectfully request approval of the hearing officer's report, including the regulatory impact analysis and readoption of the rules as recommended by the hearing officer shown in attachment H of the hearing officer report, with the amended PQL definition as noted before on slide 17. Below is our contact information. I am Morela Sanchez King, and also Eric Smith from the Groundwater Resources section.
Thank you. Are there any questions for Ms. King? Seeing none, the action is to approve the hearing officer's report and adopt the rules with the recommended changes. Is there a motion?
So moved.
Commissioner Anderson moves. Is there a second?
Second. Suzanne Lazarick.
Commissioner Lazarick seconds. Is there discussion on the motion? No discussion. All in favor, please raise your hands. All opposed? Thank you very much.
Thank you. Have a nice day.
Can we take a break before the second half?
Yes, and so I was about to say, in order to avoid delaying unduly, particularly with the civil penalty committees, civil remissions committees, I would suggest the commission's lunch is here. Let's take a 10-minute break. If you could get your food, and apologies to the audience, we will have to be eating in front of you so as not to delay further the remainder of the meeting. So let's take a 10-minute break and let's hold to that 10 minutes and return at whatever time that is. So if I can catch up with my agenda again. The next item on the agenda is the request for approval of the hearing officer's report and adoption of the 2020-2022 surface water triennial review amendments. Mr. Ventolaro. Or maybe not. I suspect he hasn't gone far. Yes, Commissioner Harris.
Thank you, Madam Chair. As we're preparing to make this presentation, having served as the hearing officer, I've grown to appreciate and respect the effort, the public input, the science, and the complex process of the triennial review. I would like to take this moment just to acknowledge and thank Chris Ventolaro for all his work, Jeff Manning and Karen Higgins on the team, and the rest of the team members, Assistant Secretary Basemore, I don't know if she's still in here, Commissioner Deerhake for her input and guidance, the numerous agencies, organizations, the regulated community, local government, and private citizens who provided thousands, and when I say thousands, I mean thousands, of oral and written comments. And all I can say is thank you. So, Madam Chair, after the presentation and the discussion, and when appropriate, I'd like to make the motion on this report.
Thank you very much. Mr. Benson.
All right, good afternoon. Thank you, Chair Smith, and thank you, Commissioner Harris. And good afternoon, everyone. I think I've presented to you a few times virtually at this point, but I've got presented to you in person, so hello. So today I'm going to provide a kind of a brief overview, and can you hear me okay? You need me to step closer? I'm going to provide a brief overview of the hearing officer's report of proceedings for the 2020 through 2022 surface water triennial review amendments to select rules in 15A, NCAC, O2B, O200, and O300. This overview will include just kind of brief summaries of the surface water triennial review topics that we have, a summary of the public comments that were related to each topic, as well as a brief summary of the hearing officer's recommendations for adoption. Before I get into those summaries, though, I do want to just kind of refresh everyone's memory about the timeline that we had for the surface water triennial review. We came to the Water Quality Committee back in November of 2020, and then to the EMC in March of 2021, where we requested permission to go to public notice. We published in the North Carolina Register on May 17th and held a virtual public hearing due to the ongoing pandemic on July 20th of 2021. And then the end of that public comment period was August 3rd, 2021. And just to be clear, the public comment period began on May 17th when the notice of text was published. And that brings us to today, March 10th, to continue this rulemaking. And then I have a few other dates on here, and these are more estimates at this point. You know, it will depend greatly on the purview of the commission today. But if the commission does approve the amendments today, we'd be seeking to go to the RRC, hopefully in April of this year. And with that, we'd have the earliest effective dates of the ruling would be May 1st. And then, of course, we'd submit to the Attorney General for sign off in June. And then from there, the triennial review package would go to the EPA for the Federal Clean Water Act review in July, around July of 2022. And just as a reminder for everyone here, once the EPA gets the triennial review package, they have 60 days to notify us of approval of the package. and 90 days to notify us of any disapprovals in the petition. So the topics for rulemaking, it was quite some time ago that we kind of were before the commission, but we did have a number of topics. We looked at 1,4-dioxane, cadmium, cyanide, selenium. We had a site-specific recreational criteria for E. coli in the Asheville region. We had some slight rule language changes regarding the Eastern Band of Cherokee Indians, as well as some technical corrections, a few new definitions, as well as a correction to an existing definition. So I'll get into the summaries of each of the topics now. We'll start off with 1,4-dioxane. So the proposal for 1,4-dioxane was to adopt a standard of 80 micrograms per liter for the protection of fish consumption, and that's human consumption of fish tissue in all waters in the state, and also a standard of 0.5 micrograms per liter for the protection of water supplies in the state. Now, we did receive about 2,000 comments regarding 1,4-dioxane. And just real quick, when I talk about these comments, we receive comments typically in a number of different forms. Some are individual comments, some are comments where individuals have signed on to a petition, and other comments are comments that were received from groups submitting comments jointly. So when I talk about 2,000 comments, it's really trying to parse out all of the people who kind of contributed in some way to those public comments. So most of the comments supported adoption of the 1,4-dioxane standard. There were some requests to adopt the 0.35 microgram per liter standard for all waters in order to protect downstream water supplies. We did have some comments that mentioned the financial burden of implementing the 1,4-dioxane standards, and I believe this was mostly referring to the water supply standard of the 0.35. That was where the most concern was. And then we also received a comment from EPA regarding the human health exposure factors that were used in the calculation of the 1,4-dioxane standards. And just to kind of elaborate on that, just very briefly, we calculated this 1,4-dioxane standard per our narrative standard for toxics, which is in 15A, NCAC 02B 0208. And in that narrative standard, it tells us exactly how to calculate these human health standards and aquatic life standards. In this case, for human health standards, we do have human health exposure factors established in that rule. So body weight, drinking water rate, fish consumption rate, those are all established values in that 02B 0208 rule. That being said, in 2015, EPA updated the exposure factors that they use in their calculation of human health criteria. So I want to make clear that while we're sticking with the calculation of the standard as directed by our rule, we are going to evaluate the human health EPA exposure factors that they updated in 2015 for adoption. Probably part of the next triennial review, we're going to try and get to this. So the final recommendation for 1,4-dioxane was to adopt the standard as proposed. So that would be a standard of 80 micrograms per liter for the protection of consumption of fish tissue in all waters. And that would appear in 02B 0208. And it would also include a standard of 0.35 micrograms per liter for the protection of water supplies, which will appear in the water supply rules in 02B 0212, 0214, 0215, 0216, and 0218.
Questions?
Yeah,
Commissioner Solomon?
just real quickly, Mr. Vinglaro, I know you got these late, but I too got some comments from former Commissioner Tedder on the Jordan Lake watershed and 1,4-dioxane. Have you had a chance to think about that yet?
Yeah, he did send me there. I believe the comments were in regard to the use of kind of an evaluation level. Sorry.
Well, water supply 5 classifications and the potential conflict on 0.02626B, which is the Jordan Lake rules, specifically with regard not being in conflict with that rule, which is not listed up here. And I know you just got this late.
Right.
But I just want to make sure while we're talking and you're talking, maybe some of the staff can look into that and make sure we have a.
Yeah, that would be great. Yeah, I don't know if anybody can quick look at that, but basically there was a question regarding a 1,4-dioxane study that the department had done kind of back in the early stages, I think, of some of the 1,4-dioxane concerns that had come up. and an evaluation of 80 micrograms per liter was used to kind of evaluate, to compare samples that were taken against, I'm assuming determine if further action was needed. I don't really know the specifics. That was in water supply 5, water for the Jordan Lake watershed. I personally don't know why that 80 was applied in that particular instance. I'm not sure if any other staff is here that may be more familiar with that. But I do know that a lot of times water supply 5s are put in place to protect downstream water supplies. And although water supply 5s can also be used as a raw water source for kind of small systems like industries that want to supply water to their employees. But yeah, I'm not familiar.
Yeah.
I don't think I picked up on the Jordan Rule potential conflict.
It's point for everybody. It's 0.02626B, and it talks about in Part B for water designated as water supply 5 in the Jordan Lake watershed, the requirements, blah, 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 apply. So I just catching you early here with this, that somebody maybe needs to look at it before we take a vote. Do something that covers another rule.
Okay, thank you. Appreciate it. Yeah, so with that said, the recommendation, the intent of the proposal was that it would apply to all water supplies. I guess we may have to kind of look into this a little bit. Okay. Next up, we have cadmium. So the proposal for the cadmium standard was to update the existing freshwater dissolved hardness dependent cadmium standards, as well as the saltwater dissolved cadmium standards. And this was to better bring them in line with the EPA's current national recommended water quality criteria, which were updated in 2016. So just for a little clarity, for freshwater cadmium, we have 3 separate standards. We have our freshwater chronic cadmium standard, our freshwater acute cadmium standard that applies in trout waters, and a freshwater acute cadmium standard that applies for all other surface waters. And the reason why I wanted to point that out is because there is an important thing to note here. After we had come to the commission in March of 2021, we did notice that there was an error in the calculation of the hardness dependent acute cadmium standard. So that error has been corrected. And it only applied to that freshwater acute standard. It did not apply to the acute trout or the chronic standard. And to just give you a little better idea of what this means, the correction, I just threw this chart in here. And this chart really just compares the freshwater acute hardness dependent cadmium standards at varying hardness levels. You can see different in-stream hardness levels on the left there. So we have 10, 15, 25 milligrams per liter hardness. And the column immediately to the right of that shows what the calculated standard would be based on those water quality hardnesses with the current standard. So for the current standard at an in-stream hardness of 10, the standard would calculate out to be 0.37 micrograms per liter, and 0.52 and 0.82 respectively. Now comparing that to what we originally proposed is the next column, and you can see the numbers are very similar. And when I say the proposed standard, this is the standard that contained the error. So just so you're clear. And then lastly, on the column on the right, we have the corrected standard. And this is where that error was corrected in the calculation. And you can see that the values are very similar. There's a little bit more of a noticeable decrease at the 25 milligram per liter hardness. But this really isn't expected to impact things. The standard that generally drives kind of like impacts and costs is usually the chronic standard. And in the case of cadmium, the chronic standard actually relaxed. So it actually kind of became a little bit less stringent in a sense. So we did receive about 20 comments regarding cadmium. And of those 20 comments, they were all kind of part of the same group comment. And there was some concern expressed that the freshwater acute standard would not be protective of sensitive species such as trout. And this kind of points again, which in the hearing officer's report, we provided kind of a more in-depth explanation of our evaluation of this. So I definitely recommend taking a look at that if that's something that you'd like to get more information on, but in a very kind of succinct way. This goes back to the different standards that we have for cadmium. So for trout waters, we have that acute trout standard. which is specifically designed to be protective of the trout that we find in those kind of western mountain streams. Now, there may be trout and a few other sensitive species that don't appear or that occupy waters that are not classified as trout. So because of that, we went back in and we kind of reassessed what the standard would be versus the toxicity information that EPA provides for those species in their criteria documents. And through that kind of analysis, we were able to show that, this acute standard, even for all the sensitive species except for rainbow trout, which are protected specifically by the trout classifications, all of these species would be protected. So given that, the final recommendation is to propose amendments to adopt the proposed amendments to the cadmium surface water quality standards, and those would appear in 0211 and 0220. The freshwater cadmium standards would be in 0211, and the saltwater would appear in 0220. And part of that recommendation was also be to adopt, to include that corrected version of the freshwater acute standard. This brings us to selenium. So the proposal for selenium was to replace the existing selenium standard, which is 5 micrograms per liter as total selenium, and basically to update it to be more in line with EPA's current national recommended water quality criteria, which was published in 2016. Now, so some of you may remember from our last presentation that this was kind of an interesting criterion because it really takes into account the potential for toxicity due to the bioaccumulation of selenium in the fish tissues, specifically reproductive tissues. So as the fish are swimming around in their environment, they take selenium in either through their gills or through their oral route, and that selenium ends up accumulating in their reproductive tissues. And this has the effect of potentially impacting their ability to reproduce, but also potentially impacting the survival rates of their offspring. So what EPA did here, and what made this really interesting, is that they created this hierarchy approach where fish tissue and water quality samples are taken and measured for selenium. And where you have fish tissue data, that information is given priority over any water quality information that you have. And the reason why this is significant is that by measuring the selenium in the fish tissue, you're really getting a more kind of accurate, kind of to the point measure of what selenium is actually doing in the aquatic system. So we did receive about 25 comments for selenium. Most of the comments supported the proposed amendment. We did get comments discussing considerations for site-specific conditions, including lake-specific bioaccumulation potential, species occurrence, and also species-specific toxicity information. The comments also were made regarding implementation for NPD as permitting and assessment. Basically, how do you incorporate that fish tissue component? And also some requests were made to provide clarifying information in the text of the standard itself regarding how the fish tissue and water column components would be applied. So the final recommendation was to adopt the selenium standard as proposed with modifications. And these modifications mostly include adding some of that additional language that was requested. So the additional language will help to define what instantaneous means as it pertains to the duration for the fish tissue data criteria. It will also help to clarify the use of the fish tissue and water column kind of hierarchy approach. It will also clarify a little bit of the context of what it means to measure selenium in fish. That basically meaning that when you're looking at fish tissue data, you're looking at a measure of selenium that has really accumulated in those organisms over time and over space in a given water body, meaning that where those fish reside in that system can greatly impact how they're accumulating selenium, how much they're accumulating. I'm kind of going through these fast, so if anybody has any questions, please feel free to interrupt me. Next up, we have cyanide. The proposal here was to replace the existing O2B 0211 standard, which is currently for total cyanide at 5 micrograms per liter, and to propose it so that it incorporates an option to use free cyanide as well as total cyanide. And so the proposed standard was cyanide free or total, 5 micrograms per liter. And just as kind of a reminder again, the significance of this is that back in the 1980s, when EPA had published their national criteria for cyanide, they identified that the free form of cyanide is the more bioavailable cyanide and therefore the more toxic cyanide. And by bioavailable, we mean it's in a form that can be readily uptaken by organisms. So, however, at the time when EPA published this criteria, there were no Clean Water Act approved analytical methods for free cyanide. So EPA acknowledged that and recommended that states adopt total cyanide, making the important note that the adoption of total cyanide would likely be a bit overprotective because total cyanide incorporates all forms of cyanide. So it's cyanide that's kind of bound up in organic materials, it's cyanide bound to metals, and it's cyanide that's kind of free and dissociated. We did receive about 66 comments. Most of these comments were concerned that the free cyanide would not be protective enough and requested maintaining the use of total cyanide as the standard. But along with this, there were also some comments recommending that instead of using free cyanide, use available cyanide, which also has an approved EPA analytical method. And the significance of that is that the available cyanide accounts for all of the free cyanide, so all of your like hydrogen cyanides and your cyanide ions, but it also incorporates cyanides that are bound to metals. They're called weak acid dissociable cyanides. And that's important because these metal-bound cyanides, they may not be bioavailable under all environmental conditions, but when environmental conditions are correct, basically when there's lower pH waters, those metal cyanide complexes can dissociate and release free cyanides. So it's a little bit complicated. I hope this makes sense. But the end result of this is that the option of using available cyanide really addresses both the concerns of the permittees as well as the public. It addresses the concerns of the permittees because they would no longer have to meet these requirements based on cyanides that are not bioavailable or may never be bioavailable and therefore likely not to be toxic. And it addresses the concerns of the public because not only is it focusing on what EPA identified as being the toxic form of cyanide, it's kind of going one step further to also encompass forms of cyanide that have the potential to become more toxic. So with that, the final recommendation is to not adopt what was proposed, which was cyanide as total or free, but to instead adopt cyanide as total or available cyanide. And again, at 5 micrograms per liter, the magnitude doesn't change here. The other part of this would be to include a definition of available cyanide in the O2B 0202 definitions. That would basically explicitly define what available cyanide is. And that basically is that the available cyanide refers to inorganic cyanides that are free, which are hydrogen cyanides and your cyanide ions, as well as those metal cyanide complexes that are dissociated into free cyanide ions under mildly acidic conditions. Yes.
I've got two questions because we're changing here.
Commissioner Solomon?
The first question is, when you talk about total or available, do we have PQLs that are below that level, or are we guessing at that from a laboratory standard perspective?
I think the total, if I recall correctly, the total is above. I don't think we have a PQL at the moment for available because our laboratory doesn't analyze for available, but they will obtain the ability to do that. And then that will kind of establish the PQL as they.
Well, let's go back to that, because if you don't have a way to test it on available, and it takes the labs some period of time to get that, then all of our utilities are going to be subject to something that may have an adverse effect. Because we can't measure total we got a PQL below that, but available, if it doesn't have a test method with a PQL, we could be in jeopardy. The second question is, what does or really mean here either? I didn't really see a definition of, is that both, or is that an and, or is that either?
Right, it's an either. So what we wanted to do here was that we didn't want, so it's a great question because what's going on here is that, total is going to be a bit overprotective in a sense. So by having the option of using available, it really provides some regulatory relief for facilities as you switch. So if you have a facility that's currently required to monitor for total cyanide, and they're doing fine, they don't have any issues with that, they can just keep doing that. One of the things that we weren't entirely sure about is that, how much, it's hard to kind of estimate how many commercial labs have the capacity or will want to develop the capacity to do available cyanide. So we wanted to leave this as an option so that, existing permittees that are fine doing total cyanide, they can just keep doing what they're doing. Where if they may be struggling with total cyanide, they have the option to kind of switch to available cyanide to potentially get some relief. Does that make sense? And
Yeah,
that would,
but I worry about the jeopardy that if I'm not meeting total cyanide for some reason, then I'm going to go and probably, just from experience, we're probably going to proxy some number off of some variables off of, because it's a non-detect here. You're going to have to come up with some way of proxying available cyanide, which you might be out of whack on available too. I mean, I don't know. It seems more stable to do something we can test for, which is total, right?
well, we will develop that capacity. It won't take, I think there are labs that could probably do it right now. I think our lab is getting estimates at the moment to update their equipment. So it's not something that should really take terribly long to get rolling. And keep in mind that, any permittee, this would kind of be tied in with their permit cycles. So it's not like they would have to automatically switch over to doing available, it would kind of tie into that whole process of switching over. There's, we also have those compliance schedules and things like that NPDES can kind of take advantage of to, segue someone into available if that's an option that's needed. That's appropriate.
Yes, thank you. I'm always concerned that these last minute changes, that there's unintended consequences that have not been kind of vetted. Thank you.
Sure.
Any other questions? If not, go ahead.
Next up, we have site-specific recreational E. coli criteria. So you may remember we proposed this as a site-specific standard in the Asheville region, the 19 counties of the Asheville region. This was done really as kind of a response to a lot of concern that we were hearing at the time from non-governmental organizations that were doing a lot of sampling out in the region. And those groups had also developed kind of a working relationship with the division's Asheville Regional Office, where the Asheville Regional Office developed the capacity to do these newer E. coli testing methods. So our intention when we proposed this was to really kind of use this as a first step in a process of, kind of updating our bacteriological standards for recreation statewide. EPA has been recommending a shift to E. coli as a recreational indicator for decades now. So this is something that we really view this as kind of a first step, and then that we would have, kind of gradually roll in the rest of the state. So in this particular case, the site-specific standard would incorporate the E. coli pathogen indicator to replace the existing fecal coliform indicator that applies in Class B waters or primary recreation waters. And this change would have been made in O2B 219, which is the primary recreation standards rule. That being said, we did receive about 1,400 comments. And most of the comments really were focused on, questioning why we weren't adopting this statewide. So there were comments for and against the statewide adoption, but the vast majority of them were really concerned with why were we doing this in only a limited area of the state. Concerns with considerations for environmental justice issues were mentioned. And there were also comments about the lack of information regarding the impacts from switching to E. coli. So based on this and these public comments and also discussions with EPA, who didn't feel that establishment of a site-specific standard for E. coli based solely on a geographic area was appropriate, we're coming to the commission now with a final recommendation to not adopt the site-specific E. coli standard as proposed for the Asheville region, But instead, and I want to be very clear about this, the department is committing to the adoption of an E. coli standard statewide for all Class B waters. Now, this is going to take some work. You know, we're kind of shifting our focus here from looking at this kind of isolated region, or not isolated region, but this certain focused region where we had a lot of activity going on, to really having to evaluate what the adoption of this statewide will be. So this will require us to do some work. We're going to be evaluating the statewide adoption. We'll be doing a number of things, including considering kind of going back to the EPA recommended criteria and considering their recommended illness rates, their statistical threshold values, rates of exceedance, magnitudes, et cetera. We'll also be initiating a monitoring effort to where we'll go out statewide and we will collect side-by-side fecal coliform and E. coli samples to get a better understanding of, how do these things differ when we're looking at them out in the environment? Are we seeing the same numbers? Do we see different numbers? And this information will help to inform the regulatory impact analysis for this effort. And it'll also help to inform and, if necessary, help to develop what we're calling our crosswalk for TMDLs. And basically what that means is where we might have existing fecal coliform TMDLs that, if we're switching to E. coli, this information hopefully will help us to evaluate those TMDLs without having to kind of redo them. Maybe we might be able to develop a way to kind of translate them to E. coli TMDLs without having to start over. Another part of this evaluation is going to be, considering timelines for the statewide implementation. We'll also be looking at EPA made a comment in their public comments regarding the use of a phase-in approach, which is what some other states have done. I think Kentucky may have done this, where they adopted both fecal coliform and E. coli at the same time for a set period of time. I think they used like one triennial review period. And much of that time was used to allow permittees to kind of, have some time to shift their focus from fecal to E. coli. So that let people kind of get their labs up and running, make sure that, the commercial labs all had the ability to do E. coli, et cetera. And then lastly, but of course not in the least, we do hope to include outreach to stakeholders to really get feedback on what they consider to be critical issues surrounding the statewide E. coli standard in primary recreational waters. And one thing I do want to mention also is that I know, the department has basically stated that they 100% support this effort. So this is something that we are going to do. This isn't something that's going to get pushed off down the road. We're going to look at this in the next triennial review. And to kind of help facilitate that, I think one thing that we've been kind of asked to do is to put together a timeline of events to kind of demonstrate, what steps we'll be taking and how those steps might play out, time-wise. So we'll have a better idea. We can share with the public, we can share with you kind of a better sense of when we'll hope to be able to get to everything. And it's a little bit more challenging. We couldn't have that ready today because that does involve groups outside of the planning section. We do have to coordinate with other groups internally to kind of work out these things, but we do hope to come back with that sometime in the future.
Mr. Sullivan?
As you mentioned, this fecal chloroform has been going out for years, for decades. How many states have already moved away from it and how many still use it? Do you know that mix? Curiosity.
A lot.
I mean, most states have
states.
gone away from this.
Yeah.
So we're not inventing, we don't necessarily need to wait 3 years on this one. We're not reinventing something here or on the leading edge, are we? We're behind.
We're a little bit behind on this one, I think. And, it is important to note that we do have, our existing fecal coliform standards are in place and they do provide protections for the same things. By switching to E. coli, what we're really doing is we're just kind of updating to the more recent science and the more recent analytical methods and stuff like that. And the real challenge here is just kind of that shift, kind of doing that shift in a way that we're really able to make that change and make it implementable and have it go smooth. And that's the real challenge there.
So just to be sure we're all clear on this, as I understand it, the recommendation will be not to make any change in the standard as a part of this triennial review package. And instead, the recommendation is to create this as a follow-up item coming out of the triennial review on this specific standard. Is that correct?
I think that's worded correctly. I don't know.
Commissioner Arado?
Thank you. Just had one question about several of the comments had raised the issue that Class C waters are also used for recreation, and I didn't see it. It's probably in here. I just didn't see the direct response to what the department's position is between going ahead with Class B and not rolling in Class C waters as well.
Yeah, so that's a great question, and it is a bit challenging because these EPA recommended criteria apply specifically to primary recreation waters. They do not apply, and EPA has kind of verified this, that they do not apply to secondary recreation waters. And for North Carolina, that means that our Class B waters, what we classify as Class B, are our primary recreation waters, and secondary recreation falls under Class C. The other issue that's tied to that is I think a lot of what was kind of discussed as some of the environmental justice concerns that some Class C waters are actually being used potentially as Class B water. So they're actually there's some Class C waters that are experiencing a higher rate of recreation. And maybe that's something that needs to be considered going forward. And, we do have, folks always have the option to submit for reclassification. So that's something that we want to communicate. And hopefully part of this outreach with the stakeholders will be an avenue to better kind of discuss that, to inform them and kind of educate folks that, there are methods in place to do that. But also, if they let us know, they can let us know because we don't necessarily know what every single water that people are recreating in. And, keep in mind, these classifications were largely done many years ago. So things have changed.
Commissioner Modest?
When will you be coming back with the plan?
I'm not sure. I guess we'll be planning to get back to the EMC, maybe as I don't think that's fully been worked out, but maybe coming back to the EMC with an information item I'm not really sure. I guess Commissioner Harris might want to speak to that.
Commissioner Harris?
Yes, we've been talking to the department, and I was going to make that part of my motion whenever it moves forward, but bringing it back, a work plan to the EMC in May, so everybody can see how this will be moving forward.
Can I finish sorry.
Yes, I'm sorry.
And I had a chance to read the EPA letter, and it seems like the phase-in, or they call it like a hybrid approach where you have both for a while, seems to make a lot of sense. So if that is able to jump to the top of the plan, so that the folks in Asheville who seem like they've been preparing to do this can get started while we bring everybody else along with these other really important steps, seems like that could be a valuable part of the plan.
Thank you.
Commissioner Deerhake?
Thank you. A couple of points. I don't think it was emphasized in the slide, but EPA Region 4 said that taking a region-based approach, a regional office-based approach, was not appropriate. They treated it as site-specific, you said. And a site-specific standard carries a lot of extra work that goes with it to get approval. So that was one of the main drivers for moving away from the regional approach that's in the rule that went to public hearing. The other thing I wanted to mention is there in the summary in the hearing officer's report, I want to emphasize what is said there by the recommendation, and that is the department will complete the following actions in support of an expeditious return to rulemaking with a revised proposal to adopt a statewide E. coli standard for primary recreation Class B waters. And I emphasize the word expeditious, and that it will be accelerated, not waiting until the next triennial review. Correct?
Yeah, and that's part of kind of developing this plan as the first step, is that we're going to kind of roll into it and kind of start getting to work on it.
Thank you.
Yeah.
Thank you.
Immediate. Absolutely.
Madam Chair.
Commissioner Keen?
In reference to, we're not waiting 2 years out, or we're going to make this pretty quick, is moving from site-specific 1,400 yes or no's, or agree or disagree with the hearing piece that you had. Seems like the most response for this. So the justification for the, I think the EPA being part, sometimes EPAs move slower than the state sees the importance of what they need, and basically sometimes don't line up. So I do have a concern of considering the timelines for statewide implementation and phase-in approach recommended by the EPA. What is there, and that will be our next report, because I think it's important for marine fisheries as stakeholders. I think it's important. Fish and Wildlife Commission, Visitors Bureau, because we're in this recreational piece, commerce, all of these being major stockholders know what is needed and what's not. And then they have their own science and their people too. So certainly they're the main stakeholders as far as I can see here, and they may line up a little differently than the EPA in their timetable. So I would just ask to consider that moving forward expeditiously.
Any other questions, or we move on?
And before I move on, one thing I do want to make clear is that for the Class B waters, these are strictly fresh waters. So the salt waters we're already kind of up to date with our saltwater recreational criteria. So this would really just apply to the freshwater, primary rec water. So just to, everybody has that information. So next up, we move on to some of the more kind of technical side of things, corrections regarding Eastern Band of Cherokee Indians. We proposed to modify the language in OGB 0301 to recognize that the Eastern Band of Cherokee Indians now have jurisdiction over the waters within their boundaries. And this basically came about when they received treatment status of the state treatment that they received in 2015 by EPA. So they now have their own water quality standards program, their own classifications, and we're just kind of slightly modifying this language to kind of acknowledge that. And the final recommendation is to adopt as proposed. We had a couple of definitions. So the final recommendation for the definitions is to add 3 new definitions to the O2B 0202 definitions rule, and also provide the clarifying language that was originally proposed for the existing industrial discharge definition. And the 3 new definitions include definitions for lentic and lotic, which were part of the selenium standard. And these really kind of define flows of different systems, different waterways. So lentic means an aquatic ecosystem that has standing or flowing water, such as a lake, pond, or reservoir. And lotic means an aquatic ecosystem that has rapidly flowing water, such as a stream or river. And then again, we have the new definition for available cyanide, which I read earlier, but I could go through it again, I guess. This refers to inorganic cyanides that are free, such as the hydrogen cyanide and cyanide ion, as well as the metal cyanide complexes that are dissociated to free cyanide ions under mildly acidic conditions, which are in pHs 3 through 6. And we also have a number of technical corrections proposed to be made, and these are all these aren't like substantial changes. These are basically correcting errors that were made, leaving out some language or errors in the effective dates of some of the rules and things that were just kind of noticed as we were going through the rule package. So the recommendation would be to approve all of these technical changes. And then I just wanted to mention, because we had some changes from what was originally proposed, we had the error with the acute cadmium standard, and we had the change from the total or free cyanide standard to total or available cyanide. We did do an updated evaluation of the costs associated with those changes. For the acute cadmium standard, no effect was basically identified. And again, that's because it's really, the cadmium is really driven by the chronic standard and not really by those acute standards. And for the total, for the cyanide change, there was no change to the benefit that's expected to be received by regulated parties. And basically regulated by switching from total to available, regulated parties were getting, in a sense, some relief because of that switch. So there hasn't been any change to that benefit based on this switch. Although there may be some additional laboratory costs to replace some equipment in the DWR central lab. And our lab is actually looking for quotes and estimates at the time. They're having a hard time finding some quotes, but they should have them soon. And then lastly, just kind of as a reminder, as part of our public notice, we did ask for additional public comments on topics that we weren't addressing in this triennial review. So we did receive comments on these topics. There's a few EPA criteria that we haven't looked at for adoption yet. That includes the EPA aluminum criteria, which was published in 2018, their ammonia criteria published in 2013, and their cyanotoxin recreation criteria published in 2016. PFAS, obviously, we received quite a few comments on PFAS, methyl mercury, desire for us to have a flow standard, nutrient criteria, as well as pesticides. Oops. And that brings us to our request for today. And Commissioner House, do you want me to make the request? Or okay. So the request is for approval of the hearing officer's report of proceedings and adoption of the 2020 through 2022 surface water triennial review amendments to select rules in sections 0200 and 0300.
And I'd like to recognize Commissioner Harris as the hearing officer to make her recommendation.
So is it appropriate for a motion at this time?
Yes.
Okay. Thank you, Madam Chair. I move the EMC approve the hearing officer's report of proceedings and adoption of the 2020-2022 surface water triennial review amendments to select rules in 15A, NCAC 02B 0200 and 0300. In addition, the EMC directs the department to present its work plan to evaluate implementation of a statewide E. coli standard for Class B waters to the EMC at its upcoming May meeting.
Is there a second to the motion?
Second.
Commissioner Deerhake seconds. Is there discussion on the motion? Commissioner Solomon?
I hate to do this once a motion's been made, but I do have questions of staff, and I'll ask you, Commissioner Harris, so I don't try to violate the Robert's Rules of Order here. But did we put a note on the fiscal regulatory impact on the things that Mr. Ventilaro mentioned in the package? Again, my concern there is if the regulatory impact analysis is not seen complete or it's misunderstood, you will get our 10 letters of objections to the RRC for not following the APA potentially, and I don't want it to come back. So have we amended that, or how are we going to handle that in the regulatory impact analysis?
Well, and we may have to pull that piece out and let it track differently if that's what you're asking me about, the E. coli.
No. I'm sorry, the cost for the total and the free.
Okay.
Don't pull cyanide.
So
The cyanide. He had a slide up there about two things that changed on the, and I didn't see them indicated in the regulatory impact analysis that was approved. And so as we send this up, if people have a different opinion that these costs aren't right or a problem with the regulatory impact analysis, RRC will send it back on those 10 letters. So I'm just trying to make sure how we are going to handle that in this process. And then the second one I was asking Chris on the Jordan Lake stuff, if there's clarification there, because that will get it sent back to us very fast if we're violating the Jordan Lake rules. So those two things I've just asked you as hearing officer.
Yeah. And I don't have an answer for you. I don't believe they, to be honest. So I'll have to defer, but I don't think we changed the fiscal analysis on that.
yeah, so I think basically what it came down to with the way we understand it is that with OSBM doesn't require an amendment to the RIA if the changes that were made were not substantial changes. And I believe we didn't view these as being substantial changes. So amendments weren't made to the RIA.
Just make sure nobody else thinks there. Just because you don't think there are, there may be other people. I guess he gave a slide saying that they had looked into it, which is great. which is great, but I just want to make sure everybody's in agreement with that. And then the first question I asked to try to get that in play would be, I don't want it to come back if we're adopting rules that are accepted in the Jordan Lake or there's other consideration on Jordan Lake. So that's another question I've got before we approve and send to the RRC.
So to stay first with the issue of the total versus free cyanide change, total or free to total or available. In terms of fiscal analysis, since total is an option under both, is an alternative under both, it would, I think, be surprising that change would have any significant impact on cost. But I guess I'll put that question to Mr. Vintaloro is, if we're looking at a situation where we have an existing standard, part of which will continue to be in place regardless of the rule change, but there will be a new alternative available that's intended, as I understand it, to be less burdensome, although that may require some transition. I guess in my mind, that seems unlikely to require additional fiscal analysis, but I don't know if there's any specific guidance on that.
That I will have to check. Thoughts?
As long as it's not compromised, again, I don't interject. I'm just concerned, again, anytime we do this and we make those last minute changes, I don't want there to be objections from somebody that would put us in jeopardy to bring it back.
Does anybody else have any discussion on that point? And let's stay for a moment with the total or free cyanide change to total or available cyanide. Any other discussion on that particular change or whether it's viewed as substantial or not?
Karen Higgins, Division of Water Resources. My memory serves me from talking with the staff who put the regulatory impact analysis together, because like you said, it's an or, it's not a requirement to use the available or free. So it's an option, it's not a requirement. And I believe that's what made it not a substantial change.
Okay.
So as to the second issue, the late comment about potential conflict with the Jordan Lake rules, I don't know exactly how we can resolve that today. I think we always have the option. Clearly, the commission cannot have a rule in place that conflicts with legislation. If it turns out that that is the case, then obviously we will need to amend the rule to make the two consistent, but I don't know if that's a question that we can clearly answer today, and I'll defer to Ms. Higgins and Mr. Vintaloro.
So I apologize because I haven't seen the comment. Is the question whether the revision in 0218 creates a conflict with the Jordan rules?
Yes.
Okay. So there is language in the Jordan rules that provide an exception for things in Rule 218, sub-items 3E through 3H, and I believe the addition for 1,4-dioxane is in 3E, or I'm sorry, 3G. 3G, which is in between E and H. So that exception should still be there. I believe that when the rules were readopted in 2018, some of the paragraph number of numbers changed slightly, but that would have to be done as either a technical correction or as part of the Jordan rule readoption that was delayed per the legislature, but should be forthcoming to the EMC in the future. So I don't know if that.
It does, and it says that, but I don't know what's in 3E through H, like you say, and how 1,4-dioxane goes to that. And again, I'm not trying to stir it up as much as this is a late question, and I just want to catch it if y'all had not thought about it before we approve something to move on.
Yeah, so if I'm looking at the hearing officer's report that is online, and like I said, for 218, it's within sub-item 3E. 3G, which falls in between E and H.
Okay, that's fine.
Too much for my brain after lunch.
Yeah, mine too. I don't even, I'm late to the dance on this one, so I'm just asking. So thank you.
So it appears that there's likely not a conflict if there's an exception in the Jordan Lake rules for that particular provision. So back to Commissioner Harris, who has made a motion. We did have a second by Commissioner Deerhake. Is there any other discussion on the motion? All in favor, please raise your hands. All opposed? Thank you very much.
Thank you very much.
The next action item is the recommendation on the petition for rulemaking related to the chronic aquatic standard for silver. Let me just say, I'm going to first let Mr. Reynolds sort of introduce this item, and then Commissioner Deerhake and the parties are available. I will just say, for those who are here for the civil penalty remissions committees, we have a complicated agenda today. Realistically, I would estimate the remainder of this agenda is probably going to take at least 30 to 45 minutes. That's aspirational, so I hope we can get it done that time. But just to let you know, you've got some flexibility if you're waiting for that. Unfortunately, we still have a couple of significant items, not as long as some of the earlier ones, but still significant items to get through. So, Mr. Reynolds. I guess, yeah.
Thank you, Madam Chair. There are a lot of petitions today for the commission, a lot of petitions. Unlike the petition for declaratory ruling that you did earlier, and I know this will make Commissioner Carter smile as he had to turn me around on it, a petition for rulemaking is not quasi-judicial. This is part of your quasi-legislative authority to determine whether you would like to grant a petition for rulemaking. Now, granting a petition for rulemaking does not mean that you are in fact adopting or taking action to adopt the rule, only that you're going to move forward with putting the rule out for public comment as you would with any other rules, just like all the rules you've done today. If at the end of that rulemaking process you decide not to adopt the rule, that is completely and entirely up to you, and that's not challengeable. If you deny the petition, then as with many other things, the petitioner does have a recourse to seek judicial review of the decision to deny the petition. This matter was received and referred to the Water Quality Committee as part of your process. As you all may remember, previously all petitions had to go through the committee structure first. Now it's optional, but the chair did exercise that option and refer the petition through the Water Quality Committee. But again, I just want to emphasize this is quasi-legislative. It's entirely policy-making decision, and the question before you is whether to grant or deny the petition. And again, granting only means that you'll move forward as part of your regular rulemaking process. If you have to have a fiscal note and regulatory impact analysis before you go out, you would have to generate that first. You're basically putting it into the hopper. This one involves a surface water standard, so even if planning, even if you chose to grant the petition and go out to rulemaking and then adopt it, you would still have to have the EPA approval in order for it to become effective. But generally speaking, again, it's just a question of whether you want to move forward with rulemaking or not. And I believe that the chair has, along with Commissioner Deerhake, has asked the staff to do a brief presentation just sort of to give an overview of the chronic silver standard. You've actually addressed this question a few times, and I'm sure you'll hear that as well. You addressed it in 2016 and 2019 as well. And then after that, I believe the Madam Chair, Commissioner Deerhake, as Chair of the Water Quality Committee, is prepared to move forward with the report out of the committee.
So the DEQ presentation will be
Yes.
by.
Oh, I'm sorry. I didn't want to say that and take.
Oh, no, that's fine.
And I meant to mention as well, Madam Chair, if I may, that you've also invited Mr. Paul Calamita here to answer questions that the commission may have, but just wanted to point that out.
Yes, that's correct. And so after we hear from Mr. Ventilaro and Commissioner Deerhake's recommendation, we will have an opportunity if commissioners have questions for either DEQ or for Mr. Calamita. They're both available to answer questions. So thank you.
Okay. Well, good afternoon again. Again, my name is Chris Ventilaro, Water Quality Standards Coordinator, Division of Water Resources. And again, we were just asked to provide a brief history and basis for the Class C freshwater aquatic life standard for silver. Just wanted to start off with a little bit of history for the chronic silver standard. This standard was adopted kind of way back in 1989. EMC adopted the current chronic silver standard, but they adopted it to address some discharge of silver from a number of industries. I think at the time, a mirror manufacturer was one of the main industries. I think there were also some film processing and production facilities that were also under consideration. But the commission at the time adopted this chronic silver standard to be implemented as an action level for NPDES permit limits. Basically, what that meant was that where facilities showed a reasonable potential to be above that standard, they would have to conduct whole effluent toxicity testing. And if they passed that whole effluent toxicity testing, then they wouldn't have to take any further actions. However, if they were failing their whole effluent toxicity testing, they would have to do further investigation into the cause of that failure. And if it turned out to be silver, they may have been provided a permit limit based on the chronic silver. Now, in 2016, as part of that surface water training review, EPA disapproved of the further use of action levels. And my understanding of it at the time was that because we had adopted a number of updated metal standards, that they didn't feel that the use of action levels was further appropriate. So as a result of that, in the 2019 triennial review, the commission moved to remove that action level language from the O2B 0211 rules. They did hear some public comments requesting the removal of that standard at the time, but at the time they did choose to retain the chronic silver standard at 0.06 micrograms per liter. And just a little bit on the regulatory and scientific basis of the standard. The chronic silver standard basically is a numeric standard that's based on the narrative standard for toxic substances, as described in the 15A NCAC O2B 0208 rules. And the standard uses the final acute value from EPA's 1980 ambient water quality criteria for silver. And it basically just applies that as directed per the rule, which in this case was to take that FAV in place of the lowest LC50 and multiply it by a safety factor as described in the rule. So you can just kind of see how that calculation works out here. The FAV from that EPA 1980 document was 1.2 micrograms per liter. The safety factor was 0.05 per O2B 0208, and that resulted in the 0.06 microgram per liter chronic silver standard. And this was really done because silver is demonstrated by toxicity testing to be toxic to aquatic life. With 8 of the 10 species that were evaluated by EPA in their acute silver criteria document are found in North Carolina surface waters. So water fleas are very common. They were the most sensitive. Fathead minnows are very common. They were the second most sensitive, but also other more sensitive species were bluegills and a few others. Now these aquatic life standards are designed to protect from various toxicity effects. So we have chronic standards for aquatic toxicity to protect organisms from long-term exposures that might result in impacts to growth, behavior, and reproduction. And then we also have acute standards to protect organisms from more short-term exposures that might result directly in mortality. Oh, and I guess that's it for this one. Yeah, so the last thing I just wanted to mention was something that council had already said is that, if the next steps would basically be if the commission grants the petition, then we would move forward as a department with the rulemaking side to strike that language from the rule. And that's all I have.
Thank you. Are there questions for Mr. Ventilaro? Commissioner Carter?
Looking at your slide here, you talk about the demonstrated toxicity up at the top, and then you mentioned chronic and acute. Is the toxicity that was, toxicity testing, was that for acute or chronic effects?
So most of the toxicity testing done for that EPA criteria document was based on acute toxicity testing.
That's right.
That's not atypical. In this particular case, EPA didn't feel that they had enough data at the time to establish a chronic silver standard. So they just established the acute silver standard and really left it to states to determine if they needed a chronic silver standard and how to go about applying that. And the way that's kind of handled, if we have acute data, if we don't have direct chronic toxicity information to establish a chronic standard, then we take acute data and we apply a safety factor to accommodate for the potential there for chronic toxicity.
So that's where the lowest LC50 comes from, is
That's
just
where
the acute data?
Exactly. And what we're really using here isn't a lowest LC50. We're using the final acute value from EPA, which is basically determined from a group of acute toxicity exposure information. So a whole bunch of LC50s from different organisms, different trophic levels, et cetera, different taxonomic groups is used to determine that FAV. So this FAV is actually really inclusive of a lot of different organisms, as opposed to just being like one single LC50 from one test.
And the safety factor, you've got it referenced here as, what was the regulatory reference? Is that in our rules?
That's in the rule, yeah. So basically O2B 0208, right at the bottom, I think it's item 1, I believe, for aquatic toxicity. Basically, we default to a safety factor of 0.01. However, if a substance is kind of like not a persistent substance, then we'll use a safety factor of 0.05. So a persistent substance would get a more kind of stringent number based on that potential for it to stick around for a long time.
Do you know, just out of curiosity on this, like where those safety factors came from?
They were established back, I believe they first appeared in the rule in 1989, if I'm not mistaken. And I don't specifically know exactly where those specific numbers came from, but I think they're based on a lot of the toxicity information at the time. At the time, aquatic toxicity was really kind of up and coming branch of science, really. And I think there was a lot of influence from that. Other states, so a lot of states in North Carolina use EPA recommendations based on the Great Lakes water quality programs. They have similar, it's different, but similar. So it's kind of along the same lines. So we'd have to look into more detail to see exactly how they came up with those numbers.
Can I turn to Commissioner Harris, Commissioner Deerbake, for her recommendation from the committee?
Thank you. At the January meeting, the EMC's Water Quality Committee heard this petition for rulemaking to remove the freshwater silver chronic toxicity standard for aquatic life. And as mentioned, the EMC chair referred the petition to the Water Quality Committee for review and recommended action. So I come here today on behalf of the committee. The standard of interest, as mentioned, is O2B 0211C. It includes chronic toxicity standards for 6 elements, for your information, 6 elements that are not water hardness dependent. These standards include silver, and the other chronic toxicity standards include arsenic, beryllium, chromium-6, mercury, and selenium. After hearing the 2 presentations, the committee had comments and questions, and then a motion was made and seconded to recommend to the EMC that it deny the petition today. The reasons for the denial included, first, the contention that because there was no national standard, there shouldn't be a state standard. The absence of a national standard does not prevent a state from adopting a standard. Also, it was observed that EPA objected to the action level relief component of the standard in the 2016 triennial review. Then in 2019, as part of the triennial review, the EMC rejected the petitioner's request for any changes in the standard. And for this year's 2022 triennial review, the petitioner chose not to submit any comments from what we just heard and voted on immediately before this agenda item. Based on this history, the committee was discussed that doesn't seem to make sense to reconsider the standard independently. Another reason for denial in January in bringing that recommendation to you today was that considering termination of the silver chronic toxicity standard is a process that's too complicated and not well suited for a petition for rulemaking. The state of science on silver's chronic toxicity has not been reviewed by the Division of Water Resources in years, and that seems to be the next logical step. It was pointed out during committee discussion that one wastewater treatment system did find relief from the standard with a site-specific demonstration, and such demonstrations could be an interim measure while DWR and stakeholders work on an updated standard. And the final reason for recommending denial today was that Rule 02B 0208 requires protecting aquatic life from chronically toxicological substances. And we learned during the meeting that chronic toxicological effects from silver could irreversibly damage populations of organisms at the bottom of the food chain, which could have major adverse impacts up the food chain, including our state's rainbow and brown trout. After a substitute motion did not receive a second, the Water Quality Committee voted 5-1 on the original motion to recommend the EMC deny the petition for rulemaking and address concerns during the next triennial review planning period, which we anticipate will become effective in this coming year. We'll get started this year. Further, the Water Quality Committee wanted to recommend to the EMC today to instruct Division of Water Resources to begin a review of the state of science on silver's chronic toxicity and instruct DWR to continue discussions with EPA Region 4 about their rejection of the action level and seeking alternative approaches, and also to engage with stakeholders in the scientific review and policy options analysis from this point forward in the next triennial review cycle. The Water Quality Committee also believes that effective discharges could and should work with the MPDES branch in the interim on a site-specific basis to explore the potential for applying the water effects ratio to derive a site-specific standard, or seeking a variance through various routes that are available in the standard, in the regulations, or exploring other MPDES permit implementation options. So, Chair Smith, I'm prepared to make a motion when you're ready.
You may make your motion. Although I will say, before we get into extended debate among the commission members, I would ask Mr. Calamita to introduce himself and make himself available if there are questions for him or if there are additional questions for Mr. Ventilaro. So we can either do that piece first or have your motion first.
Point of order from me.
Yes.
Shouldn't we engage in questions outside the members before the motion's made?
That's probably a good plan. Yeah. So let's do that. Let's hold the motion. And then if there are questions for either Mr. Ventilaro or Mr. Calamita on behalf of the association, and just to repeat, you've got a good background on the chronic silver standard itself. Just to repeat it, everyone has a copy of the petition for rulemaking in their packet. The request on behalf of the petitioner is to repeal the chronic silver standard.
Yeah.
So are there questions for either Mr. Ventilaro or Mr. Calamita? Yes, Commissioner Bailey.
I just wanted to know why there weren't any comments during the triennial review on this standard.
Madam Chair, members of the commission, my name is Paul Calamita. My privilege to be here today on behalf of the North Carolina Water Quality Association. Commissioner, to answer your question, we have banged our head against the wall so many times. I can show you dozens and dozens, no exaggeration, of comments. You all, the slides show you've rejected it in 2019. At some point, we got tired of banging our head and we looked for other opportunities to try to raise this issue with our regulatory partners. We work for you. We implement your water quality standards for non-domestics for every business and industry in this state. And we do that for all the pollutants, and we've done that faithfully. And we are about to faithfully do that for chronic silver. But it is the first time we can't in good conscience do it, but we will do it if we're not successful today. And there will be consequences to innocent businesses and industries here in North Carolina that are not imposed anywhere else across the country, to my knowledge. And also, most of these treatment plants, if not the vast majority, will no longer be able to accept new or expanded discharges who have any silver contribution, including several that have been in the newspapers across the state.
Are there other questions?
I do.
Commissioner,
Else?
Commissioner Solomon?
Yeah, and if you will give me a little bit of leisure, that's just, I'm not on the committee, so this is the first time I've got to ask questions, but I've got 3 for each, and I'm gonna try to be fair to both, okay? So for Mr. Vinalaro, wherever he is. So I look back and I've got copies of it, but this is the document summary of water quality standards from 2007 to 2014. And it looks like the same document you used to put your slides together because it's got all this stuff that you talked about outlined in it. But one of the things I found interesting was back in the day when this was adopted in this report in 2014, all the reference data is to the 1980s, which is all 40 years old. And one of the conclusions here is the department really was on the border about it, but they thought that, quote unquote, the opinion of DWR that EPA could think that the was not warranted. It didn't say they would, it just said they could. And so speculation in this letter says we're going to be very, very conservative in our approach and stick with our guns. And that was in 2014 or 15. I'm leading to the question, Madam Chairman. I know you're going to get on me for not being brief, but I know there's been at least one petition for rulemaking for this. I think out of Greensboro that was denied. I think water quality came back about a year or so ago, the same group, Mr. Calamita, and it was denied. And now there's a third one here. So when I look at all this, my question to him and to you, my question to him and you is, why was this not by the department's thing in this current triennial review? Why did we just approve something with no silver? Because it's not one-sided. You guys could have done it too.
Yeah.
Why didn't you do it?
I think the answer to that was really the kind of pressing priorities that we're faced with right now. Looking at 1,4-dioxane was a big concern for the department. Addressing the coli was a concern for the department. And then we also had other requests for dealing with cyanide and cadmium. So I think based on just kind of staff resources and time, there's only so much we can kind of do at any one given time. And that was kind of the focus, kind of as directed by the department, was that we focus on these things.
So the department just didn't think it was enough of a priority at the time, and that's okay. I'm not fishing.
I can't put words in the department's mouth, but I mean, there were other pressing things that were going on. That's why this wasn't.
And I'll ask, I think he was just asked this question, but let me ask your other two. So the other way I understand this, and I'm in the business, so there is no way that the PQLs are above what we can detect for chronic silver. And so anytime we get a chronic silver calculation, we have to go to a formula that is not site specific, and it's based on the number of non-detects that is both in the influent coming into the plant, but also the effluent, which the effluent should be non-detect anyway. But if 50% get there, then we go to this formula, and that's tripping up the chronic silver calculation. It's not a measure because we can't measure it. It's a calculation, right? Am I right?
I would have to defer to our NPDS staff.
Okay, well, maybe they can clarify, but the point being is, so I see where the pretreatment association says 2 dozen, and then I've got information myself on 3 dozen utilities around the state that are over allocated. So I guess I ask you, are you aware that there's as many as 2 or 3 dozen major utilities that are over allocated?
Again, I would have to defer to our NPDS staff.
Okay.
Hi, I'm Julie Grigg. I'm Deputy Director for the Division of Water Resources. I'm going to see if I can help you out a little bit with some of this. So So, you know, both the chronic and acute standards are below detection level, not just one. And when you say something is over allocated, any POTW that exceeds their permit limit is probably over allocated to metal. And they have to go back to their significant industrial users, redo the headworks analysis
Right.
when they get a limit, and they have to make sure that industrial users lowers it so that they comply with the effluent standard or the limit in their permit. So in that case, if you're saying they're over allocated, it means that they have someone or some addition coming somewhere of silver that is causing.
Right, right. And my question to Mr. Vinalaro was specifically, we had a letter come in from the Pretreatment Association. And then the data I have unofficially says 2 to 3 dozen wastewater utilities who treat our wastewater are over allocated. They said that in their letter. Does that surprise you? That's the question. Does that surprise you?
So the real issue right now with silver to make that determination is that most people were only using less than 5 as a detection level. And we are trying to get all the POTWs on board to use the better test, to use a method of analysis that gets it down to less than 1, so we know they're less than 1. So
Can I follow on with that? Because I understand there's only one lab certified to get down to that, and that lab is in Wilmington to get down to a chronic silver or total. So I don't know which one it is, but the labs don't have PQ. They're not certified to go to that PQL.
they're certified to do the proper test method.
Yeah.
And just by doing that test method, a lot of them can get it down to that PQ. We're finding the labs are doing it. We used to, 2 years ago, it was hard. We're seeing most of the labs start to do it now.
So let's stay with me this a second, and this will be my last question. So if there's 2 to 3 dozen over allocated, they're supposed to tell their industries to shut down or to go back, all the industrial commercial people, to reduce silver. So they don't have any other options on silver. And I'll ask this to Mr. Calamito. There may be options, but they may be costly options or whatever it happens to be. But you've got 2 or 3 dozen. How do you know they're over allocated? And is that an NOV?
So one, I'm not sure. We have not issued limits to two or 3 dozen municipalities at this point. And I think the main reason is because we're finding it was less than 5 and not less than 1. And we told them to go back and do more sampling. So that's really where, and the practicality, that's where we stand at this point, trying to get people down to lower detection levels. So what do they have to do? But they do need to go back and make sure that they're not over allocating silver to their industry. And so it may result in someone have to install treatment or some action. Yes, that is correct.
Okay, now let me just ask, last question will be, I know you're behind in MPDS permits, and I hate to ask this question, but if you know there were people over allocated and still giving that allocation away, would you enforce that? Would DEQ enforce that? And I hate to ask that question, but in today's world, we seem to have government selectively enforcing things. So would you enforce it if you knew it was there?
Yes, we enforce our standards. Now we give people time to come to compliance with them.
Okay.
Okay. So there might have to be some time to allow that to happen.
Okay. Madam Chair, if I can I ask the same questions to Mr. Calamito?
Let me just
I'm a member.
one suggestion, which is to keep our focus on the petition request. So the decision we have to make is whether to grant the petitioner's request to send out to public notice and hearing a rule that would repeal the chronic silver standard. So we're at the beginning of that process. But one thing to keep in mind is that there are criteria about which we have to adopt, amend, repeal standards under the Clean Water Act.
Yeah, I know.
And those standards have to do with whether and what standard is necessary to protect the existing uses of the water. So just with that caveat, the issue on the table today is whether to go out to public notice with a proposed rule to delete or repeal the chronic silver standard. Now, of course, the decision to do that doesn't commit the commission ultimately to adopt that rule, but that is the issue. And the set of criteria we need to keep in mind as we think our way through this are the criteria for adopting, amending, and repealing Clean Water Act
I understand. I'm going there. I want to ask these questions. I've not had a chance to be in a committee to debate this, so I would like to ask Mr. Calamito questions, if I may, as a member.
That's fine.
Mr. Calamito, if I may, I think you've addressed why not in the triennial review. Do you want to say anything else about that, or is what we've said clear? You've said you banged your head. You've been trying for years and you haven't succeeded. Is that a fair assumption?
In answering your questions, the one detection level is not an issue. We're using one or elsewhere in the country without a problem. The labs do it fine. It will simply reinforce the consequences that I see. When we go down to one, we will find more, not less silver, because we're going to a lower level. And this standard will become even more acute for the POTWs. And really what this comes down to is whether or not you believe the consequences that I'm suggesting to you that are going to follow a decision by the board not to reevaluate this standard promptly, because there aren't interim measures. The water effects ratio is at least a year process because of the seasonal testing, and it costs $50,000 to $80,000 or so $1,000, and it requires resources from the DWR that, quite frankly, we haven't seen. So we are very concerned that there isn't an interim hedge that allow us to maintain the status quo, continue to serve the business as we have. If you vote this down, we are not going to stand alone. We need the department and you, this is your standard, to stand shoulder to shoulder with us if we are not going to drop the consequences. And you haven't seen the consequences because the department has been sitting on renewing the affected permits. But once those permits are renewed, the waste load allocation has to be reevaluated without the action level. And what we've been trying to explain to the department for years, that consequence will come.
So directly, then let's go to the 2 to 3 dozen, because I'm looking for the urgency. I'm looking for the urgency. Is that fair?
40 were served. We surveyed POTWs across the state. 40 responded, and 2 to 3 dozen out of the 40, including most, if not all, of the larger systems, are significantly over allocated, with the exception of Raleigh, that because this was such an issue, went through that year process to get a site-specific standard that alleviated it for Raleigh for the time being.
Thank you.
Did you have any other questions?
The only one I would ask you is not only you're an executive director of the association, but you're also a subject matter expert as an environmental attorney. But what would theoretically, hypothetically, I'm not going to pin you to your members, but what would you advise people in other states if they're up at their threshold? Do they continue doing business as usual, or do they have to stop giving away commercial growth or allocation? What do you advise?
I've done this for 30 years. I have 10 of these state associations. All I do is municipal practice. There is no other state in the country that has this problem for silver or any other metal. Nobody else is in the threshold of losing control of their program, and we're your partner. Not trying to get away with anything. My advice to you would be grant the petition and ask the department to give us a writing, because we're your partners. We're not going out the limb on our own, but some writing that helps us maintain the status quo, why there's a reevaluation. And if the reevaluation determines that the standard stays, and let me just say one thing. All the state did was take EPA's acute value. 42 years ago, EPA developed that acute value and said, we don't have enough data to do a chronic. And what the state did was they took the acute value and did exactly what EPA has declined to do for 42 years and 45 of the 50 states, and multiplied it by a safety factor and said, ta-da, right out of the air, we have a chronic acute value. And as I emailed to you, that violates federal law. Federal law says use the criteria guidance, use the criteria guides modified with some site-specific state sampling, which we don't have, or another scientifically defensible manner. Those are the only 3 ways you can justify a water quality standard, and the department hasn't done either. If there was science behind this standard, our organization is not about a race to the bottom. Our organization is about faithfully implementing the requirements that you adopt, and we will do so on chronic silver, but it really is inappropriate. Thank you for your time.
Let me address one point Mr. Calamita raised and was raised in his email, which was asking the commission to direct the department effectively to not enforce the chronic silver standard in the interim. I don't know of any legal basis for the commission to do that. Enforcement authority for these programs lies with the department rather than the commission. The commission's job is to establish the standards. The department's responsibility is to enforce those standards. Obviously, if the standard changes, so will the enforcement program. But I don't know of any basis by which this commission could or would direct the department not to enforce a standard that's still in place and is being reconsidered but has not been removed. I'll ask Commission Counsel if he has any other thoughts about that, but that would be my caution.
And what will be good news to everybody, I don't have any other thoughts.
Are there other questions, Commissioner Carter?
Yeah, let me, first, I get Mr. Calamita back up for, I think I already know the answer, but I thought I'd reinforce this a little bit. Going back to what Commissioner Solomon raised about the overallocated facilities. So as you said, once they get a new permit, they're going to have a problem. They're going to have to deal with the existing situation. And that, I presume, correspondingly means that they're not going to be able to add anything. No new industry is going to be coming in. And I'm thinking specifically, for example, the big announcement we've had in the last few weeks of the SST facility over in the Triad area. Something like that is probably going to be dead in the water if you run into this silver issue in one of these overallocated systems, correct?
The 30% of your industry in North Carolina is metal finishing. And so number one, all of those folks should get reduced loadings. That's number one. Number two, if they need an expansion, they can't have it. And any new sources, I'm not going to name any names, but any new sources that may have silver in their effluent should not be allowed to these facilities that are over allocated, the 2 or 3 dozen of the 40 that responded. We think this is a real impact. I've never been before you folks before. Our association is more than a decade old. We're your partners.
I guess the other thing I would like to respond to, I agree with you, by the way, that we don't have the authority to tell the department not to enforce. However, I do believe it would be appropriate if this commission decides to grant the petition to at least give the department our best judgment that there is a need for some sort of interim relief. If they can figure out a way working with the association to do that. That doesn't mean not necessarily non-enforcement, but it's certainly there are ways to deal with these kinds of situations, I think. And we could certainly, I believe, send a strong message of that sort.
Mr. Bailey, did you have a question?
It's a comment, but it might really not be applicable. I mean, it might not be something that would work for this situation, but it was my recollection when you appeal certain conditions of a permit, that those conditions, as long as the appeal is standing, aren't enforced. And so if there's permits that are issued and the permittee decides to appeal the silver standard, that would hold back enforcement. But that's a recollection I have.
I believe that is normally correct, that if there's an appeal of a permit condition that may, I'm not sure that it automatically, but it may lead to a stay of the new permit conditions. So that, I think that is a possibility. Are there other questions before we come back to Commissioner Deerhake?
I have one question, Madam Chair.
Yes, Commissioner Keene.
I guess 2 from Mr. Calamito. You've been trying a long time, it sounds like. First of all, were you at the committee meeting yesterday?
I was not.
Did you make this presentation to the committee meeting?
In January, I did, Commissioner.
Okay, was that an information item only, Madam Chair?
As Council Reynolds explained at the beginning, with declaratory rulings, the chair has the option of referring the matter first to a committee. And so I referred this petition for rulemaking to the Water Quality Committee. And so they heard it in committee in January, and Mr. Calamita made a full presentation, as did DEQ at that time. And that led to the recommendation that's now coming from the Water Quality Committee to the full EMC.
And the way I understand it, that was under a vote.
That's correct.
And that was the 5-1, correct? Okay. Second question is the membership. You know, you represent several states. So I was just trying to get an idea of what the membership is in North Carolina and those people who would support moving forward with this.
The North Carolina Water Quality Association comprises the 35 largest wastewater systems in the state, and another 15 or so smaller systems, as well as all the leading environmental consulting engineers that practice in North Carolina.
Thank you. Thank you, Madam Chair.
No other questions? Commissioner Deerhake?
Yes, I will just repeat. I believe what I'm saying is similar to what Commissioner Carter had mentioned in my report. We did ask that we believe as a committee that the effective dischargers should work with the MPDS in the interim on a site-specific basis to explore potential ways to remedy this while the standard is being reviewed once again. I would also, I also heard that it's at the point of permit renewal that this is negotiated. Is that correct, Mr. Calamita? It's not immediate, but it's at the point of permit renewal.
We are in the awkward position of all of those over-allocated systems know they're over-allocated, and we're not supposed to be over-allocated. That's number one. Number two, it becomes an issue that can't be, continue to be evaluated upon permit renewal, and that's why there are so many permits that haven't been renewed.
Okay. And then last of all, I would remind us that the petition is to remove the standard. There wasn't a petition to make the standard more lenient or more feasible for the facilities, and that we as a commission are obligated to comply with the water quality goals of this state and of the nation, and that was reflected in 0208, which requires protecting aquatic life from chronically toxic substances. And the committee as a body comes to you with a recommendation based on these facts that we move to deny the petition. I really do think that there are interim measures that can be taken to try and begin to address this, and we have made the message quite clear to staff and leadership at the department that this scientific assessment needs to proceed quickly so that we can try and remedy this as soon as we can. That doesn't mean that it will demonstrate that we can eliminate the standard and just conflict with what we're charged to do, but it might find some relief for the facilities. Thank you.
That was made in the form of a motion. Is there a second to the motion?
I'd like to make an alternative motion if this one fails.
We haven't asked Mr. Septic.
That's what I just asked. Well, that's true. But is there a second to the motion? Commissioner Harris seconds the motion. So the motion on the table is to deny the petition for rulemaking, but with the additional provisions noted by Chair Deerhake, to direct the department to undertake a review of the standard as part of the next triennial review process. In the meantime, work with dischargers on site-specific solutions where problems arise. So is there discussion on the motion? Commissioner Monist.
Yeah, just quickly, I agree. If the petition had been to revise the standard, I would have been inclined to grant it, but I think rejecting it doesn't feel right. It does seem like improvement needs to be made and would urge us to move forward on that.
Mr. Solomon.
So my alternative motion is to seek to find some middle ground here. and I'm not really ready to give up a chronic silver standard without exploration. I understand why that is the rule, but I want to figure out a way to amend our motion here or to have two motions, and council, I may look at you, but if we vote down this motion, I want to make a motion because our rulemaking is our biggest stick to bring the parties together and move them forward. But to go to an alternative motion, that would be to evaluate the need for the chronic silver standard, to explore the actual levels of which that chronic silver standard should be leveled at, and then to look into the process for how that is being calculated. So it would be an alternate motion of that line to explore whether we need it, how do we establish the correct one, and then how do we come up with the final number? And so that's what my alternative motion would be. Should we reject, and how do you do that, Counselor? I would love to hear that.
Let me just say first that it strikes me that much of what you just recommended is included in Commissioner Deerhake's motion. And I think the only difference may be, and I think this may be something for the commissioners to discuss, is whether, as I understand it, Commissioner Deerhake and the committee recommended that this be folded into the next triennial review with direction to the staff to do exactly the things you just described. So the only difference I see between your potential alternative motion and Commissioner Deerhake's motion is whether this, as part of the motion, is folded into the next triennial review process or proceeds sort of separately on its own track.
That would be correct, because I think we've asked the questions to say the parties aren't together. And so I would say this isn't, and I do respect what the committee's done, but I've learned a lot in the last couple of weeks with the information brought forward that so many are affected. So I think we need to put a sense of urgency. And so to take this to rulemaking, even though it may be somewhere a little ahead of the triennial review, I think it's warranted. And I think that's the message that we can give to the department and to the association to get together and get this hammered out.
So I think, I'm sorry. So Council Reynolds, did you have a comment to make on process or otherwise?
Sure. Thank you, Madam Chair. So the motion on the floor is as provided by Commissioner Deerhake. If the commission were to grant the motion, notwithstanding the recommendation to deny it, the commission grants the motion, it has to go out in the manner proposed by the petitioner. It doesn't also mean that some other things could go on outside with it separately, but I see the two motions being in conflict, and so. Well,
let's clarify what we're talking about here, I guess. Yeah. So
I'm not sure if Commissioner Solomon is actually offering the motion now or suggesting that he will after this.
That's part of what we need to clarify.
Okay, I'll offer the motion to go to rulemaking to evaluate the need for a chronic silver standard, to evaluate the level of the chronic silver standard, and to explore how that methodology is calculated. And that would be my alternative motion. So it would be a separate rulemaking process.
So the one thing that your proposed, we'll treat it as a substitute motion, your proposed substitute motion omits is what the actual ruling on the petition for rulemaking would be. And so right now we have a petition for rulemaking that's requesting us to send out to public notice a draft rule to repeal the chronic silver standard. So I think we need to clarify in your motion whether you intend to deny the petition, but initiate a process moving toward rulemaking on perhaps on a more expedited basis than through the triennial review.
For the safety of the vote, I'd rather it be one motion to deny the request and to do what I just said as a substitute motion. But if it has to be two motions, we will vote down the request first and then make a independent, because this body can do rulemaking at any time. So we can go to rulemaking on this matter separately.
I think all you need to do is simply add and deny the petition, the rulemaking to your motion, and that gets you where you want to go, JD.
Okay. Is that what you're asking?
That's what I was asking, yeah.
Yes, I will amend it, yes, and add and deny this. She made the primary motion.
So we have a motion on the table. We have a second. We have a proposed substitute motion, which would differ only in that it does not specifically tie any rulemaking to the triennial review. Is that a correct understanding?
Correct.
So before we get to discussion, again, a reminder on substitute motions, we have to vote first on whether to substitute this motion for the motion on the floor, and then come back and debate and vote on the merits of the motion. So do we have a second to the substitute?
Yes, I second it.
Commissioner Carter seconds the substitute motion. So the question on the floor at the moment is whether to substitute Commissioner Solomon's motion for Commissioner Deerhake's motion. Is there discussion on the motion?
Yes.
Thank you. I really don't see the difference between my motion and the motion that was made. I mean, it's the timeline, it's what you're talking about, basically. And my motion did not say deny the petition and wait till the next triennial review. I discussed that it could fall in the next triennial review as part of the process, but the motion does not say wait until the next triennial review. And the fact that we recommend the EMC instruct staff to begin as soon as possible on this scientific review, I think it's consistent with what you're saying. What I'm concerned about is I also want to understand from council, if the primary motion were defeated, is that automatically interpreted as an acceptance? It's not, is it, of the petition, as approval of the petition, granting the petition?
No.
It's not?
No.
Okay.
And so your motion would have been to
Deny
the petition with a certain set of language around that denial.
Right.
Commissioner Solomon has proposed a substitute motion that also would deny the petition with, he's put slightly different language. I agree. I don't think there are substantial differences here, but
The big one will be is I want the date certain. There's a lot of things that start with starting rulemaking. My motion says we start rulemaking now. That doesn't mean it has to go to public hearing for 15 months. There's a lot of things that can happen, but I'm making the motion that we start the rulemaking. And we do the same thing that Commissioner Deerhake may be thinking about, and I am too, but we are starting rulemaking.
and by starting rulemaking, I assume you mean a direction to the staff to begin working on review of that rule and coming back to the commission as soon as possible with information and recommendations to move toward amendment of the rule.
Yes, move for the public hearing.
Just point of
Commissioner Deerhake.
Yeah, just to clarify that, part of the rationale for not taking it on its separate path was the spirit of the triennial review and what EPA expects of a triennial review. They'd like to see it bundled, a number of standards bundled together and brought to them at once. And so that's why the committee, that's one of the reasons why the committee didn't recommend starting immediately on the standard, but rather beginning the scientific review. I don't see how you can begin a standard until you do the scientific review anyway.
And if I may, I don't disagree with you on that, but I will say it is the urgency of the matter. If there are 2 to 3 dozen utilities waiting on permits, I think we could wait to triennial review, and that would be my preferred way, to be honest with you. But the urgency of having this many stacked up and potentially in violation, I think that drives the urgency for me to have an independent rulemaking. So that's all. I don't disagree with you that we should bundle these things where we can, but this urgency has changed the game a little bit, I think. So that's.
So we have a substitute motion and a second. And again, the first vote will be whether to substitute Commissioner Solomon's motion for the motion on the table. Is there any further discussion on that particular vote? Commissioner Kelvington?
Yes, I think that we have such urgency with the permitting system, the over allocation now, that I think we should accept their petition, and then as a caveat of that, make sure that we do include silver in the next triennial review. So we remove the standard now, but and make sure that is included in the next review. And then that way we give there's, we won't have such an economic impact to our state. I called one pre-treatment coordinator yesterday, and they are, the larger utilities are going to have an easier time. Some of them are going to have an easier time than when I called was, but the small utilities are, they don't, if they get one industry in there, several industries, they're not going to be able to expand. They're not going to be able to have to expand. And she said she knows of one, they're having to push away businesses wanting to come into their communities because of the standard. So I think it's very urgent that we address this situation now.
So let me suggest, I think people are wanting to debate on the merits of the motion, and we're not quite there yet. So we need to vote first on whether to substitute Commissioner Solomon's motion. So are we prepared to vote on that? And then we'll have debate on the motion itself.
Madam Chair.
Commissioner King.
Just question on the second motion, and I was willing to second that. Mr. Chairman, Commissioner Carter did. But my, I guess, clarity is, is this the consensus of Commissioner Solomon that he's going to deny the petition if this vote fails, and then we go back to the first vote and it fails, then the petition is denied and we move on? Is that what I understand?
Yeah, may I am not willing to give up the chronic silver standard at this point. And the very strict definition, as Commissioner Deerhake said, we've been asked to go into rulemaking, which will maybe take 18 months to do that. That's just rulemaking. That's the request. But I'm not prepared to give up the chronic silver standard until we have explored it. But I am willing to strike that down and substitute it with starting the rulemaking to examine the alternatives to it, my paraphrase here, versus going to motion to say we're going to kill it. I don't want to kill it yet. I want to study it through rulemaking as we go through. So I hope that clarifies, Commissioner King.
Thank you, Commissioner Solomon.
Are you prepared to vote on whether to substitute? I'm sorry, Commissioner Arado?
I'm on the Water Quality Committee. So was there any discussion about how much time a scientific study would actually take? Do we have a sense of whether we're saving 18 months here or if we're looking at the same timeline?
We didn't ask for a timeline, but the conversations along the way have been clear that the workload on the staff is basically going to take a good deal of time, and we may be in the same position as the triennial review calendar anyway for development of the triennial package. I have suggested that it doesn't have to fall on the staff to do the work, that there are plenty of aquatic toxicologist consultants out there who can do a lit review in a timely fashion and then deliver that to the staff for their evaluation. So we may be talking about the same timeline just because of the workload on the staff if they don't seek outside assistance.
Any further discussion? Commissioner McAdams?
Yeah, Madam Chair, thank you. I wish to speak simply because I believe in discussion among us as we're approaching a decision as to how to vote. I favor Commissioner Solomon's substitute motion because I think that I think there's urgency to this issue, and I think the wording in his motion is stronger as to let's undertake this and let's get it done now. I think that it is the stronger motion. So I advocate
Are we
approval of it.
prepared to vote on whether to substitute Commissioner Solomon's motion? If so, all in favor, raise your hand. All opposed? So the motion carries. So now the motion on the table is Commissioner Solomon's motion, which is to deny the rulemaking petition, but to direct the staff to immediately begin doing the work necessary to re-examine the rule and initiate rulemaking based on that re-examination. Is that a fair statement? Is there discussion on the motion?
Well, and I assume that Mr. Solomon is also certainly agreeable to much of what Chair Deerhake said earlier about staff working with the association and its members in the interim to figure out some interim solutions while we finish up working on the chronic standard?
Yes, and I think going to rulemaking, trying to move to that will put a sense of urgency on everybody to work together to get that done, but it will take time.
Right, but no, I understand that. I'm talking about some interim relief before we get done with the rulemaking.
I'm not prepared to do that until we look at it in more detail. I think rulemaking is enough for now until we see more definitive problems.
Oh, I will say in partial response to your question, I think there was discussion in the Water Quality Committee, and there's been some discussion today of some of the methods that systems can use in the interim to obtain site-specific standards. And so the staff will retain all of the tools that they have to work with permittees, and we would certainly expect them to do that.
That's right.
Is there any other discussion on the motion? If not, all in favor, raise your hand. All opposed? The motion carries. And that is the conclusion of that agenda item. Thank you all very much. Mr. Calamita, thank you, the staff, for that presentation. The final action item on the agenda is request for adoption of rule text modifications to the 2L0202 groundwater standard rules that have been recommended in response to Rules Review Commission objections to those rules based on ambiguity. Ms. Shelton? They'll settle down.
Yeah, that's fine. I'm gonna walk around with it. Good afternoon, Chair Smith and members of the commission. I'm Bridget Shelton, the Groundwater Standards Coordinator with the Division of Water Resources. So I'm here today to request the adoption of rule text modifications that were made to the 15A Ncac 02L 0202 Groundwater Quality Standards Rule. These modifications were made in response to the Rules Review Commission's objection to the rule based on ambiguity and clarity issues. So a brief background on this item. The division reviewed the Groundwater Quality Standards rule text, as well as the current interim maximum allowable concentrations, or IMAX, and proposed amendments to the rule based on this review. These amendments included the adoption of groundwater standards for a number of substances, the majority of which had established IMAX, updates to the rule for clarification and organization, and rule text revisions to add an IMAC notification process and to clarify the triennial review process and procedure. So EMC heard and approved the hearing officer's report and the proposed amendments at their November 18th, 2021 meeting of last year, and the Rules Review Commission then reviewed these EMC approved amendments at their February 17th, 2022 meeting. I just want to mention that the RRC staff opinion is included as an attachment to this item, and yes, it's included as an attachment to this item. Wanted to go over that really quickly before we get into the rest of this presentation. So paragraph C of this 02L 0202 rule requires that when there is no groundwater standard for a substance and that substance is not naturally occurring, the substance is not permitted in groundwaters of the state in concentrations at or above the PQL, or the practical quantitation limit. So as a reminder, the PQL is the lowest concentration of a given material that can be reliably achieved among laboratories. It's an analytical value. It is not based on human health or toxicity values. Paragraph C of this rule also allows the director to modify the PQL requirement for these substances in groundwater through the use of an IMAC, or an interim maximum allowable concentration. This is a human health-based protective value. General Statute 150B-196 states that agencies may not waive or modify a requirement set in a rule unless the rule establishes specific guidelines the agency must follow in determining whether to waive or modify the requirement. So the PQL is a requirement in this rule that can be modified with the establishment and the use of an IMAC if the rule has specific guidelines that must be followed to modify this requirement. Again, the RRC staff opinion is provided as an attachment and lays out a bit more detail on this concept. So at the February meeting this year, RRC objected to the rule, finding that the rule was not clear and unambiguous. It was a close vote, I think 5-4. The RRC objection letter is also included as an attachment for this item. Specifically, as written in the objection letter, the RRC found that the rule was unclear and ambiguous as it lacked specific guidelines required by GS 150B-19.6 to waive or modify the PQL requirement through the use of an IMAC. So the division has made rule text modifications to satisfy the RRC's objection based on ambiguity and clarity issues. The rule text document that we've included as attachment A for this item has those recommended changes, as well as other technical changes that were made after discussions with RRC counsel prior to the RRC meeting. So the changes in that attachment, and that I'll cover now, anything highlighted in yellow is changes that the EMC has not seen. So I'm focusing specifically on paragraph C for these next few slides. This is the paragraph where the IMACs are first referred to and where the IMAC establishment process is laid out. So this paragraph is where most of the technical changes were made to try to provide more clarity in order to satisfy the RRC's objection. So as I mentioned here, everything highlighted in yellow is a new change that the EMC has not seen. In this paragraph shown here, this highlighted text is mainly adding clarifications such as references to other parts of the rule and other rules. We add language about modifying the requirement to make it very clear what the purpose of IMACs are. So any person may request the director of DWR to modify the PQL requirement by establishing an IMAC for a substance in accordance with the specific guidelines listed in some subparagraphs 1 through 9, which I'll go over in a little bit. In addition, any person may request the director of DWR to update or remove an existing IMAC in accordance with the specific guidelines listed in subparagraphs 1 through 9 of this paragraph, which I will cover now. So continuing with paragraph C and following this text right here, we start to list the specific guidelines that the division must follow in order to determine whether to modify the PQL requirement. So the specific guidelines are as followed. First, this is new language here for number 1, but it's not a new practice. We're just making it clear here that the division initially reviews the IMAC request to make sure that the data and information submitted is in accordance with paragraphs D and E of this rule, which lay out the calculations and references required to calculate a health-based standard. So making sure that the information that is submitted is complete and appropriate. Moving on to guideline 2, this language was already mostly approved by the EMC. It states that if the information submitted is not in accordance with paragraphs D and E, the director shall request additional information from the requester. If that appropriate additional information is not provided, the director shall return the request. And the struck out language at the bottom here, at the end here, about an annual update to the EMC does appear later. We've just struck it out right here to show that this has been moved, but it will appear later, which I'll cover. So continuing again with paragraph C and guideline 3, again, most of this language has already been seen and approved by the EMC. The director receives an IMAC request. The information submitted is reviewed, and if it is determined to be in accordance with paragraphs D and E of this rule, DWR will provide public notice and opportunity for comment at least 30 days before an IMAC is established, updated, or removed. The public notice will include the information listed here in A through D. We added language to B here to make sure it's clear that there are guidelines for the calculations for these IMACs, and the notice shall be emailed to interested parties and posted on the division's website. Next, 4 for the specific guidelines to establish an IMAC. So the first half of this paragraph here, again, is not a new practice. We just added this language in it here to be very clear on the basis of how the director establishes an IMAC. So this language was actually pulled from O2L 0103, which sets out the policy for the whole subchapter. So again, this was always our practice and how we operated. We're just putting the language here to make it clear what the basis is for the director to establish, update, or remove an IMAC. So if the director of DWR finds the establishment, update, or removal will not degrade the quality of the groundwaters, will not likely cause or contribute to pollution of the waters of the state, and will be protective of public health, then the director shall establish, update, or remove the IMAC. If the request does not meet the requirements listed in this subparagraph, the director of DWR shall return the request. The second half of this paragraph's language is adding a timeline to the IMAC establishment process in order to provide more specificity to the guidelines for an IMAC establishment. So the director shall establish, update, or remove the IMAC or return the request within 180 calendar days of receipt of a request submitted in accordance with paragraphs D and E of this rule, unless the requester agrees in writing to a longer period. Failure by the director to establish, update, or remove an IMAC or return the request within 180 days of receipt of a request submitted in accordance with paragraphs D and E of this rule shall be considered a return of the request. So moving on to 5, here we are keeping the public and the commission informed of these IMAC activities. So if the director of DWR establishes or updates an IMAC, the IMAC shall be posted on DWR's website, which was listed earlier, and the commission shall be notified in writing within 30 calendar days and at the next regularly scheduled commission meeting that a new IMAC has been established or an existing IMAC has been updated or removed. So moving on to number 6 for the guidelines to modify the PQL requirement with an IMAC establishment. So there were some concerns brought up by the RRC about it not being very clear in the rule how long the modification or the IMAC remains in place. So we wanted to add language and a timeline here to be clear that once these IMACs are established, the division will be moving them towards the commission or towards rulemaking. So A, within 12 months of establishing an IMAC pursuant to this paragraph, the director of DWR shall make a recommendation to the commission whether, 1, a new groundwater standard in place of the IMAC should be established pursuant to this rule, or 2, the IMAC should expire. After a recommendation is presented by the director under Part A of this subparagraph, the commission shall decide whether rulemaking shall be initiated to adopt a new groundwater standard in place of the IMAC. If the commission initiates rulemaking to adopt a new groundwater standard in place of the IMAC, then the IMAC shall remain in effect until it expires under subparagraph C7 of this paragraph for this rule. I just wanted to walk through an example real quick of this language. So the director of DWR receives an IMAC request for a particular substance. The guidelines listed earlier are followed and the IMAC is established. Then the division has 12 months to come to the commission with a recommendation on whether a groundwater standard is needed for this substance that has an IMAC, or if the IMAC modification should expire and the PQL would then become the requirement for this substance. After the recommendation is presented, the EMC will then decide whether rulemaking shall be initiated. If rulemaking is initiated to adopt a standard in place of the IMAC modification will remain in effect during the rulemaking unless the IMAC expires. So that brings us to 7 here. So we added language to address the RRC's concerns about the ambiguity of how long these IMACs stay in place. So we added the clarification here that under certain circumstances, an IMAC can expire. So to walk through an example of this language, an IMAC has been established following the guidelines covered earlier, and within 12 months, the division comes to the EMC to make a recommendation on the path of this IMAC. If the EMC declines to initiate rulemaking on this IMAC, which is option A listed here, the IMAC will expire on the date of that decision. The other option is the EMC decides to initiate the rulemaking and eventually adopts a new groundwater standard in place of the IMAC, which is option B listed here. In this case, a groundwater standard now exists for this substance, and the previous IMAC for this substance expires on the date of the rule adoption of this rulemaking. And the last option here is C. So the EMC decides to initiate rulemaking, and after the rulemaking process is almost complete, the public notice has happened and the comments have been received, the EMC decides to not adopt a groundwater standard for a substance to replace an IMAC. The date of that decision is when the IMAC will expire. So just kind of covering all the options here on the path of an IMAC. And finally, moving on to number 8 of the guidelines. This language here is just clarifying that although there are circumstances where an IMAC may expire, any person may still request that an IMAC be established again. They may request an IMAC for this substance again based on new information or new site information that was not included in the original IMAC request. And this IMAC may be established again if the specific guidelines covered earlier are followed. And finally, step 9, this is that language that I mentioned had been struck out earlier. We moved it to the end of the guidelines here to describe the process more accurately. So the Director of Division of Water Resources shall provide an annual update to the Commission on the status of pending IMAC requests and any IMACs that have been established, updated, or removed during the previous calendar year. So keeping the Commission and the public informed of these IMAC activities. I just covered Paragraph C, the recommended rule modifications to paragraph C, but I quickly, before moving on, wanted to mention paragraph G of this rule. That is not included in these slides, but if you look at the rule text attachment, you can see that we did strike through some language that referred to the IMAC review process in paragraph G. There was some confusion when IMACs were referenced in two different paragraphs. We modified the text in G to only refer to the triennial review of the established groundwater quality standards. We took out references to IMACs in G and added a clearer process for the establishment and review of these IMACs to paragraph C, as I've just gone over. So we believe that that language is no longer needed in G. So here's the anticipated rulemaking schedule. As I mentioned, the EMC approved of the hearing officer's report and the rule text in November of last year. RRC reviewed this rule and objected to it based on ambiguity in February of this year. Yesterday, I presented an information item at the Groundwater and Waste Management Committee. And today we are asking for approval of rule text modifications to satisfy the RRC's objection. If approval is received, we will then go back to the RRC for their approval of the rule, which would make the effective date of May 1st, 2022. So the division's requested action today. The division is requesting that the EMC adopt the rule text modifications to 15A NCAC 02L 0202 groundwater quality standards to satisfy the Rules Review Commission's objection. Thank you.
Thank you. Are there questions for Ms. Shelton? Mr. Bailey?
Well, I just wanted to point out I was the hearing officer on these, and so it's been a long road to get here, and we're still not here yet. JD has shared my pain. So, well, of course, all of the DWR probably has too. So anyway, but I did want to point out that we had discussions with Council Reynolds about the substantial changes. As everybody probably noticed, there's a lot of highlighted yellow. And I brought this up in our committee meeting yesterday. And you would normally jump to the conclusion that all the highlighted yellow portions are substantial changes and should go back to public hearing. But I'll let Council Reynolds address that issue.
Thank you, Madam Chair. So if I can, Bridget, get you to go back to slide 7. I think this is the best way to look at it. So all that paragraph looks like it's been entirely changed, but it hasn't been, because this is already in the rule to which you cited, and at the request of RRC Council, we moved that same language from the rule that it referenced into this one so that they weren't so interconnected and they could last independently of one another. So as Commissioner Bailey said, oftentimes the number of changes are often confused with what is a substantial change, but there's very specific definition in the APA as to what a substantial change is, and it has nothing to do with the number, because none of the intent or impact of these rules have in fact changed. They were changed in an effort to satisfy the technical change request made by RRC Council, and then by the objection of the RRC, which was to make things more clear. This doesn't result in more money being expended or anything along those lines. It's just, this is how we made it more clear. And I think it does in fact resolve the objection. I think it does it very well. And I commend staff for all of the work, including educating me, almost the uneducated or inability to be educated on IMAX. But I think we resulted in the result has been that we have an excellent rule, and that the RRC will in fact accept this. And those who objected to it, being the Homeowners Association, I think would also welcome these clarifications as to the guidelines, but I won't actually speak for them.
Commissioner Bailey.
Just one other, couple of other comments, or maybe just one. I just wanted to note that we looked at 2L0100 rules today, and there was a change in the definitions for practical quantity, PQLs, practical quantification limits, that's also associated with this RRC review. So it's in a way, these two are both part of the same comments. We had to go back and change those two.
Yes, yeah, based on the RRC meeting, there was some confusion over what a PQL is, and we decided we needed to clarify the definition, which is not in our rule, it's in the 0100 rules.
So we addressed that also. It was a lot of work to go through all of that. I don't have any further comments.
Any other, I've now totally lost track of where we are. Any other questions for Ms. Sheldon? If not, do we have
Just want to mention, we were made aware yesterday that there are some minor technical changes we need to make in terms of formatting before a motion is made.
Yeah, and that, I'm sorry, I should have mentioned that. It's about how we refer to a subparagraph.
Yeah.
It should be a subpart instead. Jennifer Everett sent those to me yesterday afternoon, and as you all know, around here we do what Jennifer says when it comes to formatting rules, especially. So those are the only sort of minor change, no other word.
How many of them are there?
Or I can give them.
Four, and it's all about,
Minor formatting.
but don't tell me minor. What is it again?
I can go.
I can tell you exactly what they are. Just give me 1 second.
So, for example, here, it spells out 12. We referenced it in a number rather than spelling out 12.
Okay, that's, what other ones?
Yes.
Subpart was one.
Yeah, so here it says after recommendation is presented by the director under subparagraph C, we move, it says part A, subparagraph C6. So it's formatting.
And so we change, instead of saying subparagraph and citing that, we say part, like, so for their C6A is one reference. It's now, we're, because of formatting, we've been asked to refer to it as part A of the subparagraph, a reference to C6C, subparagraph C7 of this rule, changing now to part C of the subparagraph, and then the same type of conforming changes in part C7A. And then as she said, 12, actually, I'm sorry, there's 5. Wants to change from subparagraphs 1 through 9 of this paragraph. Changing also per to in, as in IN.
Okay, thank you.
That's.
Thank you.
Yeah.
So are there other questions for Ms. Shelton? Commissioner Bailey?
I'm ready to make the motion.
I'm ready for you to make the motion. Please do.
I move that the EMC adopt the rule text modifications to 15A and CAC 02L.0202 groundwater quality standards to satisfy the Rules Review Commission's objection, including those technical revisions that were just discussed.
Thank you. Is there a second to that motion?
I'll second. Suzanne Zorek.
Commissioner Lazarek seconds the motion. Any further discussion on the motion? If not, all in favor, please raise your hands. Opposed? Motion carries. Thank you very much. It has been a long road, and I really appreciate the hard work and patience of the staff in working through all this. But it was a good result.
I would, if I can add, I'd like to thank Councilor Reynolds and Representative Chris Millis. I've got his letters here. They kind of hit heads before the RC, and it was a close vote, right? But I think Representative Millis, sometimes this has been posted as Representative Millis's issue and why the home builder is concerned. But he basically says in his letter, if you read it in the RC, it's more about the integrity of the rulemaking process. And this could be, if we don't do it right here, it'd be clear that it could happen on other things. And so he's watching that. And then just to add that there were some formalities. We talk about corrections. And that's one reason why I asked him corrections, is there's some new policies at the RRC about what is a major and a minor correction. And so I just want to make sure we had a clear understanding that this didn't get changed in a major way before it got to the RRC. So thank you very much.
I would also actually appreciate if at some point that window closes and the comments stop somewhere in that process, as opposed to up until 30 minutes before.
An RRC meeting? Yeah.
Yes.
Yes, that's
But-
correct. Thank you.
So remainder of the agenda, director's comments, and I'm going to go left to right. Director Wren, do you have any comments today?
Yes. Good afternoon. Thank you, Chair Smith. Good afternoon, Commissioners. Just a couple of quick items. The department has accepted its first onshore wind energy project to go through the permitting of wind energy facilities process laid out in NCGS 143, 215, 115 through 126. Apex Clean Energy proposes to construct and operate the Timber Mill Wind LLC project, a 45 wind turbine system with associated facilities on approximately 6,300 acres in Chowan County with a nameplate wind energy capacity of 189 megawatts. The requests for a pre-application site evaluation meeting and pre-application package were received from Apex in June of 2021. A draft application was received in November 2021, and the scoping process will be completed on March 22nd of this year. We expect to receive the final application in late April 2022, and a public hearing will be required as part of the application review process. Final item is the division continues to work with North Carolina Emergency Management to establish the Dam Watch system. This is a early warning system that alerts emergency response personnel to potentially dangerous conditions at 130 dams across the state. The system will monitor water levels in the impoundments and rainfall data across the state. The system will allow state and local agencies to plan and prioritize response services for severe rain events. Training on use of the system will begin the end of this month and continue on through April. Thank you.
Thank you. Director Scott.
Thanks, Chair. Members of the Commission. As required by House Bill 951, Section 3, the department was required to develop a plan by March 1st to ensure adequate financial resources for the decommissioning of utility scale solar projects to be submitted to the General Assembly for legislative action. Several DEQ programs contributed to this plan that was submitted last week to the General Assembly, and an informational item was presented to the Groundwater and Waste Management Committee yesterday on this topic. On a similar note, we are still working on proposed amendments to 15A NCAC 13A to consider adding solar panels as a universal waste and to clarify hazardous waste requirements, and looking to possibly propose that before the Groundwater Waste Management Committee either in May or July of this year. A couple of additional items. We do continue to work on the Colonial Pipeline release in Huntersville, North Carolina. If you remember, we filed a motion, a complaint in Mecklenburg County Court based on that significant fuel spill release. We are in discussions with Colonial regarding that filed complaint and necessary next steps to resolve it. We have, like Division of Air Quality and Water Resources, been involved with the Weaver Fertilizer Plant fire in Winston-Salem, specific solid waste and hazardous waste material management decisions being made regarding material that's leaving that plant site. Just appreciate all the great work across our programs, and I think Air Quality had a significant update on that within their committee yesterday. There's also a lot of continued work on PFAS. Just a few highlights to touch on here. We are working strongly with the Division of Water Resources on several fronts to include work in the lower Cape Fear related to the Comores PFAS contaminants that have been detected in the river and also in the lower Cape Fear County. So specific private well sampling is getting underway in those lower Cape Fear counties of New Hanover, Columbus, Brunswick, and Pender counties, and also additional environmental assessment work for PFAS will be conducted in those counties. And then on a final note, Chair Smith, you may remember Jim Bateson as our Superfund section chief. He wrapped up his work with our division late last month and has retired. And so we're actively interviewing and hope to make a new section chief decision very soon for our Superfund position. And on an additional note, a great colleague, Mary Johnson, who had 46 years of state service, dedicated state service, also retired this month and from our solid waste program. So we're in a rapid hiring mode, doing a lot of HR work and also a lot of technical work. Thank you.
Thank you. Director Abrazinskis.
Thank you, Madam Chair. Good afternoon, everyone. A quick update today on phase 2 of our Volkswagen Environmental Mitigation Trust work. There are some lengthy written remarks in the record for you to review. I'll just give a quick highlight today. The phase 2 of this work is underway. This is how we've recently developed our phase 2 plan. which outlines the general categories and allocations for the remaining 68 million in beneficial NOx emission reduction projects that we plan to invest in over the near term. Recently, we've released a few requests for proposals for some of the first couple of source categories, and there will be several more coming over the coming months. We're also in the midst of a number of outreach meetings to historically under-resourced counties as part of this process. It's 37 counties across the state. We're making sure that those areas are fully aware of these opportunities and can readily identify eligible projects. We're going to prioritize electrification, certainly as part of this process, but there's lots of details on our website. If you're interested, I encourage you to check that out. And then one other quick update, under phase one of that Volkswagen work, we fully funded 5 electric school buses. Well, we're excited to report that next week we're going to be attending the ribbon cutting for the first electric school bus that we put into service in North Carolina. It'll be at the Eastern Band of the Cherokee Indians. So I'm super excited to be there for the first mile, and we'll send some pictures and report out next time. Thanks.
Great, thank you. Director Smith.
Hey, thank you. Good afternoon, everyone. Our first item today is on February 15th, Division of Water Resources participated in the North Carolina Manufacturing Alliance workshop. This included staff from the Division of Water Resources Planning Section, Water Quality Permitting Section, Public Water Supply, and Water Quality Regional Operations Section. So staff presented and the EQ staff presented more than 13 different topics ranging from emerging compounds, inspections, as well as a question and a roundtable discussion with regional office supervisors. The next item is the 2022 draft Yadkin PD River Basin Water Resources Management Plan. This plan is available for public review and comment. The 2022 Basin Plan is the 4th document to be developed for this basin by the Division of Water Resources. Information presented in the Basin Plan is a cumulative effort involving many agencies and stakeholders across the basin. I'd like to thank all those involved in developing and reviewing the document. The deadline to submit the comments is Friday, March 11th. Comments can be mailed to Jenny Baker at virginia.baker@ncdeaner.gov or sent by mail to Division of Water Resources Planning Branch. Attention, Jenny Baker, 1611 Mail Service Center, Raleigh, NC 27699-161. The final item is the Animal Waste Management Digester Systems General Permit. DEQ will hold 4 public meetings in April on the draft Animal Waste Management Digester Systems General Permit. 3 meetings will be in person, and a 4th meeting will be online via WebEx. Members of the public are invited to attend and submit comments on the draft permit. The 3 draft general permits cover installation and operation of digester systems at existing swine, cattle, and wet poultry operations. The digester system general permit drafts are available online. The upcoming public meeting on the draft general permits will be held from 6 to 9 p.m. The first one is April 5th at James Front Community College. The second is April 7th at Sampson County Exposition Center. The third is April 19th at Statesville Civic Center. And the final virtual meeting will also be held through WebEx on April 21st at 6 to 9 p.m. And finally, I'd like to thank staff for all their work today on all these presentations and all the behind the scene work that went into this. So just congratulations and thank you. And that's all the comments I have. Thank you.
Thank you. So Commission committee chairs, Commissioner Arata, did you have any final comments?
We'll just give a plug for a presentation that's currently planned and very much in the works for the May meeting on House Bill 951, the energy bill. That's again in the works, so there might be a few changes between now and then.
Commissioner Bailey?
Just a couple of things. As a result of Commissioner Manas taking on the vice chair position, then a couple of other changes were made. So Commissioner Lazork is now the vice chair of the Groundwater and Wastewater Management Committee. And I wanted to thank Commissioner Keene for being such a big help to me and stepping in when I couldn't be available as chair for the meeting. And he will now take over Commissioner Mona's position as chair of the Civil Penalty Prevention Committee. So just want to thank everybody for their service, and those were the changes with that. And we had just another little, we've had some of the updates that the commission had here today, but we also are looking into the pending IMAX more. We found out there was only one pending IMAC, and since then, the entity that requested it, the Moores, has basically withdrawn its request. And we also have a list of other IMACs that are out there that have been granted that we'll need to look at once these rules, the 2L 0200 rules are out. There's about 17 other IMACs that weren't included in the rules. Thank you.
Thank you. Commissioner Deerhake?
Thank you. Water Quality Committee did meet yesterday, and we had two information items. One was an overview of the delegated riparian buffer programs and stormwater programs. We heard presentations on the riparian buffer program, the MS4 program, water supply watershed protection program, and the nutrient management program. We have a really comprehensive matrix or spreadsheet of all of these programs, page and a half too long on an 11 by 14 page. But it's very useful information because we periodically get requests from, isolated requests from each of these programs, and it's hard to keep them all straight. I do have a couple of extra copies, hard copies. There's also a soft copy available on our website, our webpage for that, for the meeting yesterday if you want it. But numerous local programs around the state and very limited state staff to audit their performance. So it has to be very targeted and very carefully planned to get a gauge on how well these local programs are operating, plus the outreach and education to the communities for them is extremely important to make sure that the authority they've been delegated is being carried out properly and we're protecting our water quality. The second agenda item we had was a report on the Greensboro 1,4-dioxane investigation. As you know, last fall, we voted on the special order by consent for the city of Greensboro and the 1,4-dioxane. As those negotiations were moving along, we had two spikes in discharges that occurred, one in late June and one in November. And they were quite perplexing. The investigation was carried out by Assistant Secretary Mace Moore under her direction at the Secretary's office. And they have done a great deal of investigation and cause analysis, as Commissioner Solomon, is that the right term you like to use, cause analysis? Root cause analysis. They've been doing, and he's sat in on some of these briefings, but we had a good report on that. Unfortunately, they still haven't determined what the cause is, but they've gone through a lot of process of elimination, and they've narrowed it down, they think, to what's called the Patton, P-A-T-T-O-N, trunk line feeding into the wastewater treatment plant at TZ Osborne. So more monitoring and extensively increased monitoring will be happening in the city of Greensboro. They now have 58 sampling points between the treatment plant and the dischargers into the treatment line from various industrial sources. So although we don't know exactly what that cause was, we are seeing a significant increase in improvement in the operation in the Greensboro area to minimize 1,4-dioxane discharge downstream to folks in the Cape Fear. So I believe that is all that we have. I will mention, thank you for mentioning the Yadkin River. So we will be hearing that in committee in May. I believe that's what's currently scheduled. So that means it will come to the full commission in July, probably. And I would love to go on that trip to the Cherokees, the electric bus, but I wish I could, but I can't.
Commissioner McAdams, did you have any comments?
No, Madam Chairman, the Water Allocation Committee did not meet.
So other commission members, Commissioner Solomon, Commissioner Lazorek, Commissioner Kelvington, Commissioner Keene.
One quick thank you and a shout out to Director Scott and his staff for the solar panel overview yesterday. That answered, I think, a lot of questions we've had for the last almost 2 years. They put it all together yesterday and gave a grand presentation. They've done a lot of work. They've circled the wagons on this. Windmills now, or wind farms and electric buses, but you, again, circled the wagon on the solar panels, and we're on the right track. So you and your staff are to be commended for all the hard work. I know what you presented yesterday didn't just happen. You guys did a great job, and girls too. Thanks.
It was a really good presentation. Commissioner Harris, Commissioner Duggan, Commissioner Roberts. Who have I missed? Commissioner Carter.
Can I thank Commissioner Harris for her work on the triennial review? That was a huge effort. Thank you.
Commissioner Anderson, did you have any comments? Council Reynolds, do you have any comments?
Group 2 remissions in this room this time. They've upgraded us. And Group 1 is across the hall.
Right. So again, thank you. Appreciate the patience of the folks here for the remissions committees. It's often hard to estimate how long these agenda items are going to take. So again, Group 2 is here. Group 1 is across the hall. This meeting's adjourned. Thank you very much.
Remissions 1, 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 remissions 1,